Hi, Mel.
I wasn't really watching. Hi.
I just looked at the website and it looks like the YouTube link is posted next to July.
Oh, sorry. Let me
Yeah.
go back and fix that.
Yeah. Thank you for getting it started. I appreciate it.
Yep. I wasn't really watching. Hi.
Hi. I just looked at the website and it looks like the YouTube link is posted next to July.
Oh, sorry. Let me
Yeah.
go back and fix that.
Yeah. Thank you for getting it started. I appreciate it.
Yep. I wasn't really watching. Hi.
Hi. I just looked at the website and it looks like the YouTube link is posted next to July.
Oh, sorry. Let me
Yeah.
go back and fix that.
Yeah. Thank you for getting it started. I appreciate it.
Yep. I wasn't really watching. Hi.
Good morning, Mr. Gitjos.
Can you hear me?
I can hear you. Hey, you got your mic working.
We'll address that later.
All right then. So you did not go the headset route?
I'm using mine. There's something else with the work computer where I don't have any speakers on it at all. So I tried a couple different things, but in the end just opted to use this fine piece of technology.
I thought I sent you something to work around that. That was Carrie's laptop, right?
Yeah.
Did I give you a headset? I sent you something, or did I?
I had the old headset, the Bluetooth you gave me, but that was that a bark?
Silas heard you. Sorry, stop.
So the headset didn't work out?
It did not work because the speaker itself does not seem to be working. So I can call in on the phone, but even if I try to look up like a YouTube video or watch something from CNN, it doesn't come across. So I tested the speakers, I tested the mics, and I just couldn't get them to come through.
Carrie's speakers don't work. I think they don't and they won't. There's something wrong with the hardware.
Okay, so after Milo came to me on, I don't know what day it was, Thursday, Friday, I don't know.
I think I sent him as something secondary he has to use until we get the other machines from the state, because Carrie's speakers have failed to work for a while. And I did all the troubleshooting, and it seems like it's a hardware problem. So
well, and I couldn't I have a separate plug-in mic and headset, but it wasn't for whatever reason, it just wasn't connecting. Because sometimes, instead of a Bluetooth, a hardline one will work better, but I couldn't get it. So, I mean, I'm here. I'm happy.
Well, thank you for troubleshooting it. We will continue to do so.
Nothing but the utmost faith.
Yes. So, yes. Yep. Still processing, not enough coffee yet. To be continued. Hi, Matt, you're sideways.
Or, you know,
Yeah, that's better.
yeah, I'm mastering Zoom. You think I would know it by now.
You would think, right? Good to
Uh,
see you. We'll be with you in a while.
Okay. All right. The reason I'm sideways is I was plugged in. I'm trying to keep my phone charged. I'm using my iPhone for this one.
Yep, been there. Yep. And you guys didn't submit anything, right?
No, just the complainants did.
Right.
The investigator recommended no reasonable grounds for my client.
Got it. Okay.
Okay.
And I shall mute you.
Okay.
Hello, Commissioner Dusan.
Good morning, Madam Executive Director. How are
Oh,
you?
I am fine. I'm eating my breakfast right now. So
There you go.
I'm going to turn my screen off and my sound so no one else has to experience that.
I'm going to do the same. I'm going to go get my toast. Thank you.
Okay.
Minutes.
Hi, Alex.
Hi, Amy.
Good morning.
Good morning.
I'm
I'm
going
gonna turn. Yep,
Yeah.
I'm gonna turn my computer. I'm gonna turn it.
Yeah, everything
Yeah.
Hello, Commissioner Whitworth.
Good morning.
Good morning.
How are you?
I'm good. How are you?
Good.
Everyone's getting settled in and eating breakfast, so
Yep. And dealing with the cat.
dealing with cats. Yep. All right, I'm going to rename you here. I'm adding in your commissioner status.
Oh. Sit down.
Most of our meetings include cats of some sort.
Well, she keeps stepping on my keyboard.
Because she's going to do what she wants.
Well, she is, and she's going to be excused in just a moment if she doesn't behave when we start.
All right, then. I'll be back.
Yeah, me too.
Good morning, Commissioner Ashby. I know you're still getting connected.
Good morning. How are you, Amy?
I am fine. How are you?
I'm well, thank you.
I'm
sorry
adding
about
your, what's that?
I'm sorry about the last minute sort of, I got to duck out thing. I know it's not ideal when I have to leave early.
Yeah. Yeah, it's, it is what it is. We happen to have a long agenda. And yeah, there it is.
Yeah, I asked for protection from the courts at the beginning of the year for all of my cases, but we had an emergency hearing set and it was set in the early afternoon and I suspected I'd be done by then. And so I hesitated quite a bit and then I said, yeah, I'd do it. So it was late last week that I got set. So.
Well, maybe we'll magically be done by then. I don't think so, but maybe. Good morning, Commissioner David. Good morning, Commissioner O'Brien.
Good morning. Good morning.
How are you this fine morning?
Just fine. Just fine.
Good, good.
I flew to New York City over the weekend.
The outside world, how was it? Oh, you're muted. You're muted, Ed.
was shocking. I had forgotten what
Thank you.
airports look like.
They're crowded,
They're,
just like they
they're
used to.
crowded. They're crowded, but when you have a mask when you walk in and until you walk out, and they're very much compliant with that, and the airlines are too.
Oh, yeah.
It's actually a good feeling.
Yeah.
Yeah. And the grandchildren are fine.
Oh, good. It's nice to hug people again, isn't it?
Oh yeah. Yeah, it was fun.
And they're making progress for getting you across the border, right? Is there hope for July?
Well, there are wars and rumors of wars, and we keep threatening to invade if they don't pay attention, but we're not sure quite what's going to happen. I mean, they're talking about a metric for the New Brunswick population to be vaccinated before they do that, and Trudeau has to sign off on it also. But yes, it's starting to look like it'll happen sometime this summer.
Good. Five commissioners. Wow. When was the last time we had 5 commissioners? Several years.
Deb, how are you? We missed you last month.
I'm good, thank you. I wasn't here because my husband had knee surgery and I was his driver. So,
Oh, it's the driver, right?
yeah, it's very unlike me to miss a commission meeting, but
How's
but
he
he
coming
couldn't get
from
there,
that?
couldn't get there without me. Pardon me?
How's he coming along after that?
It was laparoscopic
Oh, it was.
surgery.
Okay. So
Yeah,
it wasn't
so it
wasn't a
a
replacement. Yeah.
No, no. I think a little bit slower than he anticipated. But it hasn't slowed him down any bit. He's out in the yard right now, probably kneeling all over the place and
Right.
then wondering why it hurts later.
He thought he was going to run it off, right?
Yeah, right. Thanks for asking. Uh-huh.
No
So
problem.
Commissioner Whitworth and Commissioner O'Brien, this is the first time you are seeing each other and electronically meeting.
Yes.
So as I said, this is the first time we've had 5 commissioners in several years, and I cannot tell you how happy I am. 1, 2, 3, 4, 5. It's so great.
Mark.
We always record them audio, and sometimes we forget to turn the video recorder back on. We start the meeting recording and then we pause it till we get started. And sometimes we forget to turn the video part back on. So that was me remembering to turn it back on.
Seems to me that's the first time I've seen that warning. Is that new in Zoom or something?
I only started hearing that recently too. So I think it must be either a new function or a new thing that we have turned on in our
Yeah.
system.
This
So-
was visual, saying, notice the meeting's being recorded and asking you to acknowledge.
Oh, really?
Yeah,
Oh, I don't have that. That's interesting.
it was a written panel on the
Wow.
screen.
I think it's so people who are participating know that you're
Sure.
being recorded, even though you can see it up in the corner.
Right.
I think it's a good warning. Mind your manners. Right?
Now, before we start, I just want to make sure I know who everybody is in here and what case they're here for. I see Lindsay Eyre, and I don't happen to know that name or have a case by that name. If you could just let me know what case you're here for. And then, okay, Miss Elsa Lakawi, and I think your husband is there to interpret for you at your request, since we offered to provide you with an interpreter. Mr. Turcott, if you could just let me know what case you're here for.
Yes, good morning.
Mr. Turcott, what case are you here for? Nope, you're muted. There you go.
Macaroni Grill.
I'm sorry, which one?
Lindsay Eyre and MAC Holdings Macaroni Grill.
Macaroni Grill. So,
It's a consent item.
okay, so you just want to make sure we adopt it. Okay, got it. Now I understand why Miss Eyre is here, and yes, sorry, I wasn't thinking about that. Thank you.
Thank you.
Oops, I was trying to mute you and you muted yourself at the same time. And yeah, I'm going to mute you again.
Thank you.
Okay, Mr. Cloutier, I see you're here for that case. All right, so Commissioner Whitworth, I think we're good to go.
Okay. Good morning, everybody. I'm Deb Whitworth, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I am asking each of you who may have an electronic device whether it's a cell phone, pager, etc., to ensure that they're silenced now. You should have an agenda which was provided to you via email, including the consent agenda. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time period. The commission will vote on those cases and they will not be considered further today. The remaining cases on the agenda are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Can we move to adopt the agenda and consent agenda?
So moved.
Second.
Second,
All in favor, raise your hand and say yes.
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 2, 3, 4, 5. Thank you.
Is there a motion to approve or revise the minutes of May 17th?
I'll move adoption of the minutes.
Second.
All in favor, raise your hand and say aye.
All right.
Aye.
Opposed?
Deb,
I'll
were you-
abstain. I'll abstain from that since I wasn't at that meeting.
Okay.
Director's report, Amy.
Yes, good morning, everyone. Let's see. So for the director's report, you have a memo from me regarding personnel. If you have questions about that, I'm happy to answer that. Any details about personnel, we would need to talk about in executive session. With regard to compliance, you have a memo from me that shows that we have 10 reasonable grounds cases pending in conciliation, although several of them will likely fail conciliation today. We have 1 unsuccessful conciliation and no successful conciliations to report and no post-conciliation agreements for you to review. For investigation, we received 64 new complaints in May, and the numbers continue to be higher than is typical. You're up, if you saw our annual report, about 10% last year. I think that's going to continue to be high. For administrative dismissals, we dismissed 15 cases in May. And for predetermination settlements, there were 4 in May with benefits of about $83,000 to complainants. For litigation, I would ask that we discuss that after executive session. And for new business, the legislative session is racing toward a close, and there's a lot of activity on a lot of bills. It's a very pressured time. Our 8R1 agency bill, which was the same bill we had put in 2 years ago, it's been through committee, it's been approved through committee. And we're just waiting for it to be discussed and voted on in the House and Senate. And the budget, it has not all the pieces. So if you remember, yes, Commissioner David.
Was there any dissent in those committee reports? Because if they're unanimous, then it should be gabbled through, right?
There was dissent. It was a party line dissent from the Republicans.
Okay, so it might be debated, yeah.
Yeah, I suspect there will be pieces that definitely will be debated that are not substantive changes, but just things in the Maine Human Rights Act that not everyone enjoys. For our budget, so if you remember, I reported at a prior meeting that the governor's biennial budget was put in at baseline levels. So what's being discussed now are the initiatives that each agency had put forward. The governor has put in a change package, and all of our initiatives are in there, which is fantastic. There are some changes to that the Judiciary Committee made. And so we're continuing to try to clarify that with the Appropriations Committee. The Appropriations Committee, they are at this point going line by line on unvoted initiatives at random times. And they did a few of our items, not even necessarily cohesively, but they did a few of our items on Friday on very short notice. And I think they will continue to do them piece by piece. So I will not be able to tell you with any certainty. Well, at our July meeting, I will definitely be able to tell you what happened. So a lot of things that are happening at state agencies around the state, including ours, are waiting for July 1 for the new budget to be put in place. So we are racing towards that. Yes, Commissioner O'Brien.
Could you just, in the bill, the actual bill, is there a budget in that? Is there appropriation tied to that? Or is it all in the budget?
I'm sorry, which bill? Our agency?
The agency bill, yes.
There is no fiscal note.
Okay.
On that.
Okay. So it's all line by line in the budget. Okay.
So the line by line is about our budget only.
Okay. And the other one is about the bill only.
The other one is about the Maine Human Rights Act
Right.
and substance of that.
Okay. Yep.
And they have nothing to do with each other. So,
okay.
Yeah.
Thanks.
And finally, the state is doing a survey. So we have been told in terms of COVID and reopening, our agency, all state agencies were told to continue with the remote work arrangements that we have through July 1. Right now, the state is conducting a survey of all state employees about vaccination status and masks and people's comfort levels. And we've been told that they will be issuing new directives when they know the results of that about state agencies reopening to the public, I think in early July. Yeah, so that remains to be seen. It's something that we inside the agency talk about all the time, about how to bring people back into the office more, and about conferences, whether they're going to continue to be remote or in person, mediations, commission meetings. It's a topic that we really can't answer much about yet, but we are talking about it, as I'm sure is every other agency in the state. So I think hopefully we should be able to talk about that more in July at our meeting. I do have a draft set of dates for our 2022 meetings. I have not shared that with you yet, but I should be able to send it to you shortly and have you take a look at it and let me know, commissioners, if there's any conflicts on your ends. That's all I have for new business.
So we will adjourn for 5 minutes, come back at 8:45 and hear our cases for the day.
Commissioner Doosan.
Wonder if this is the time that I should notify the commission chair that I've consulted with commission staff, and once we begin the hearing list, I would intend to remove myself from participation, recuse myself from participation in item number E19-0239, Elso Lakiwa versus American Roots. I'm sorry for messing up your name. Because of conflict of interest or appearance of conflict of interest or lack of impartiality.
Thank you.
And so I see Ms. Elsa Lakawi, and I'm pretty sure I pronounced your name wrong. Looks like I thought you were going to unmute. And you have your husband there.
You are good. You are good.
I'm good. Okay. And sir, can I write your name down, because I am not at all sure. Actually, I don't think I have your name at all. So could I get your name?
My full name. Shall I write this on the chat?
Yeah, it's exactly what I was going to say.
Sure.
I'm
okay.
a lot more likely to get it properly. And I just want to be clear to folks that our agency did offer to hire an interpreter for that proceeding, but that the complainant preferred to use her husband as the interpreter. Thank you very much. That way I can be sure that I put it in our minutes properly. And I know we also have, I'm writing it down. Okay, Abu, thank you. El
Thank you.
Makarim. I know we have other interpreters on here as well. I saw we have a Rodrigo. I do actually know how to pronounce that. My brain just didn't work.
Yes, you got it right. Good morning.
Okay.
I'm the Spanish interpreter.
Okay, we hired 2 Spanish interpreters, I think, for 2 different cases, which was probably not the smartest thing. But so Rodrigo, are you going to be interpreting for the first case on the agenda?
Is the Hermila Vargas?
Yes, it is. Yep.
Yes, that's what I have in my notes.
Okay, wonderful. Thank you very much. And we actually did hire another interpreter for the second and third cases in the event that the parties who speak Spanish and need interpreters are present. And I believe I saw.
Good morning. This is Sylvia.
Sylvia.
The other Spanish interpreter.
Thank you. So we have Sylvia and Rodrigo. Okay. All right. So I just wanted to make sure I know all the interpreters in our universe at the moment. So it looks like we have a few minutes left.
Okay, so we have a couple minutes left. We'll come back at 8:45.
Yep.
Oh, yes.
Can I just apologize for the terrible first meeting technical problems that I had, and just hopefully this will be worked out. We've had lots of service technicians here, and my goal is to get through this meeting. Thank you.
Thank you, Commissioner O'Brien. And Commissioner Whitworth, you weren't here, but there was some disruption. So I appreciate all the work you're doing on your end, Commissioner O'Brien.
Thank you.
Thank you. Okay, it's 8:45. So let's continue with our meeting. So cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to provide the most relevant arguments to the case. The time is limited to 10 minutes, although I think, Amy, when there's an interpreter, you extend that time. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes, unless you have an interpreter, may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions, and we ask that you introduce yourself as your case is called. So our first case, E19-0332. Is there anybody here for the complainant, Hermelia Vargas?
And before we start, I think we should, do we need the interpreter to start interpreting this proceeding?
My name is Michael Guerre. I'm an attorney at Pine Tree Legal Assistance, and I'm appearing on behalf of Ms. Vargas. She does not speak English.
Okay, so do we need to do the introduction opening? Actually, Ms. Vargas is raising her electronic hand. Ms. Vargas?
Señora Vargas, ¿usted está ahí?
Sí, estoy aquí.
I'm here.
Okay, do we need to do the introductory opening that our commissioner just did over again so that we can make sure that Ms. Vargas understands those instructions, even though her attorney is presenting for her? I think maybe Mr. Guar, what do you think?
Well, I'd be happy to waive the reading of those instructions.
Okay.
If
Okay, so then, Mr. Guar, I will, normally it would be 10 minutes, and Mr. Rodrigo, since I don't have your last name, if you could interpret this all, I would appreciate it, so that Ms. Vargas knows what's happening. Normally we would give you 10 minutes, but I will make it, is 15 enough to be equivalent with the interpreting, or do we need to wait and see how quickly that goes?
I think 15 minutes might be enough. My presentation is actually relatively brief.
Okay.
Normalmente se da 10 minutos para este tipo de casos, pero hoy por motivo de la interpretación vamos a usar 15 minutos y el abogado concurrió que 15 minutos son suficientes.
All right, well, we'll see how it goes then. Okay.
Vamos a ver cómo va entonces.
Go ahead, Mr. Guar.
Okay, I'm sorry, Commissioner Whitworth and members of the commission. My name is Michael Guerre. I'm an attorney at Pine Tree Legal Assistance. I work in our farm worker unit, and I have only been representing Ms. Vargas in this case since very shortly before the deadline for submission of disagreement. And my experience with interpreters is that it's much better to speak in short pieces and then wait for interpretation as we go, rather than.
Yep.
Yeah.
So,
And if you see my hand like this, it means I need a pause to retain. We want to strive for completeness. El abogado thank you. Hermelia, el abogado, se presentó y dijo que él ha estado trabajando con usted en este caso. Y él trabaja para Pine Tree en la unidad de la parte de trabajo de campo.
And could you interpret the portion about how I've only been representing Ms. Vargas since shortly before the deadline for submission of disagreement?
Y el abogado también dijo que ha estado trabajando con usted un poco antes del tiempo que era el tiempo de entrega de la sumisión para no estar de acuerdo.
And in this case, the respondent, the decision or the recommendation made by the investigator, which is based upon an assertion by the respondent, turns pretty much entirely upon the investigator's conclusion, with which we respectfully disagree, that there was no adverse employment action against the complainant.
La decisión fue hecha basada en la recomendación del investigador y nosotros no estamos de acuerdo con esta decisión, que no hubo ningún caso de desacuerdo, un caso de maltrato de parte del trabajador hacia el demandante.
And the reason for that, in turn, is that the assertion made and the conclusion reached by the investigator was that Ms. Vargas was not a full-time employee, that she was a seasonal employee, and that she was laid off at the end of the season. In other words, she was laid off and she was terminated from her employment at the time, when she normally would have been anyway, and therefore there was no adverse employment action.
Y la razón por la que no hubo ninguna acción adversa de parte del empleador, la razón que no fue dada fue porque ella no era una trabajadora a tiempo completo, sino que era una trabajadora temporal migratoria. Y la razón es porque ella la dejaron ir, la despidieron, la cancelaron al final de su etapa de trabajo temporal, y pues entonces no hubo ningún trato adverso del trabajador hacia el demandante.
We respectfully disagree with that.
Nosotros respetuosamente no estamos de acuerdo con eso.
When the complainant responded to the respondent's initial submission, she specifically stated in her submission that she was contracted as a seasonal worker and that the respondent had an application from her for full-time employment.
Nosotros en su sumisión original, el demandante dijo que ella había recibido un contrato para trabajar como trabajadora temporaria, pero que ella había solicitado un trabajo de tiempo completo.
In addition to that, she also stated that when she was terminated, she was told that she was being terminated because she was a temporary worker, and she then asked her supervisor if she was a temporary worker, because up to that point, she had believed that she was a permanent worker.
La demandante también declaró que cuando ella fue cancelada, ella preguntó a su supervisor si ella era un trabajador temporario, porque ella estaba bajo la impresión de que era una trabajadora permanente.
And these assertions by the complainant appear to have been overlooked, with all respect to the investigator, who otherwise produced a very fine report. These assertions by the complainant seem to have been overlooked by the investigator.
Esas ideas, esas asunciones que el demandante tiene, que ella hizo, parece que fueron descuidadas, parece que no fueron, a pesar de que se hizo un buen trabajo por parte del investigador, parece que esa idea que ella tenía, que era trabajadora permanente, no fue tomada en consideración.
There is no mention of the complainant's assertion that she was a full-time year-round worker in the investigative report, much less an analysis of those assertions compared to the respondent's assertions.
No hay ninguna mención de ese hecho de que la trabajadora asumió que era un trabajador permanente, mucho menos en comparación con el análisis que se hizo.
And obviously, if the respondent's assertion is correct, the complainant's assertion is correct, it contradicts the respondent's stated reason for termination, which was that she was terminated at the end of a season and not for any other reason.
Y obviamente, si el demandante estaba asumiendo que era trabajador permanente, eso va en contradicción con la respuesta que se dio, porque ella pensó que era trabajadora permanente y la dejaron ir porque era trabajadora temporaria.
And that, of course, would in turn support the inference that she was terminated for retaliatory reasons.
Y eso daría la implicación de que a ella la cancelaron por razones de retaliación.
And what we seek from the commission in this case is essentially a remand. We ask that there be a new investigation which analyzes completely the terms under which the respondent was hired, whether it was full-time or seasonal. We believe it was full-time, because if it was full-time, it follows that the respondent's stated reason for termination was not valid.
Lo que nosotros buscamos de la comisión es que haga una remienda, que hagan una nueva investigación, y que en esa nueva investigación se analice completamente los términos de la situación de empleada del demandante, si fue realmente tiempo completo o si fue temporario, porque si fue tiempo completo, entonces no está, es contradictorio con la decisión que se tomó.
Thank you.
Muchas gracias.
Okay, so I was clocking only the time when Mr. Guar was actually speaking, not the interpreted piece, and that was just about 4 minutes. So Mr. Guer, I realize I'm also mispronouncing your name. You will have additional time after we have questions from commissioners and hear from the respondent. Can you interpret that for Ms. Vargas?
I'm sorry, could you please repeat that? I was looking at my notes, I'm sorry.
Sure. I was telling Mr. Guer that I was only timing the time that he talked. And so he will have about 6 minutes left to present after we hear from commissioners if they have questions and from the respondent.
Okay. Solo se utilizaron 6 minutos porque solo se cronometró el tiempo que el abogado estaba hablando, no el intérprete. Entonces el abogado todavía tiene 6 minutos para hablar después que la comisión hable al respecto.
So at this point, we'll turn to commissioners to see if they have any questions. And commissioners, I would say if you do have questions, please leave time for the interpretation. So Commissioner Whitworth, any questions for Mr. Guer?
No questions, thank you.
Commissioner Ashby, any questions?
Good morning. Yeah, I see in your submission, Attorney Guer, the statements of items of disagreement with the investigator's report signed by your client on May 24th. It's near the end of your submissions. Do you have that?
Yes.
Yo veo aquí en su submisión que usted tiene una declaración de desacuerdo con la investigación. ¿Usted tiene ese documento?
The second paragraph indicates that your client can't remember for sure, but believes there was a question on the application, where she was asked if she was applying for year-round work. Are we at that level of proof, or do we have maybe better proof than that?
En el segundo párrafo. Can I jump in on that? Okay. En el segundo párrafo dice que su cliente no recuerda de seguro cuando estaba llenando la solicitud para trabajo, si estaba llenando para tiempo completo o para temporal. ¿Tenemos una prueba mejor que eso o eso es?
Well, Commissioner Ashby, obviously I did not want to overstate what the complainant told to me, but I would emphasize that that is only one of several facts which indicate that the respondent is asserting that she was a full-time employee. In addition to what may have been a question on the application, there are also her direct statements to the commission that she was hired as a full-time employee, as well as her questioning that assertion by her employer when she was terminated.
Bueno, comisionador, obviamente yo no quiero redundar en lo que dijo el demandante, pero eso es solo uno de los hechos, el hecho de que ella llenó ese papel, pero también están las declaraciones directas del demandante diciendo que ella era una trabajadora a tiempo completo y también su cuestionamiento al empleador de por qué si ella era a tiempo completo o no.
Thank you. I think that's all the questions I have.
Gracias, esa es toda la pregunta que yo tenía.
Commissioner David, any questions for Mr. Guer so far?
Yes, in the same vein, Attorney Guer, I don't see in her pro se response before you were involved that she mentions the allegation that she believes she was full-time, which seems central to your argument.
That's correct. I can only emphasize that up until that point, Ms. Vargas was unrepresented. And I did the best I could in talking with her and eliciting the relevant facts. I think it's fair to say that Ms. Vargas doesn't necessarily understand which facts are important and which ones aren't in this matter. And I can only say that when I began representing her, I did the best I could to correct the record. or to make the record
Fair enough.
complete.
Fair
Wait,
enough.
can
I'm
we-
not
can we
suggesting
wait?
it's,
Hold on, Commissioner David, can we let this be interpreted?
Yo veo que hasta ese punto, desde antes, la misma idea, abogado, hasta ese punto de que usted estuvo involucrado con ellas, no había bien una claridad de los hechos, de lo que estaba pasando. Entonces el abogado dijo que, bueno, que él solo puede responder al respecto de lo que él, desde el tiempo que él está interpretando y que él hizo lo mejor que pudo, y él solo puede decir que, bueno, que quizás a la señora Vargas no sabía muy bien, no tenía muy idea de lo que estaba pasando hasta el momento que él empezó a trabajar con ella.
Commissioner David?
yes, I'm not suggesting that it's dispositive, Attorney Guerra, but I think it might have some significance. But that's all.
Yo no creo que eso sea algo que sea dispositivo, pero creo que eso tiene que tener alguna significancia también.
Commissioner Dusan, questions for Mr. Guerra?
Usted
I
todavía,
do not have questions at this time.
Thank you.
no
Commissioner
puede-
O'Brien, questions for Mr. Guerra at this time?
Comisionado O'Brien, ¿tiene alguna pregunta?
Yes, just to follow along that line, I understand that an application was never produced. Am I right on that? I mean, no one saw the application?
I believe so, Commissioner. I'm sorry.
Entonces, si yo tengo una pregunta, comisionador O'Brien, pregunta si yo entiendo que la aplicación, la solicitud nunca se produjo. ¿Es así, es verdad?
And Commissioner, yes, I believe that it is correct that the application was not produced by the respondent.
And do you know if that was requested? And they refused to do it, or how, where does that?
I looked at the commission's original request for documents to the respondent, and that was not specifically requested. However, there was a document request that would have, for relevant documents, that would obviously have, the application for employment would obviously be within the scope of a relevant document. And I would suggest that if that document existed, it should have been produced.
Thank you.
Se preguntó si la aplicación, la solicitud para trabajo se produjo, y el abogado dijo que correctamente que no se produjo, y se preguntó si está disponible, y el abogado dijo que obviamente en la parte que no se pidió específicamente, pero que en la parte de documentos relevantes debería estar ahí esa solicitud de trabajo.
Commissioner O'Brien, anything else? Okay. So at this time, we would turn to the respondent. And again, you'll have 10 minutes of your actual presentation, which I will stop my timer when it's being interpreted. I see Ms. Johnston.
Hi there. Good morning. My name is Elizabeth Johnston, and I'm appearing on behalf of the respondent, Jasper Wyman and Son.
Hola, yo soy Elizabeth Johnston y yo estoy compareciendo hoy en lugar del respondiente, que es la compañía Wyman.
I would also like to note that April Norton, the Director of Human Resources, is on the call listening in as well. And I think the investigator's report from our point of view really spells out the key factual aspects of this case and why a finding of no reasonable grounds is appropriate. But there are a few points that I do briefly want to speak to regarding this matter.
Yo quiero también mencionar que el director de Recursos Humanos está en esta llamada también escuchando por el teléfono, y también quiero declarar que la investigación, como se dijo, lo que se encontró, no se encuentran, no hay razones para lo que se está pidiendo, pero también quiero aclarar algunos otros puntos.
First and foremost, I think it's important. The only adverse action that Ms. Vargas was claiming in her initial charge and the amendment to her charge was that she got a written warning and related to taking breaks.
Es importante destacar que en primer lugar, que la única acción adversa de parte del empleador que la señora Vargas recibió fue recibir una advertencia por escrito por tomar breaks o recreos.
The warning that Ms. Vargas received, although she claims that it was discriminatory, retaliatory for making complaints about other coworkers, the record and the documents that were set forth in conjunction with the position statement submitted by a respondent, as well as a narrative, established that that was administered for a legitimate and non-discriminatory reason.
De la advertencia que la señora Vargas recibió, aunque ella dice que fue algo que fue discriminatorio, retaliatorio, en verdad fue algo que se hizo de una forma justa.
Another significant aspect of Ms. Vargas's initial charge and her amended charge, as well as the rebuttal, involved complaints made about other employees at Wyman and her interactions with them.
This is the interpreter speaking, would you please repeat the last segment for me?
Yep. A large aspect of the charge, the amended charge, and the rebuttal to the position statement involved Ms. Vargas's making complaints about other employees at Wyman and her interactions with them.
Thank you. Una gran parte del aspecto de su acusación principal y de la acusación que vino después y tiene que ver con las quejas que la señora Vargas hizo de sus compañeros de trabajo.
And I think it's really important to recognize that the documentation, as well as the investigator's report, established that Wyman addressed and investigated the complaints that Ms. Vargas made about other employees. And they did this by reviewing surveillance footage, talking to Ms. Vargas, and talking to other employees.
También es importante reconocer que el reporte de la investigación dice claramente que acerca de las quejas de la señora Vargas de los otros empleados, y eso todo se pudo ver, se puede comprobar a través de las cámaras de seguridad y todo eso.
Respondent took her complaints seriously and took corrective action against other employees when it was warranted and substantiated by its investigation.
Y se respondió a las quejas que la señora Vargas hizo después que se investigó y se determinó que había sustancia para hacerlo.
The additional submissions after the investigator's report focused substantially on the termination of Ms. Vargas's employment, but this was not alleged in her initial charge or in the amendment to her charge. And although termination was discussed briefly in the rebuttal, it wasn't expressly alleged as a discriminatory or retaliatory act.
El hecho de que ella haya sido cancelada de su terminación como trabajadora no estaba en la sumisión adicional primera, eso vino después. Eso se habló en la primera, pero no tenía nada que ver con la primera, eso vino después en la segunda.
At this point, where the termination wasn't part of the case, and for Ms. Vargas's attorney to now allege that the discharge was retaliatory, and submit written argument on the very last day of the window following the investigator's report, made it impossible almost for respondent to respond to that allegation at all.
Y el hecho de que el abogado haya indicado que la terminación de la señora Vargas fue en reacción o retaliación al primer caso, en la primera sumisión, casi un día antes del tiempo que teníamos para esta reunión, casi hizo imposible para nosotros poder prepararnos para esta acusación.
Throughout the case, the investigator didn't have a chance to ask for additional information about the termination, and we didn't have a chance to develop the record as to the issue of whether her termination of employment was an adverse employment action. And while there's a lot of discussion about the application, which we do have, that's part of the reason why that's not in the record, is because the termination simply wasn't at issue.
También el investigador determinó que no fue una acción adversa del trabajador el hecho de terminarla, aún porque nosotros tenemos la aplicación y podemos ver que eso no estaba en la... I'm sorry, can you please repeat the last phrase for me? I lost the last phrase they said.
Termination wasn't an issue.
La terminación de la señora Vargas no fue un problema.
With that said, however, while we're not allowed to present new information, there is substantial information in the record already that do establish that she was a seasonal worker. Specifically that she signed a seasonal employee handbook that was provided to her at orientation on the first day of her employment. She underwent a seasonal employment orientation. She performed work alongside seasonal employees, and it was the type of work that seasonal employees perform.
Aún cuando no podemos presentar nueva información, nuevas pruebas hoy, tenemos evidencia de que ella era una trabajadora temporaria porque tenemos un manual de trabajadora temporaria que ella firmó. También ella hizo trabajo que normalmente hacen los trabajadores temporarios y también ella trabajó al lado de los trabajadores temporarios.
So at the end of the season, when there was no more seasonal type work for Ms. Vargas to perform, that's why she was let go, and it was not retaliatory for anything that she had done previously in the course of her employment. For these reasons, we respectfully ask that you adopt the investigator's finding of no reasonable grounds, and I'm happy to answer any questions.
Al fin de la temporada de trabajo, la señora Vargas fue terminada, como se hace con todos los trabajadores, y eso no fue algo retaliatorio, como se dice. Por eso nosotros sugerimos que adopten la investigación que se hizo, en la cual decimos que no hay fundamento para dudar de lo que el investigador encontró.
Thank you. Questions for Ms. Johnston, Commissioner Whitworth?
No questions, thank you.
Commissioner David? Nope, I skipped Commissioner Ashby. Sorry. Hold for just 1 minute, Commissioner David. Commissioner Ashby, sorry.
He could have gone first, that's fine. I just have one question. Is there, if the record indicates this, is there like a mass layoff that occurs with your seasonal employees leaving, or do they leave in some other schedule?
Hold on, Ms. Johnston.
Una pregunta, si hubo un despido masivo, ¿se dejó ir a varios empleadores al mismo tiempo?
It is not quite mass, but not quite individual. There's a substantial reduction that takes place over that entire seasonal workforce around that time of year. So depending on particular position and the needs, then it's sort of a large reduction occurring in the same time period.
No hubo un despido masivo, tampoco hubo algo individualizado, sino que simplemente hay una reducción de trabajos temporarios. Depende mucho de la posición, depende mucho de la necesidad que se hace una reducción de personal.
And so this employee left with other employees. I mean, she was not singularly terminated on that day.
Entonces este empleado se fue con otros empleados, no fue simplemente dejada ir solamente ella.
If the record can tell us.
Yeah,
si,
no, in the
si el récord lo permite.
Apologies.
No.
In the position statement, we do state that complainant and several other employees were informed that particular day that they would not be needed. And then there's, additional information outside of that realm.
Thank you.
En la declaración de nuestra posición dice claramente que el empleado se lo dejó ir junto con varios otros empleadores y otras informaciones adicionales con respecto a eso.
Commissioner David, now you.
Thank you. Attorney Johnson, is there any individual confirmation of hiring and the status? You said that she signs a seasonal handbook and an orientation, but do they give a confirmation that you are hired ... Or is it just, you sign up and you start getting your paycheck and...
Yo sí tengo una pregunta. ¿Hubo una confirmación de estado de empleo? Usted dijo que ella firmó un manual y una orientación, pero hubo, por ejemplo, un papel que dice, usted fue contratada, tal, o simplemente se hace la orientación y se le empieza a pagar.
Commissioner, I'm not entirely sure of the nitty gritty of that process in this situation. As I mentioned, April Norton, the Director of Human Resources at Wyman, is available, and I would defer to her to answer that question if that was possible, but I'm not sure myself.
Yo no estoy segura de eso, de exactamente qué fue lo que pasó en esa situación. Tengo al representante de recursos humanos que está conectado. Yo deferiría a él para una respuesta en cuanto a eso, pero yo no sé.
But I would add that we did include a copy of the cover excerpts and the acknowledgement page from the handbook that Ms. Vargas had signed at the outset of her employment.
Pero sí voy a resaltar que yo incluí una copia de la parte del manual del empleado que ella firmó.
Commissioner David, I would note that the investigator is indicating they can answer your question as well.
Como comisionador David, también quiero decirle que el investigador también puede responder su pregunta.
So Commissioner David, any other questions for Ms. Johnston? No. Okay. Commissioner Dusan, questions for Ms. Johnston?
I think not. I too want to know if there's an offer letter that confirms status and hourly rate, that kind of stuff, but it sounds like I should reserve that question for the investigator to inquire if she inquired about that.
Okay.
Yo no tengo ninguna pregunta. Es que quisiera saber si hay alguna carta de oferta de trabajo o algún arreglo en cuanto a lo que se iba a pagar por hora, pero creo que reservo esa pregunta para el investigador.
Commissioner O'Brien, questions for Ms. Johnston?
I'm all set. Thank you.
Okay.
Señor O'Brien no tiene preguntas.
Okay, Ms. Johnston, you'll have about just over 5 minutes when we come back to you. But at this point, we're going to go back to Mr. Guare. Where are you, Mr. Guare? There you are.
Thank you.
So Mr. Guare, you have about 6 minutes left.
Thank you. A few quick points. First, it is absolutely correct that the charging document and the amendment to the charging document in this case do not contain an allegation of termination. The reason for that is that at the time the charge was filed, the complainant was still working for Wyman's. It would have been dishonest, premature to say the least, to allege termination at that point.
Mr. Guare, I know that the interpreter was raising his hand.
Yeah, we're good. We're finished. Correcto. Yo entiendo que en la primera acusación y la enmienda a la primera acusación no hubo ninguna alegación de terminación, de despido, porque ella todavía estaba trabajando para la compañía. Entonces eso no sería honesto hacerlo. Solo eso.
And after she was fired, as I've noted previously, and I won't repeat myself, Ms. Vargas did state that she was hired as a full-time employee.
También después de que a ella la despidieron, yo no quiero repetirme a mí mismo, pero la señora Vargas dijo que ella había sido contratada como empleada a tiempo completo.
And although her post-firing submission did not very eloquently state that she was terminated for retaliatory reasons, I would emphasize again that she did state that she was hired as a seasonal worker. She was laid off. She questioned her seasonality. That, with an unrepresented complainant, I believe creates enough of a factual inference that further investigation would have been warranted.
También, como se dijo antes, ella dijo que fue contratada, ella cuestionó si era realmente trabajadora temporaria o si era trabajadora a tiempo completo. Además de eso, ser un demandante que no tenía representación, eso de cierta forma afectó la parte del proceso.
Ms. Johnson also noted that the respondent investigated the complaints made by the complainant and concluded that there was no substance to those complaints.
También la señora Johnston declaró que el investigador de la compañía investigó las alegaciones del demandante y no encontró ninguna sustancia en ellos.
I would point out, though, that for our purposes today, the real question is not whether what Ms. Vargas was alleging is correct or not.
Yo quiero apuntar que en el día de hoy lo que es importante para nosotros no es si lo que dijo la señora Vargas es correcto o no.
The question is whether she was retaliated against for making those complaints.
La pregunta es si ella la retaliaron, fue retaliada por hacer esas quejas.
And the final point that I would like to make is that I would point out to the commission that in the record, there are 3 documents submitted by the respondent with regard to the complainant's hiring: a job description, actually 2 job descriptions, as well as a document which the complainant signed called an employee acknowledgement form. None of those documents mention whether the employment is seasonal or full-time.
También se habló de documentos, los documentos de orientación, los documentos de manual del empleado y otros documentos, pero ninguno de esos documentos realmente dice si ella era trabajadora temporaria o trabajadora a tiempo completo.
Unless I missed it, there is no mention whatsoever of seasonality or temporary employment in any of those documents.
A menos que yo no lo haya leído bien, pero no hay ninguna mención de que ella era temporaria o que era a tiempo completo en esos documentos.
And to get back to conclude a point that I was making a minute ago, which is that the question before us today is whether she was fired in retaliation for making complaints.
Entonces, voy a volver al punto que estaba haciendo antes, que era el hecho de la pregunta para nosotros hoy es que si ella le respondieron de una forma retaliatoria por ella hacer ese tipo de acusaciones.
The question is not whether the complaints that Ms. Vargas made are true. The question is whether she was retaliated against for making them. And the only standard that the statute imposes upon a complainant in these circumstances is whether they are acting in good faith. And there has been no allegation whatsoever by the respondent or by the investigator that Ms. Vargas was not acting in good faith.
La pregunta para nosotros no es si las alegaciones que ella hizo eran verdaderas o no, pero sí si ella fue tratada de una forma retaliatoria por la empresa al hacer esas declaraciones. Y el hecho de que se haya investigado, se haya cuestionado la naturaleza de las declaraciones que ella hizo, no se encontró nada de que ella no lo hizo en buena fe.
To summarize, and then I will stop, I promise. I believe that there is a legitimate factual question here as to whether the complainant was hired on a full-time or a seasonal basis, which warrants a new investigation. Thank you.
Voy a resumir, y termino, hay una pregunta legítima aquí que quiero dejar, que es la siguiente. Si el demandante fue contratado en una posición temporaria o en una posición tiempo completo. Y para eso yo pido que haya una nueva investigación. Gracias.
Questions for Mr. Guare from commissioners. Commissioner Whitworth?
Yeah, I do have a question. I'm wondering, and I don't know if this is in the record or not, so if it's not, please don't answer it. I'm wondering if this individual, had been hired, not on a temporary basis, but on a regular basis, what would the job be in the middle of January, for instance? Because again, I haven't seen the job description, wasn't provided to us, although I do know it's in the record. What kind of work would be done outside of blueberry season?
Yo sí tengo una pregunta. Si el individuo fue contratado en una base permanente, base regular de trabajo. ¿Qué tipo de trabajo se haría en la mitad de enero? Porque yo sé que está la descripción en los récords, pero ¿qué tipo de trabajo se haría aparte de la temporada de blueberries?
I'm not sure it is addressed in the record, and I am not the best person to ask what employment is available during the winter. All I know for sure is that I do know that Wyman's has full-time year-round employees, and Ms. Vargas is asserting that she was hired to be one of those.
And Commissioner, I would note that I don't believe there is information in the record, and I'm sorry I didn't catch that sooner about what work might be there in the off-season.
Yo no sé exactamente, el abogado dijo, yo no sé exactamente qué tipo de trabajo se hace, no sabría decirle, pero sí sé que Wyman, la compañía, contrata personas para trabajar tiempo completo durante esa temporada.
That's all I have. Thanks.
Eso era todo lo que yo tengo. Gracias.
Commissioner Ashby,
I have no questions. Thank you.
Commissioner David,
No, thank you.
Commissioner Dusan. Okay. Commissioner O'Brien.
No, it's already been asked and answered. Thank you.
Okay. So then we will turn back to Ms. Johnston. You have just over 5 minutes left.
Thank you. Just to start off, in response to Attorney Guerra's statement that we determined that there was no substance to Ms. Vargas's complaints during employment, we did determine that there was substance in cases where the investigation warranted it, and we did administer disciplinary action to another employee based on those complaints.
Solo para responder, thank you. Solo para responder lo que dijo el abogado Guerra, que no encontramos ninguna sustancia en las alegaciones que hizo la señora Vargas. Nosotros sí investigamos y sí encontramos. Y cuando encontramos la sustancia, nosotros sí actuamos y tomamos las medidas necesarias.
And I understand completely that the issue here isn't the substance of the complaints, but I did want to revisit that just again to establish that we worked with Ms. Vargas and we didn't have a retaliatory animus to her for making those complaints.
Yo entiendo que el problema aquí no es la esencia de las acusaciones que ella hizo, sino si se retalió o no contra ella. Y nosotros trabajamos con la señora Vargas y entendemos que no hubo ninguna acción retaliatoria en contra de ella, y yo quería establecer eso.
And again, the fundamental question here at this point is about the termination. And while she was still employed, just I believe a few days difference between her complaint and the termination, I think that even further establishes that the allegations about the comments and the complaints related to other employees and the written warning are the fundamental basis of her making the complaint.
También la pregunta fundamental aquí es el tema de cómo ella fue despedida y el hecho de que fue a días de su queja o de su demanda. Ella fue despedida por causa de las quejas que ella hizo, que no fue corrección, por causa de la queja que ella hizo contra sus empleados, contra sus compañeros de trabajo, sino porque ya era el tiempo de terminar su trabajo temporal.
Ms. Vargas had ample opportunity in the months and almost a year, I believe, that this has been pending, to amend her charge and her complaint to include an allegation that she felt she was being retaliated against in terms of being terminated. And this was briefly discussed in the rebuttal, which she appears to have had help assistance drafting. But just the allegation was never made. And I think that's telling that she didn't view her termination as retaliatory, despite that she might have been had a different perspective on why it occurred.
También nosotros hablamos mucho de que ella tuvo una amplia oportunidad de hacer una enmienda a la acusación que se hizo si ella se sintió como realmente había sido despedida por causa de retaliación y ella no lo hizo, pero sí después con el tiempo quizás algo pasó en su perspectiva y ella decidió declarar que fue por causa de retaliación. O sea, ella tuvo suficiente tiempo para hacerlo, apenas pasó, pero no lo hizo.
And lastly, I would just like to correct the statement that there's no documentation that states, seasonal or temporary, but the cover of the handbook that was signed and submitted an excerpt in the file with respondent's position statement explicitly says seasonal, summer, and temporary employees on it.
También me gustaría hacer una corrección en una declaración que dice que no hay documento especificando si ella era trabajadora temporaria, trabajadora tiempo completo. La tapa del manual que ella usó, que se le envió, dice específicamente que es para trabajadores temporarios del verano.
And Ms. Vargas either would have had a translated version or had this document and the information within translated by Rebecca Ortiz, who's an employee of Wyman, who's referenced in the position statement as having translated.
If I could just ask the parties, and I'm sorry I didn't catch this, we don't allow the name of individuals who are not the parties, so please don't use individuals' names.
I apologize. An employee of Wyman who had translated for Ms. Vargas in the past would have been available to translate the information there.
Y también quiero decirle que la señora Vargas hubiera recibido una versión traducida al español de ese manual de trabajo o hubiera un empleado de la empresa Wyman hubiera traducido para ella lo que dice el manual si no estuviera en su idioma.
And as a final point, I would just like to add that there's no information, even if Ms. Vargas believed she was a full-time employee, there's no information to suggest that she was terminated in retaliation for making any complaints months prior to her termination at the same time as other employees.
Mi punto final es que no existe ninguna información que sugiere que la señora Vargas haya sido terminada, haya sido cancelada en el trabajo por motivos de retaliación, aunque ella lo haya sentido por causa de lo que haya pasado con los empleados algunos meses anteriores a su fecha de despido.
Nothing further. Thank you.
Nada más. Muchas gracias.
Okay, questions from commissioners for Ms. Johnston, Commissioner Whitworth,
No questions, thank you.
Commissioner Ashby,
No, thank you.
Commissioner David, Commissioner Dusan,
No, thank you.
Commissioner O'Brien.
No, thanks.
Okay, so that's it from the parties. And now we're going to turn to the investigator. Let's let the interpreter mention that first.
No hay ninguna otra pregunta más adelante de ninguno de los comisionadores. Entonces vamos ahora a dar el turno para el investigador.
Good morning, everyone. My name is Alex Brindley, and I was the investigator assigned to this case.
Buenos días todos. Mi nombre es Alex y yo fui la investigadora asignada a este caso.
And I believe Attorney Johnston answered Commissioner David's question, but I want to reiterate that the respondents provided in their answer a employee manual for seasonal temporary employees, which the complainant did sign an acknowledgement form of.
La abogada Johnston respondió a la pregunta del señor Mike Gary, pero también yo quiero decir que el empleador sí proveyó un manual de instrucciones, manual del empleador, que dice que es trabajador temporario.
But other than that, I don't have anything else to add, but I am open to questions if you may have them.
Pero más de eso, yo no tengo nada más para agregar. Estoy dispuesta a responder preguntas.
So commissioner questions for the investigator, Commissioner Whitworth,
No questions, thanks.
Commissioner Ashby,
No, thank you.
Commissioner David, Commissioner Dusan,
Just if you would clarify or reinforce to what extent your investigation did or did not include a review of the specific hiring status of the complainant.
Solo, sí tengo una pregunta. Si su investigación hizo o no lo hizo, encontrar o revisó de una forma específica la situación la situación de empleado de la señora Vargas.
So considering the fact that the respondents did provide an employee manual that the complainant did sign that stated that she was a seasonal employee, I didn't feel it was necessary to inquire further as to whether or not she was a seasonal or full-time employee.
Dado el hecho de que el empleador sí proveyó un manual del trabajador donde dice que es para trabajadores temporarios, yo no vi la necesidad de seguir investigando para ver el hecho de si realmente era trabajador temporario o trabajador full time.
If I may, a follow-up question.
Si puedo, por favor, hacer una pregunta de seguimiento.
Did you have the occasion to inquire whether there was any other hiring document, a different hiring document provided to full-time employees?
I did not.
Thank you.
Usted tuvo la ocasión, pregunta del comisionador Dusan al investigador, usted tuvo la oportunidad de ver si había algún otro documento de empleo y el investigador respondió que no.
anything else, Commissioner Dusan? Okay, Commissioner O'Brien? Okay. Thank you, Alex. So we've heard from the parties and the investigator, and now the question is for the commissioners to vote.
Escuchamos de las dos partes, escuchamos también de los comisionadores. Ahora la pregunta es para los comisionadores para votar.
I'll move that we adopt the findings of the investigator that there are no reasonable grounds to believe that the respondent discriminated against the complainant.
Yes.
Is there a second?
I was gonna well, and that the complaint be dismissed in accordance with the act.
Sorry, Jeff.
No, fine. I was trying to accommodate the interpreter.
Okay. So let me. Would you mind?
Yeah, I'll say it again.
Thank you, because I was waiting if somebody else was going to say something too. Go ahead. Thank you.
I'll move that we find that there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of national origin or race, or retaliated against her for engaging in workplace protected activity, and that the complaint be dismissed.
No existen fundamentos para creer que hubo de parte del empleador cualquier tipo de retaliación o cualquier tipo de discriminación basado en cualquier tipo de elemento de origen de la persona, del demandante, y que esta demanda o que esta queja sea demitida, que sea descartada.
So we need a second for that.
I'll second.
Necesitamos una segunda moción y alguien dijo, yo hago segunda.
Is there any discussion?
¿Alguna discusión?
Commissioner David?
Yeah, without concluding that I think it would be justified, Attorney Gare asked us to remand. So my question is to you, Amy, or to Barbara. I assume that that's not an option before the commission, that we vote up or down. Is that right?
Yo tengo una pregunta porque se pidió que se haga una remienda. Yo no sé si eso es correcto, si se puede hacer, si es posible, si votamos porque sí o porque no.
We have in the past had the commission vote to send back for further information. So it is something that's been done before.
Se hizo en el pasado, se mandó, la comisión puede mandar para que se haga otra investigación sin que se vote si sí o si no.
Thank you. I don't think it's justified in this case. Nothing else.
Muchas gracias. Yo no creo que se justifique hacer una investigación que siga en este caso, pero solo quería saber.
Is there any discussion of the motion for no reasonable grounds?
¿Hay alguna discusión, algún diálogo, alguna conversación para esa moción de que no existen fundamentos razonables para el caso?
If not, Deb, do you want to call the motion?
Si no hay ninguna, Deb, ¿quieres confirmar la moción?
Deb? So all those in favor of the motion to find no reasonable grounds to believe that there unlawful discrimination on the basis of national origin or race or retaliation. All those in favor of that motion, raise your hand and say aye.
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 Todos en favor de esa moción de que no hubo discriminación o retaliación ilegal basado en elementos de origen del demandante, por favor digan aye.
So the vote was 5 commissioners in favor of that motion. So the finding of the commission is that no unlawful discrimination or retaliation occurred.
Entonces hubieron 5 votos a favor de la moción que se hizo y esta comisión encontró que no hubo retaliación o discriminación.
And that ends the hearing on the first case, and the commission will send the parties and their attorneys a letter describing the vote and next steps.
Eso termina entonces este primer caso y se mandará una carta a las partes envueltas, describiendo los que se encontró en este caso.
Thank you to the parties and to the interpreter.
Gracias a las partes y al intérprete.
And I think Deb Whitworth, Commissioner Whitworth is having some technical difficulties. So either Commissioner Ashby, you can call the next case, or I can step in and do that. Either way is fine.
Would you step in just because I wasn't clear on the order? I don't have the agenda in front of me. I have the cases to be heard, but not the agenda.
Yep. And I just saw Commissioner Whitworth is back. So Commissioner Whitworth, now you're moving. Your screen is going everywhere. There you are over there. Okay. So Commissioner Whitworth, we are ready. Go ahead.
I'm sorry, I'm having trouble with connectivity. I'm going to pop out and try another computer.
Okay, I will do the honors of calling the next case then, which is H/E 19-0254 A and B, which is Waleska Rodriguez versus Worcester Reith Company, Worcester Resources, Worcester Holdings, Damian Mejia, and which I'm sure I'm pronouncing wrong, and Brianna Mejia Bouchard. And we're going to have, I believe, Sylvia interpreting here. Do we have any of the complainants or respondents? I think I did see Ms. Rodriguez. Did I see Ms. Rodriguez? Maybe not. Do we have any?
Sorry, I saw that she had called in a little while ago. She doesn't appear to be on right now, though.
Okay, are you of the opinion that we should be doing this interpreted, Mr. Mancuso?
Yes, because I know Mr. Rivera, this case and the next case are interrelated. We'll be watching the recording, and he may actually be watching the live stream right now.
Okay, then interpreting, let's see, Sylvia, do we have you? There you are, Sylvia. Okay,
Hi.
So I'll use the same protocol here, which is their attorneys and parties, you get 10 minutes, and I'll pause for the interpretation. The only submission here is by Ms. Rodriguez, but the respondents are entitled to respond without having made a written submission. So, Mr. Mancuso.
Good morning, commissioners. Thank you for hearing us out on this. I want to go first of all, state that complainants, Waleska Rodriguez and Richard Rivera, that's the next case, but the facts are all interrelated, and the two cases are, at least in terms of our response, are substantially the same. Should I be pausing for the interpretation? I'm sorry.
That's what I'm waiting to see.
Buenos días, muchas gracias. Primero que nada, quiero mencionar que ambos casos es de Waleska Rodríguez y Rivera. Ambos casos tienen la misma importancia.
First of all, complainants want to state that we don't disagree with the majority of the factual findings of the report. The sum total of our disagreement, as outlined in our response, comes from certain facts that were testified to by respondents in the IRC that we feel weren't adequately factored into the tests, into the legal tests that the investigators' report considered.
Primero que nada, el demandado y yo queremos aclarar que estamos de acuerdo con todo lo que se mencionó anteriormente. Es solo con algunos hechos de las respuestas que recibimos con las que no estamos de acuerdo, que fueron hechas en las pruebas legales y en las pruebas realizadas por el investigador.
First, with regard to whether there exists an integrated enterprise between the Worcester respondents and Mr. Mejia and Ms. Mejia Bouchard.
Primero fue con las respuestas que dio el acusado, el señor Mejia.
At the IRC, the owner of the Worcester respondents testified that they had that he was always on site to watch over the work that was being done and had the ability to address complaints from the contractors. This is specifically on page 14 of the investigator report for Mr. Rivera, if you want to reference where that specifically is.
Lo primero que se menciona es lo que está en la página número 14, es lo que se menciona por el señor Rivera. Es que él atestiguó que el señor Mejía siempre estaba en el lugar disponible para responder a todas las quejas que se hayan proporcionado.
As the investigator's report came to the conclusion that the complainants had established that there was an interrelated, that the work of the contractor and of the Worcester respondents was interrelated in terms of they were doing the same thing. This establishes the control factor because, as the case complainants cited in my response, the US EEOC v. Global Horizons, this ultimate control need not actually be exercised in order to establish that the basically parent company has that control and has the ability to exercise it. This was a Ninth Circuit case from 2019.
Y lo que menciona la certificación del 2019 es que el demandante estaba relacionado con el contratista y básicamente hacían el mismo trabajo. Ambos tenían el control.
Secondly, the owner, a few days after the incident in question that the complaints arise from, referenced that he had a meeting with the complainants, and at that meeting, in response to what his supposed contractor had done, offered them additional work doing substantially the same job.
Algo más que mencionó el propietario es que días antes de las quejas, él tuvo una cita con los demandantes acerca de darles más horas de trabajo.
Complainants see this as, at very least, strongly arguable that this is evidence of the owner's acknowledgement that he has the ultimate hiring and firing authority for jobs within his own factory.
Y cabe destacar que él tiene el poder más fuerte para contratar empleados.
And that this is just further evidence of the strongest and most important factor of the interrelated enterprise test, that the ultimate joint employer or ultimate controller has control over the work that's being done by the workers in question.
Y estas son evidencias de que él tiene el único control de todo el trabajo que se realiza en su compañía, en su empresa.
Secondly, I want to move on to what was addressed in section 3 of our response.
Ahora quiero dirigirme respecto a lo que hubo en la sección 3 de nuestra respuesta.
That the report concluded that the housing coordinator for the Worcester respondents, and this is on page 5 of the Rivera report, was present, but it was not clear that they understood enough Spanish to understand what was happening when the complainants were fired by Ms. Mejia Bouchard.
Y también lo que hubo en el reporte concluyó en el reporte que se proporcionó por el señor Rivera, es que el coordinador que controlaba el alojamiento estuvo presente cuando se hicieron estas quejas, pero debido al idioma no entendió.
However, at the IRC, and as referenced on page 15 of the Mejia report, they use the same IRC for both cases, just to be clear. But I'm referencing the Rivera report because that's where I have my notes. I don't want to go on too far before the translator goes, so I apologize if I'm stuttering talking.
En el reporte del señor Mejía también se estableció lo mismo, pero me estoy dirigiendo en este momento nada más a lo que pasó en el reporte del señor Rivera en la página número 15.
At the IRC, and as referenced in the notes, the housing coordinator for the Worcester respondents stated that she understood that Ms. Mejia Bouchard told Ms. Rodriguez that Mr. Mejia accosted her, and that she responded, no, he pulled her hair. So in that meeting, in the IRC, the housing coordinator testified that she understood generally what was happening. Even if she didn't understand every single word, she got that there was an attack, and that complainants don't understand why that wasn't considered sufficient to have the housing coordinator aware that there was some kind of conduct that would have required at least some additional investigation.
También lo que se mencionó por parte del coordinador del alojamiento es que el señor Mejía mencionó que hubo acoso, pero después él dijo que no, que solo le jaló el cabello y ella entendió, a lo mejor no palabra por palabra, pero sí entendió que hubo un ataque y que se debió de haber investigado aún más el caso.
Ultimately, with all due respect, complainants believe that acceptance of that portion of the investigator's report would essentially be rewarding the Worcester respondents and perhaps specifically the housing coordinators basically feigned ignorance of the situation that was playing out in front of her. And that can't be right. That can't be the correct way that this can go.
Últimamente, con el debido respeto, con la porción que proporcionó el investigador acerca de este caso respecto al coordinador del alojamiento, que se declaró ignorante de esta situación, creemos que no procede.
Otherwise, complainants are happy and comfortable with the factual findings and the remaining legal arguments in the investigative report. And thank you for your time.
Y fuera de eso, pues nada más no estamos conformes con los argumentos legales y gracias por su tiempo.
Okay.
Yep.
Yeah, questions from the commissioners? I don't have any questions. I don't know, Amy, if you want to be the one who goes around the room.
Sure.
I don't have any questions. Thank you.
Commissioner Ashby, yep. I'm sorry, Commissioner Ashby, did you have questions?
I'm sorry, I do not have any questions. I'm sorry.
Commissioner David?
Attorney Mancuso, as I hear your argument, you are equating, are you not, that control of the overall project, which is wreath making, is equivalent to controlling the workers, which, as I understand it, are the province of an independent contractor.
Let's wait while that's interpreted.
Respecto el miembro de la comisión, el señor David, tiene una pregunta respecto al control en general del proyecto y al control general de los trabajadores, si todo pasó al contratista independiente.
It's partially that, and it's a little bit more. In this case, and this is reflected in the IRC and the interviews with the complainants, they received very little direct on-the-job direction from anybody, much less the contractors, but we're working in the Worcester respondents factory using the Worcester respondents tools, living in the Worcester respondents coordinators, and ultimately the Worcester respondents, as testified to by the owner of the Worcester respondents, could have addressed complaints. He set their schedule and he organized which contractors were coming in and set them to work. These are the control factors that extend an integrated enterprise from what would nominally be an independent contractor to the ultimate company.
Okay, and another question.
Hold on, Commissioner David, let's let that be interpreted.
Es así como usted lo dice, pero es un poco más de eso. También mencionan que recibieron pocas instrucciones acerca del trabajo que iban a realizar y utilizaron las herramientas de la compañía y estuvieron físicamente en la compañía. Entonces ellos pudieron haber respondido a las quejas que entraban por medio de los trabajadores acerca del contratista.
In the same vein, you referred in your argument, you described Worcester as the parent company, but it's not a parent company. correct? It's not a parent company of the employer, the company that hires the employees and trains them and supervises the work.
I'll wait for the translation. I'll try.
Usted en su argumento mencionó que Worcester era una compañía padre y esta se debe al empleador, que es donde recibían entrenamiento y supervisión.
Worcester respondents hired the Mejias to hire contractors for their factory. That's the technical relationship. In this instance, that meant that the Worcester respondents maintained the ability to control the individual contractors' housing, meals, their transportation, ultimately their work hours, and maintained people on site to have ultimate supervisory authority. Under the Ninth Circuit case, the EEOC v. Global Horizons, that is the joint employment that's required to establish that both parties being the Mejias and the Worcester respondents are employers of the complainants and the other wreath makers that were on site.
Let's let that be interpreted.
Our interpreter would like to ask for a repetition of the last part, please.
I'm sorry, which part?
After the Horizons company.
That under the EEOC v. Global Horizons, that the Worcester respondents maintained ultimate control over the contractors, could field complaints, and were controlling their housing. That these are the control factors that establish that the Worcester respondents and the Mejias were joint employers.
Thank you. La relación que hubo respecto al demandado de Worcester y Mejía, la relación fue de contratar los empleados, de darles alojamiento, de darles comida, de darles horas, de las horas que iban a trabajar, de darles supervisión, y ambas partes, esta era la relación que tenían con los empleados.
Commissioner David, any further questions?
Thank you.
Okay. Commissioner Dusan?
I have no questions.
Commissioner O'Brien?
Now, thanks.
Okay, so now Mr. Mancuso has about 3.5 minutes left when we come back to him. But right now we will turn to the respondents. And I believe Mr. Raines is here for some of the respondents, but not all of them.
Yes, Matt Raines for the Worcester respondents. Can you hear me?
Just barely, it's a little faint.
I'll try to speak up. How is that?
It's better.
Okay.
And so you're not here for Mr. Mejia or Miss Mejia Bouchard?
That's correct.
Okay, I'm going to let the interpreter. Do you need to interpret that or no?
La parte que representa al demandado de Worcester, el señor Mejia.
Okay, so 10 minutes, but with pauses for interpreting.
Okay, I'd like to reserve the remainder of my time. Worcester agrees with the investigator's findings with respect to the fact that it was not the complainant's employers. Quoting the investigator in the investigative report, complainant failed to provide any evidence that the Worcester respondents and Mejia Bouchard met anything other than the first factor of the integrated enterprise test, the interrelation of operation. The investigator further found that Mejia
Hold
Bouchard.
on. Hold on.
Yep.
Lo que queremos decir es que estamos de acuerdo con la conclusión de la investigación hasta ahora acerca del contratista.
The investigator further found that Mahil Bouchard employed the complainant who controlled the complainant's and her other employees' work, which included recruiting, hiring, paying, and training her crew. The Worcester respondents, quote, did not control complainant's work in any way, end quote.
Y el señor Mejía no recibió ninguna queja acerca de la contratación o de haber contratado a el grupo de personas que iban a trabajar para la compañía.
As noted, Worcester employs its own employees during the 2-month brief-making season. It recruits and hires its own employees. They complete the employment application, the I-9 process, and the E-Verify process on their own employees. They pay their own employees, they discipline their own employees when warranted, and they fire their own employees when warranted.
Y los empleados que son contratados por medio de Worcester normalmente son contratados temporalmente, se encargan de las aplicaciones de empleo, de hacer toda la verificación correspondiente de los empleados.
By contrast, Worcester did not employ the complainants. After interviewing the complainants and the respondents' representatives at the Issues and Resolutions Conference, the investigator correctly found that Worcester respondents were not complainants' employer. Worcester did not recruit them, did not hire them, did not train them, did not have them complete employment applications, I-9s, they did not run them through E-Verify, they did not pay them, did not supervise them, did not control their work or how they did it, and did not fire them, most importantly, because they had no authority to do that. Now, the fact that the owner may be on site.
Hold on.
Thank you. Entonces, lo que Worcester quiere aclarar en este momento es que ellos no dieron empleo a los demandados, no hubo aplicaciones de empleo, no hubo supervisión, no hubo control a los empleados, no hubo verificación del proceso, por lo tanto, tampoco no los despidió.
By contrast, like I said, Worcester did not employ the complainants. The complainants knew that, Worcester knew that, everybody at the time knew that Worcester was not the complainant's employer. Now, complainants counsel cites a number of cases in an attempt to create an employment relationship where there clearly is none. Those cases don't apply here. The most recent case cited by counsel during this hearing involved H-2A workers that were brought to the United States by both employers. They controlled just about every aspect of their employment in that case. And the court, a Ninth Circuit court, which is not our jurisdiction and not controlling on us, found that there was enough there to find joint employment. That's certainly not the case here.
Hold on.
Y en contraste, también queremos decir que Worcester no dio empleo a los demandantes, ya que no hubo una relación de empleador-empleado y ellos traen, el contratista trae diferentes personas a Estados Unidos a trabajar, pero en este caso no era su jurisdicción.
In fact, during the Issues and Resolutions Conference, Morrill Worcester testified that I try to steer away from speaking directly to contractors' employees because it's their business, not mine. If the individual works for a contractor, I would steer them to the contractor. If the contractor couldn't handle it, then I'd address it. But it's really the contractor's issue. So the fact that he may be on site regularly is not sufficient to establish control over the terms and conditions of the work of employment necessary to find an integrated enterprise.
Entonces, el hecho de que se haya declarado de que el señor siempre se encontraba en el lugar de trabajo de ellos no significa realmente que ellos hayan estado a su cargo.
The other cases cited by complainants counsel are similar in that regard. There's far more control exercised over the workers, company-wide HR policies, common ownership, benefits, control of day-to-day employment decisions. None of that exists here.
Y aquí no existió ninguna entrega de beneficios o que se le hayan entregado políticas de acerca de la relación de empleo de trabajo.
As clearly testified to at the Issues and Resolutions Conference, Jane Ahrens, who was the housing coordinator and responsible
No names, please. Mr. Rains, please don't use any names that we've given acronyms or alternatives for in the report.
Sorry about that, thank you. The housing coordinator for Worcester, who's responsible for arranging housing for contract crews and for employees of Worcester themselves. She arranged the housing, and she, on the day in question, entered into what would I'd call a chaotic situation at best. She was looking to house a new group of incoming workers. There were mattresses missing from the bunk beds in the housing facility. She was searching for those. They came upon these workers. Then Brianna Bouchard dealt with her workers and communicated to Ms. Ahrens that they were no longer working for her.
Mr. Rains, I know you're not doing it on purpose, but you're still using names that we can't allow.
Brianna Bouchard communicated to the housing coordinator that those workers were no longer employed by her. Subsequently, the housing coordinator indicated, as is correct, that housing is contingent on continued work in the wreath operations, requested that they vacate housing.
Le recordamos al señor James que no puede mencionar nombres en este momento. Entonces, la persona que coordinaba el alojamiento para los empleados mencionó haber estado el día de las quejas, estaba presente, lo describió como una situación caótica y también que habían varios colchones que habían desaparecido del lugar y ella los estaba buscando. Y entonces el contratista mencionó que las personas que se habían ido ya no eran sus empleados.
The investigator correctly found that there was no evidence at all that respondents had any knowledge of the alleged harassment. In fact, complainants noted that they did not tell anyone at Worcester about any alleged harassment.
El investigador no encontró ninguna evidencia de lo que pasó y los demandantes no pusieron ninguna demanda acerca de que haya habido acoso.
We request that the commission adopt the investigator's findings as they relate to the Worcester respondents and find no reasonable grounds. Thank you.
Y respecto a este caso, los demandados de Worcester declaran que no hubo fundamentos suficientes para la demanda que se está presentando. Gracias.
Questions for Mr. Rains, Commissioner Whitworth?
No questions, thank you.
Commissioner Ashby?
I don't think so. Thank you. Not this time.
Commissioner David?
The housing coordinator is an employee of Worcester. Worcester owns the housing. Is that correct?
That's correct. A separate Worcester entity, Worcester Holdings, owns the housing.
La coordinadora del alojamiento es un empleado de la compañía Worcester.
Is that separation of those two entities significant in avoiding liability?
No, the holdings, I don't think so. I think that as the investigator would note that she could find an interrelated operation between the multiple Worcester entities, just not between them and Brianna Mejia Bouchard.
Okay, then
Hold on, let's let it be interpreted.
Hubo alguna separación importante respecto a estas dos partes. La investigación dijo que no había.
I think
that the housing was supplied by a separate entity that did not employ, to my knowledge, anyone.
But what you just said was that the Worcester entities, the several entities are can be treated as one in terms of liability, but that's different from the supervision of the employees and the contractor for the employees, right?
Hold on. We have to make a space for the interpreting.
Okay. Entonces, el coordinador del alojamiento era un empleado diferente a la entidad. La entidad de Worcester sí se puede tratar como una entidad separada a la supervisión de los empleados y al manejo de los empleados.
I wouldn't necessarily concede the interrelatedness issue as among the Worcester entities. I'm just stating that the investigator found that they would likely be considered, I think, interrelated operations. They do distinct things. They own property, they own land for the balsam tips, they run the factories, and they employ, separate entities employ the workers.
Son una entidad completamente separada de los empleados, los que manejan el bálsamo y todo lo demás.
Commissioner David, anything else?
No.
Commissioner Dusan.
I have no questions.
Commissioner O'Brien.
All set, thanks.
Okay. So is there anyone here for Damian Mejia or Brianna Mejia Bouchard?
¿Hay alguien aquí para Damián Mejía o Brianna Mejía Bouchard?
I don't see anybody. I haven't seen anyone on the call. We have had no response from those respondents. So at this time, I guess we would go back to Mr. Mancuso, who has about 3.5 minutes left.
Thank you. I'll try to go.
Hold on, Mr. Mancuso, hold on.
No tenemos a nadie en la llamada, entonces no tenemos ninguna respuesta del demandado tampoco, entonces vamos a proceder.
Okay.
I'll try to go quick. First, I want to take up the respondents and honestly the report's conclusion that there's no evidence of any control factors, while then pivoting to argue that the evidence of the control factors is insufficient.
Voy a hablar rápidamente respecto al demandado. La evidencia no es suficiente respecto a los factores de control.
Simply stated, the owner's testimony that he was on site and could handle complaints from contractors when necessary is a control factor. We disagree on how significant it is, but it is one.
Y no estamos de acuerdo con el testimonio del propietario de la empresa que dice que él no tiene ningún factor de control sobre los empleados, ya que ellos trabajan para él.
And in this situation, if you look at the owner's testimony on page 13 of the Rivera report, he testifies that Worcester Reef was a single company and did all the work that is now being done by the multiple companies and the contractors.
Y si nos fijamos en el testimonio del propietario, lo que él indica es que hay muchas compañías que son las que se encargan de los empleados y del control de ellos.
That's become diffuse over time with the hiring of the contractors. But as the complainants testified at the IRC, no one really controlled or directed their work because they had been doing it so long that it was unnecessary.
Y como se menciona, es que es un poco confuso porque el demandante menciona que nadie estuvo realmente coordinando a los empleados.
So in this case, with a workforce that's already well trained to do the individual jobs, the only ultimate authority is that of controlling any kind of complaints. And as the owner testified at the IRC, that came to him and what he was present for. So what authority there was to handle anything rested with the owner and with the Worcester respondents.
Entonces, lo que nos preguntamos es qué autoridad había por parte del propietario, si toda la fuerza de trabajo ya estaba entrenada, quién es quien tenía la autoridad.
And switching gears to with what the housing coordinator did, of course it was a chaotic situation. There was an assault the night before and a number of people, including the complainants, who were afraid throughout the entire evening.
Y respecto a lo que mencionó el coordinador, la coordinadora del alojamiento, es que sí, por supuesto que había una situación caótica ya que hubo un incidente la noche anterior y los empleados tenían miedo por lo que había pasado.
And by her own testimony, the housing coordinator arrived there, heard that one of the contractors was assaulted by one of the contractor workers was assaulted by Mr. Mejia, took that information and still evicted the complainants.
Y lo que indica uno de los testimonios es que esta persona escuchó que había habido un asalto por parte del señor Mejía a una persona de los empleados, a un empleado. Y aún así, ella decidió echarlos del lugar.
So although it was chaotic, it was chaos created by Mr. Mejia, to which the housing coordinator for the Worcester respondents responded, and with knowledge that there was an assault, by evicting the complainants.
Y entonces, aunque fue una situación caótica, esta persona se dio cuenta que había habido un asalto por parte del señor Mejía y esta persona respondió a ello sacando a las personas de su vivienda.
Thank you.
Gracias.
Questions for Mr. Mancuso, Commissioner Whitworth? No. Okay. Commissioner Ashby,
None, thank you.
Commissioner David?
No.
Commissioner Dusan? No. Commissioner O'Brien?
No, thanks.
Okay, thank you, Mr. Mancuso. Now we go back to Mr. Raines. Mr. Raines, you have 5 minutes left.
Thank you. Thank you for the correction by counsel. I did not intend to say insufficient. I meant to say no evidence of control. Being on site at a facility you own is not control. It's plain and simple. And in terms of the chaotic situation that the housing coordinator encountered, as I noted, she was trying to find beds for an incoming group of workers. Beds were missing from the facility. She went looking for those beds and came upon a scene. There was an argument between Ms. Brianna Mejia and the workers, and she was informed that the workers were no longer working for Brianna Mejia, and they were subsequently asked to leave, and they did.
Y quiero corregir respecto a lo que había mencionado anteriormente acerca de que no había evidencia de control y por obvias razones lo que pasó en esa noche fue una situación caótica ya que el coordinador del alojamiento estaba enterado En ese momento estaba en el lugar tratando de encontrar unas camas que se habían perdido cuando escuchó acerca del argumento que estaba pasando en el lugar y se les pidió que dejaran el lugar.
And as for Mr. Worcester being at the facility, it needs to be remembered that there are also actual Worcester employees working at the facility.
And just to remind
Esto fue,
Worcester, there is no individual named, it's just the corporate Worcester respondents. That is owner in our report. Sorry to Sylvia.
y se les quiere volver a mencionar que no se pueden mencionar nombres en este momento, entonces nada más vamos a mencionar el propietario del edificio o el coordinador del alojamiento.
Finally, when Mr. Worcester was ultimately made aware of an issue.
Mr. Rains, it's the owner.
Oh, sorry. When the owner was ultimately made aware of the issue or an issue with the contractor, he did offer, as set forth in the materials, employment with Worcester. That offer was ultimately declined by the complainants.
Podemos mencionar que el propietario de la compañía estuvo enterado acerca del problema que los empleados tuvieron con el contratista y ofreció apoyo.
Anything else, Mr. Rains?
No, thank you.
Okay. Commissioner Whitworth, questions for Mr. Rains?
No questions, thank you.
Commissioner Ashby?
No questions, thank you.
Commissioner David?
Does that offer of employment indicate a assumption of responsibility for the behavior of the employment contractor?
Hold on, before you answer, let's let that be interpreted.
Estaba mencionado en la oferta de empleo la responsabilidad que iba a tener por el comportamiento del contratista.
No, it does not. He did know that there was an issue with the contractor, as explained to him at that meeting. He had no problem offering employment with Worcester. They always need employees.
And sorry, go ahead, interpreter.
No se sabía que iba a haber con un problema con el contratista en ese entonces.
And before we go on, I just want to note, I'm getting a note from the investigator saying that is not in the record. So the commissioners should not actually consider it unless that's mistaken.
Y en este momento estoy recibiendo una nota del investigador que me está diciendo que eso no está en el historial, entonces probablemente esté equivocado.
Commissioner David, additional questions for Mr. Rains?
The counts of discrimination and the count of housing discrimination are separate, are they not? In other words, Worcester could be found responsible for the sexual harassment, but not housing discrimination, right?
Well, I believe the investigator found that housing was contingent on working in the wreath-making operation, regardless of whether you were an employee or an employee of a contractor. And when you were no longer doing that, housing ended.
Hold on, before we go any further, let's let it be interpreted.
Lo que quiero saber es que si la discriminación ocurrió a través del alojamiento y si el propietario es culpable no solo del acoso sexual, sino también de haber discriminado el alojamiento. Y la respuesta fue que son cosas distintas.
I believe it requires a finding of underlying protected status discrimination, even on the housing count.
No fue algo que hubiera causado discriminación del alojamiento hacia el empleo.
Commissioner David, additional questions?
No.
Commissioner Dusan?
Yes, I'd like to understand what exactly is not in the record? The offer of employment directly with the Worcester Wreath Company, or the comment that Worcester always needed employees?
Perhaps.
Sí, quisiera entender qué es lo que no se encuentra en el historial, la oferta de empleo o qué fue exactamente.
I believe what's not in the record is the question that Commissioner David was asking about whether that indicated that Worcester Wreath ultimately was liable or responsible for offering employment. That hypothetical, I think, question.
Oh, whether the offer somehow could be interpreted as an admission.
Correct, based on the events there, correct. And hold on, let's let that be interpreted.
Y lo que mencionó el señor David es que si estaba el miembro de la comisión, es que si había sido responsable por los hechos que habían ocurrido y resulta que no respecto a la mención.
And it is that hypothetical interpretation that is not in the record.
Es una interpretación hipotética, dicho, que no había estado en la historia.
Okay. In other words, the investigator didn't reach a conclusion on that hypothetical.
Correct.
Y en otras palabras, no hubo algo, no hubo una conclusión hipotética en el historial.
Thank you. Thank you.
Commissioner O'Brien.
No, thanks.
Okay. So I'll call one last time for Damien Mejia or Brianna Mejia Bouchard. I don't see any additional people on here, so I'm going to say they're not here.
Una vez más voy a llamar al señor Damiano, la señora Brianna Mejía. No veo a nadie nuevo aquí. ¿Es que hay alguien nuevo?
So now we've finished hearing from the parties and their lawyers, and we will turn to the investigator.
Good morning, Commissioners. I'm Alice Neal. I was one of the investigators.
Hold on, Alice.
Sorry.
Entonces, ya acabamos aquí con las partes y vamos, con los abogados, entonces vamos a escuchar al investigador. Hola, buenos días. Mi nombre es Alice Neal y soy una de las investigadoras.
Okay, thank you for introducing me. So I was the investigator on this case. I just want to clarify a couple of points.
Entonces, yo soy la investigadora que está trabajando para este caso. Quisiera dar dos puntos.
Complainant's response to the investigator's report indicated that they perceived they were working for the Worcester respondents, but the facts in the investigation don't bear that out.
The interpreter would like repetition, please.
What was that?
Can you repeat it, please?
Sure. Complainants perceived that they were working for the Worcester respondents, but the investigation and the facts developed during the investigation do not bear that out.
Thank you. Entonces, los demandantes argumentan haber estado trabajando para el demandado Worcester, pero la investigación no ha descartado eso.
So with this case, I just want to turn back to the primary concerns that we've been listening to, are the idea that Worcester Wreath is an integrated corporation with, or integrated enterprise with the Ms. Mejia Bouchard.
Y entonces vamos a discutir las primeras preocupaciones que hubo acerca de las personas Bouchard.
The test here is if there's an interrelation of operations, if there's common management, centralized control of labor relations, and common ownership.
Lo que indica la relación es que hubo operaciones en común y si tuvieron una relación como empleado-empleado.
And as the report indicated, and I still find no reason to change my recommendation, that certainly there is an interrelation of operations. However, none of those other factors are met.
Sí, como dicen que sí hubo una recomendación acerca de la operación, ninguno de estos factores se probó en el reporte.
As Attorney Raines already indicated, owner did say that he tried to steer away independent contractors or their employees from talking to him directly. The independent contractors set their own rate of pay, and that was not controlled by the Worcester Enterprises. And then also, the independent contractors picked the days and times that they wanted their shifts to be worked before the season started.
Y respecto a lo que mencionó el abogado, es que el propietario sí trataba de hablar independientemente con los empleados, independientemente del contratista, y que la compañía del contratista sí intentó hablar con.
And those are just a few of the facts that were part of the investigation on this point.
En este punto eran hechos que son parte de la investigación en este momento.
To the question of the hostile housing environment and sexual harassment, that wasn't reached or analyzed in this case because it is in the record that neither Ms. Rodriguez or her friend complained to any of the Worcester entities about the sexual harassment in the housing environment, so an investigation didn't happen.
Y lo que se menciona respecto a los hechos es que las entidades dicen que el señor Rodríguez no mencionó ninguna hostilidad en el alojamiento o acoso sexual, entonces estas investigaciones no existieron.
And again, once Ms. Rodriguez was no longer an employee of Ms. Mejia Bouchard, housing was contingent on employment, so she was no longer had a place to live.
Entonces, como se mencionó, el señor Rodríguez ya no trabajaba para el señor Mejía, entonces ya no tenía un lugar en donde.
So taking everything that we've heard today from the parties, again, I do not change my recommendations that I made. I still think that with respect to the complainant's submission, that there are no reasonable grounds to believe that Worcester Reef is an integrated enterprise or that there was any control over, that there was any liability or reason that their eviction should be any different than it was. And I'm happy to answer any questions you have.
Y estoy abierta a contestar cualquiera de las preguntas que ustedes tengan. Y respecto a lo que ya se hablaron de las partes, no voy a cambiar mi recomendación, que es que no hubo fundamentos suficientes para la demanda.
So, questions for the investigator, Commissioner Whitworth?
No, I don't have any questions, but Alice, I just have to tell you what a great job you did with that report. It was very confusing with a lot of moving pieces, and thank you. But no questions.
No tengo preguntas, nada más quiero mencionar el buen trabajo que realizaste en el reporte. No tengo preguntas.
Commissioner Ashby.
I agree with those sentiments, Alice, and your statements just now were very helpful for me, actually. I've been wrestling with this integrated operations test, but I think I feel more comfortable now. Thank you.
Commissioner David.
Lo que quiero decir es que estoy de acuerdo con las declaraciones que aquí se proporcionaron y me ayudaron bastante, entonces me hicieron sentir con más confianza. Miembro de la comisión.
Commissioner David.
I agree. It's very complicated, Alice, and you sorted it out for us. The only evidence that Worcester knew of the sexual harassment is through the housing coordinator and that turmoil of understanding that she was no longer an employee. Is that correct?
Entonces estoy de acuerdo con lo que dijiste y entonces la única evidencia que hubo acerca de la compañía Worcester que sabía del acoso sexual fue a través de la coordinadora del alojamiento, ¿es correcto?
That is correct, Commissioner David. The only thing that housing coordinator knew was what she was overhearing that day while she was there trying to arrange beds for the 40 incoming workers. There were no specific reports to Worcester about the rest of it.
Es correcto, no hubo reportes específicos acerca de esto en el pasado, nada más todo fue a través de la coordinadora del alojamiento.
I hear you saying that there were no specific reports other than that. It's hard for me to believe Worcester didn't know or should have known of the sexual harassment, but I hear your conclusion.
Is there a question, Commissioner David?
No.
Entiendo que no había un reporte específico, pero no me cuadra que el señor Busser no haya estado no haya sabido acerca del problema.
Commissioner Tucson.
I'm still deliberating where I am on this, but I don't have any questions.
Thank you. Commissioner O'Brien, I'm still getting used to there being 5 of you.
Thank you. Ditto to the investigator, the comments about the investigator, because I was thinking it was me that was finding this so complicated. So that's all. That's no questions, just that comment. Thanks.
And I know Alice appreciates being recognized for what has been outstanding work on an extremely difficult case. So with that, we have heard from the investigator, and at this point, we will need many, many motions. Because there are many recommended findings, I think it might make sense, as painful as it is, to go one by one.
En este momento ya no tengo más comentarios, nada más igual quiero decir que fue definitivamente difícil y a reconocer a Alice en un caso tan difícil como este. Hay muchas mociones y va a haber muchas conclusiones, entonces vamos a ir uno por uno.
Someone's going to have to make one.
I'll make a motion in regards to Brianna Mahia Bouchard, and I think we can take all 4 of those together, that there are reasonable grounds to believe that there was discrimination on the basis of sex and hostile work environment, and that complaint should be conciliated, that there's reasonable grounds to believe that there was unlawful retaliation, and that should be conciliated. Number 3, that there's no reasonable grounds to believe that there was discrimination on the basis of sexual orientation or race, national origin, and no reasonable grounds to believe that there was discrimination on the basis of in housing on that basis. And that those last 2 should be dismissed.
I'll second.
Yo quisiera presentar una moción respecto a Brianna Mejía Bouchard y es que quiero decir que sí hay fundamentos suficientes para decir que hubo un ambiente de trabajo hostil y también hubo represalias ilegales acerca de la discriminación por medio del alojamiento, pero no hubo discriminación en cuanto al origen o la etnia de las personas.
So it's been moved and seconded. Is there any discussion from commissioners? If there's not, you can just vote.
Si no hay ningún argumento por medio de los miembros de la comisión, entonces podríamos votar.
If there's no discussion, all those commissioners in favor of the motion to adopt all 4 recommended decisions, raise your hand and say yes.
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 1, 2, 3, 4, 5. So it's, the vote is 5-0 to adopt all the recommended decisions regarding Brianna Mejia Bouchard.
Entonces, vamos a votar. Alcen su mano los que están de acuerdo. 5 personas están de acuerdo en adoptar las recomendaciones respecto a Brianna Mejia Bouchard.
Does someone want to make a motion regarding the recommended decisions for Damian Mejia?
¿A alguien le gustaría presentar una moción respecto a Damián Mejía?
Sure, I'll make the same type of motion in regards to respondent Damien to adopt all 3 recommendations, 5, 6, and 7. There were reasonable grounds to conclude that there was unlawful interference in regards to main human rights, protected rights. 6, that there's no reasonable grounds to believe that there was discrimination on the basis of sex or sexual orientation, race, national origin. There's no reasonable grounds to believe that there was discrimination in housing.
Is there a second?
I'll second.
Me gustaría presentar una moción muy similar respecto al señor Damián acerca de las 3 recomendaciones 5, 6 y 7 y hay fundamentos suficientes para demostrar que hubo una interferencia respecto a los derechos humanos en el estado de Maine y no hubo discriminación de origen sexual o por el origen de dónde eran las personas, nada más por medio del alojamiento.
So we are at the recommendations 8 through 10, and someone has to make a motion to do something.
We didn't vote on those.
We didn't vote.
What?
Amy, we didn't vote on the 5 to
Oh.
7.
Yep, sorry, I'm just moving on in my head. Okay, sorry. So the motion, I apologize, the motion is to adopt all 3 recommended decisions regarding respondent Damian Mejia. Has been seconded. Is there any discussion? Seeing none, all those in favor of that motion, raise your hand and say yes.
Yes.
4 or 5, it's 5-0. So those are adopted. So now I will make the snarky comment that someone needs to make a motion to do something about 8 through 10.
No votamos respecto a la situación, me disculpo. Entonces, todos están de acuerdo en adoptar las recomendaciones respecto a Damián Mejía. Sí, todos a favor y alguien va a tener que hacer otra opción.
See, Commissioner Doosan had her hand up, and also Commissioner Ashby is about to speak. So you two can duke it out.
I'll defer to Commissioner Ashby.
I was just deferring to you. I'll move, as did Ed. I will move as a group, all 3 findings that there are no reasonable grounds to believe that the respondent discriminated against complainant in employment on the basis of sex, sexual orientation, race, and that the complaint be dismissed, that there are no reasonable grounds to believe that the respondent discriminated against the complainant in housing on the basis of sex, sexual orientation, race, etc., and that the complaint be dismissed, and that there are no reasonable grounds to believe that the respondent unlawfully retaliated against complainant in violation of workplace protected activity and or the act, and that that portion of the complaint be dismissed in accordance with the act.
Jill, are you seconding?
I'll second, and then I have a amendment to the motion.
Hago vamos a movernos como un grupo y digo que no hay fundamentos suficientes respecto a la discriminación por orientación sexual y origen por alojamiento. Entonces, tampoco hay represalias y se va a descartar.
Is anyone else having trouble hearing some of the comments? And I messaged you, it's hard to hear, and I don't know if it's the connection or paper wrestling, but some of the interpretation is hard for us to hear. So I don't know if it's hard for Ms. Rodriguez to hear, but maybe you could repeat the last bit.
The interpretation?
Yeah.
Sure. Entonces vamos a seguir trabajando como grupo y lo que quiero decir es que no hay fundamentos suficientes respecto a discriminación por orientación sexual, origen o el alojamiento. Tampoco hubo por represalias, entonces se va a descartar.
Great. I don't know what you did different there, but it worked. So there's a motion that's been seconded, and Commissioner Dusan wanted to make an amendment.
Yes, I would like to move that we vote on number 8 separately, so that I may record, my votes are different on 8, 9, and 10. I would like to be able to record my vote on 8 separately from 9 and 10.
I can amend my motion. I'll simply move that we take them separately. I move, if that's okay, I'll move that there are no reasonable grounds to believe that the respondent discriminated against the complainant in employment on the basis of sex, sexual orientation, race, national origin, and or ancestry, and that part of the complaint should be dismissed in accordance with the act.
Y lo que dijo el miembro de la comisión Dawson es que quería hacer una modificación y tratar el número 8 separado del 9 y el 10. Entonces, si están de acuerdo en discutirlo, el miembro de la comisión Ashby dice que no hay fundamentos suficientes y que se va a descartar.
So
Thank you.
is
May I
there
second?
Just so I can check, Barbara, do we need anyone to withdraw the first motion, or was it okay to amend it in that way?
I think it's fine.
Thank you. May I speak to my request for a bifurcation?
Entonces se puede modificar esto si no hay ningún problema. Entonces me gustaría hablar acerca de la modificación.
On this particular matter, I am not convinced that the standard of that the complainant does not have at least an even chance of prevailing in a civil action has been met on the issue of integrated enterprise. And so I want to vote no.
Entonces,
on this item.
me gustaría votar no respecto a esto. En el estándar de las quejas no hubo una acción civil por parte de la compañía, entonces ese es mi voto.
Any other discussion among commissioners on number 8?
¿Algún otro miembro de la comisión quiere decir algo respecto al número 8?
Seeing none.
Well, I am very troubled also, as is Commissioner Dusan. It's just hard for me to conclude that Worcester didn't know or should not have known of the fairly dramatic allegations of assault there. I can see that they're not responsible for the housing, that's a clear contractual matter deferred to the employment contractor. I really am uncertain about this.
Can we pause for a sec for the interpreter?
Yeah.
Realmente no estoy seguro. Definitivamente es una situación muy difícil. No estoy seguro de que Worcester no sabía acerca de la situación dramática de las acusaciones. Entonces, no sé si sea responsable acerca del alojamiento o no.
I guess I'll weigh in on my motion. I hope we don't conflate the knew or should have known liability that comes with agency and the integrated enterprise test, which is a little different. I don't see, with all due respect to both my fellow commissioners, David and Dusan, I don't see evidence of the knew or should have known. We can speculate that it's a pretty big deal. I'm surprised they don't know, but the evidence is expressed that they didn't know, apart from the overhearing an argument that's a little unclear as to what happened. I made my motion based on my close reading of the integrated enterprise test. I'm going to push back a little gently against our investigator in that I do think that there is some tiny evidence beyond interrelation of operations. I see a little common management and a little centralized control of labor relations. The comment made by the respondent that if there's a problem with the contractors, they can come and see him. That reflects some level of management and control, but I don't think it's a four-prong test. I know that not all four prongs need to be met, but I don't see even shot of success based on the sort of nominal. Oh, I know this is long for the interpreter. I'm sorry.
It is long, and I don't want to interrupt anyone, but it's a lot.
No, you're right. I completely, I'm so sorry, both to the complainant and to the interpreter. I can break that down again. I can try again if you'd like.
I think I'm all set.
Yeah, let me start again.
Okay.
All right. I think that this is not liability based on an agency relationship.
No creo que haya habido una liabilidad respecto a la relación con la agencia.
I think that it is a closer call on the common enterprise legal standard.
Creo que tiene más que ver con el estándar legal acerca de la empresa.
I don't think that standard is met either, however, even if the standard is an equal shot.
No creo que el estándar se cumpla, incluso si es similar.
I did not hear evidence in the record establishing agency under the knew or should have known standard.
No escucho que la agencia haya sabido o haya escuchado acerca de esto.
And while I think the respondent's comment that employees could come to him if there was a problem with the contractor shows some level of control, it is not enough under the test.
Y creo que no es suficiente el nivel de control que hubo respecto al comentario que dijo el demandado.
That's all I'll say.
Y esto es todo.
Commissioner Dusan?
Yeah, I just want to be sure I am clear, though I don't want to repeat a long set of reasons.
No quiero repetir las mismas razones.
I do not propose an alternate interpretation or conclusion from the findings recommended, from the findings of the investigator.
No quiero proponer una interpretación alternativa a las conclusiones que encontró el investigador.
I am instead not convinced that the respondent would not, the complainant would not have at least an even chance of prevailing on this particular issue in the civil action.
No estoy convencida de que el demandante haya tenido una cosa que ver en la acción civil.
It's a matter of dispute. And I also really respect and appreciate the difficulty that the investigator went through to lay all this out.
Es una disputa y respeto totalmente que la investigadora haya trabajado en algo tan difícil como esto.
I just think the complainant should have full opportunity to proceed on this particular count of the
Creo
case.
que el demandante definitivamente tiene que seguir en esta parte del caso.
Any other discussion from commissioners on this motion? So the motion is to find no reasonable grounds to believe that Worcester Reith, Worcester Resources, or Worcester Holdings discriminated against the complainant in employment. All those commissioners in favor of the motion, raise your hand and say yes.
Yes.
1, 2, 3. I see 3 in favor. All those commissioners opposed, raise your hand and say no.
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 So it's 3-2, and that motion does prevail. So the finding there is no reasonable grounds.
I'll move that there are no reasonable grounds to believe that the respondent discriminated against the complainant in housing on the basis of sex, sexual orientation, race, national origin, and/or ancestry, and that portion of the complaint be dismissed in accordance with the act.
Second.
Entonces, la moción que se hace es que no hubo ninguna discriminación respecto a orientación sexual, alojamiento, y 3 votaron a favor, 2 en contra.
Is there any discussion among commissioners? Commissioner Doosan?
I intend to vote yes on this, but I remain troubled by just the final set of facts that the parties argued about this behavior in front of the housing manager, and the housing manager and the position of the respondent is that they were nonetheless not aware, because the argument took place in Spanish and the housing manager did not understand enough Spanish to have gleaned what was going on. But I think that this recommendation is correct, and I intend to vote yes.
Y en este momento quisiera votar que sí, aunque me causa un poco de conflicto el hecho de que la coordinadora del alojamiento no haya estado enterado de lo que pasó, ya que la discusión sucedió en español, pero bueno, voy a votar que sí en esta recomendación.
Any other discussion from commissioners? Seeing none, all those commissioners in favor of finding no reasonable grounds to believe that the Worcester Reith respondents discriminated against Ms. Rodriguez in housing, raise your hand and say yes.
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 So that vote is 5-0, and the finding is no reasonable grounds.
I'll move that there are no reasonable grounds to believe that the respondent unlawfully retaliated against the complainant in violation of workplace protected activity under the act, and that that portion of the complaint be dismissed in accordance with the act.
Second.
No hay fundamentos suficientes para determinar que hubo discriminación por parte del alojamiento y votaron 5-0.
So is there any discussion among commissioners on this proposed finding? Seeing none, so the motion is to find no reasonable grounds to believe the Worcester Reith respondents retaliated against Ms. Rodriguez. All those commissioners in favor of that finding, raise your hand and say yes.
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 1, 2, 3, 4, 5. So that finding is also no reasonable grounds. So the findings, there's a few reasonable grounds against the Ms. Mejia Bouchard and Mr. Bouchard, and otherwise no reasonable grounds. The commission will send a letter to the parties and their attorneys setting out the findings and the next steps. And now we have a hearing that is extremely similar, same facts, same fact pattern, involving the same parties. So just purely given the amount of time that this takes, I would encourage folks, when possible, to be brief. Don't want to deprive anyone of their opportunity to be heard. So I just thought I would make that surely useful point. So this is H/E 190255 A and B, Richard Rivera versus the same respondents. And the submission is by Mr. Rivera, and I believe it is Mr. Mancuso again.
Yes, thank you. My arguments on this in this regard are substantially identical to those with regard to the Waleska case. I believe the integrated enterprise that there is sufficient evidence to at very least explore this further. I don't think in terms of the specific facts with regards to how Mr. Rivera was treated as opposed to Ms. Rodriguez, that there is much more to discuss beyond that. Outside of just that, I would like to reiterate that by her own testimony in the IRC, the housing coordinator for the Worcester respondent, I'm sorry, I'm going too fast.
Me gustaría mencionar que mis argumentos son muy similares al caso de Waleska, al caso anterior, y es que sí hubo evidencia de acerca de lo que pasó. Y disculpen que vaya muy rápido.
But I just wanted to reiterate that by her own testimony, the housing coordinator for the Worcester respondents understood that Ms. Rodriguez was accosted. She heard that in English. So while she may not know every fine detail of what happened, she was aware that there was an attack. That's all I
nada
have.
más quiero, lo único que quiero mencionar es que el coordinador del alojamiento sí estuvo enterado de que hubo un asalto.
Anything else, Mr. Mancuso?
Just one more thing, that in terms of whether Waleska and Richard were supposed to have reported this to someone at the Worcester respondents in advance of the assault, so they were aware of it. By the complainant's testimony, the housing coordinator wasn't around often. They never met her before the actual fire. So I'm just at a loss as to who they were supposed to go to and where they were supposed to go to living in Worcester respondents housing to report this, when in fact their only point of contact with regards to the housing, even though it was provided by the Worcester respondents, was Ms. Mejia Bouchard.
Entonces, respecto al asalto, es a quién se dirigían ellos respecto a dirigir sus problemas, si había sido alguien más que habían contratado o realmente a quién iban y se dirigían para decirles todo esto.
Thank you.
Okay, questions from commissioners for Mr. Mancuso. Commissioner Whitworth, where'd you go? There you are. Okay.
No questions, thank you.
Commissioner Ashby,
No questions, thank you.
Commissioner David?
No.
Commissioner Dusan?
No questions.
Commissioner O'Brien. Okay, so we will return to you, Mr. Mancuso, after we hear from respondent.
Entonces vamos a regresar con usted, señor Mancuso, después de que escuchemos lo que tiene que decir el demandado.
Mr. Rains. Nope, you're muted.
Thank you. Can you hear me?
Yes.
As counsel Mancuso stated.
Wait, hold on. Where'd our interpreter just go? I don't see her on here. She just disappeared. Un momento. That's about the extent of my Spanish. So let's wait a minute. For those who have just joined us, we have momentarily lost our interpreter. And we're going to wait a minute. To see if she rejoins us. Thank you, Alice, for contacting the interpreter to ask her to come back.
If the interpreter doesn't come back, I'm happy to go through the rest of the recording with the complainants at a later time, so we don't have to completely derail this.
Okay.
I had planned on anyway. It's just the interpretation made it easier.
Right, right. Let's wait just a second more. Are you able to contact your clients directly to let them know that they will have an opportunity to sit with you and go through it? All right, while we're waiting, let's continue with Mr. Rains's presentation, and then hopefully we will have Sylvia back.
Thank you. As Councilman Mancuso noted, the cases are substantially identical. I'm not going to belabor them either. The housing coordinator did not know what was going on. I think that was clear to the investigator during the Issues and Resolution Conference. And she certainly didn't discriminate against complainants on any protected basis. In terms of the case law cited by Attorney Mancuso in his submission, the Roy case is distinguishable. In that case, the third party in that case had actually engaged in the harassing behavior. So that's really not an applicable case to the situation.
Okay, if folks could pause. We did get Sylvia back.
I'm sorry, I lost my connection.
That's okay. If it's okay, we're just going to keep going. And Mr. Mancuso said he can go ahead and go over that one piece that you weren't here for with his clients. So, Mr. Rains, I don't remember now if you had finished what you were saying or. Yes, okay. So questions for Mr. Rains, Commissioner Whitworth.
No questions, thank you.
Commissioner Ashby.
None, thank you.
Commissioner David.
Nope.
Commissioner Doosan.
No.
Commissioner O'Brien.
No.
Okay. So I've already forgotten where we are. So Mr. Mancuso, back to you. Did you have anything to add?
No, nothing further.
Okay. So commissioners, any follow-up questions for Mr. Mancuso? Seeing nothing. Okay, so then we go back to the investigator to see if she has anything to add. And let's let the interpreter just catch Mr. Rivera up.
Entonces, no hay más miembros de la comisión que tengan más preguntas. Vamos a proceder con las investigaciones del señor Rivera.
Alice.
And Executive Director Sneerson, did we need to hear from Attorney Raines again if he had anything to add before me?
Mr. Raines, did you have something else to add?
Do not.
Okay. Sorry if I cut you out there.
So thank you, commissioners. Again, I was still the investigator on this case. Also, my recommendations remain as they are after hearing from the parties. I did just want to highlight a couple of things. Is that when Attorney Mancuso was talking about how the housing coordinator overheard about the attack, he attributed that to complainant. My understanding from the record is that the hair pulling incident was actually a different employee, not complainant. And when
hold on.
Hola, soy Alice y también soy investigadora en este caso. Respecto al coordinador del alojamiento que escuchó que había un ataque, declaró que había sido un empleado diferente.
And then just another thing to highlight is that Attorney Mancuso mentioned that the housing coordinator was not ever really around. During the IRC, the question came up about who independent contractors' employees could report concerns to if they had questions or concerns while in their housing. And it was said that they could go to the security guards who were on site.
Y respecto a la pregunta que habían dicho acerca del coordinador del alojamiento, si no estaba en la casa, a quienes iban a darle quejas, y esto es a las personas de seguridad que se encontraban en la casa.
And if I said anything that was duplicative to Attorney Raines' presentation, I apologize. I was trying to interact with Sylvia during that time to get her back, so I didn't hear what he said. And that's all I had to add at this point, and I'm happy to answer any questions.
Y me disculpo que me perdí acerca de lo que había dicho el señor Raines porque estaba tratando de contactar a la intérprete Silvia, pero estoy abierta para cualquier pregunta que tenga.
Questions for the investigator, Commissioner Whitworth? No? Commissioner Ashby? Okay, Commissioner David?
Alice, looking at the proposed findings and trying to make this parallel in my mind with the prior case, doesn't 5 include as one finding housing and employment, and weren't those 2 different findings that we voted differently on in the Rodriguez case?
They were different findings. Sorry, I'll let the interpreter go.
Respecto a las conclusiones que hubo, siento que hay algo paralelo con el caso anterior, con el caso de Rodrigo respecto a las conclusiones del empleo.
So the question is, why are they collapsed in this case but separate in the other?
Sure. So the difference in this case is that in the prior case, there were also concerns about sexual orientation and sex. And here it was clear from the beginning that there were no protected class status discrimination or retaliation based on those protected class statuses. So instead of doing them individually, I just lumped them together.
Okay, thank you. Yeah, that's helpful.
Entonces la respuesta a por qué es diferente, por qué colapsó en el caso anterior y no en este, es que no hubo discriminación sexual o de sexo y el estatus había sido diferente.
Commissioner Dusan, questions for the investigator?
Appreciate Commissioner David's question. I am trying to go back to the prior case and line up the findings, and that's just taking me a moment. So I don't have a question, but I've gone back into the other. Thank you.
Commissioner O'Brien, questions for the investigator? No. Okay. Thank you, Alice. Great job on these cases. Now we would turn to commissioners to make a motion or motions.
Vamos a regresar ahora con Alice para hacer la moción y quiero decir que hizo un gran trabajo en esta investigación.
Well, I'll move to take them all together, 1 through 5. Reasonable grounds appear that there was unlawful interference in employment, reasonable grounds to find that there was retaliation. 3 is no reasonable grounds to believe that Worcester, 3, 4, and 5 are no reasonable grounds that Worcester Reef was involved in those illegal acts, and those parts of the complaint should be dismissed. The first 2 should be referred to conciliation in accordance with the act.
I'd second that.
So the motion is to adopt all the recommended filings, and it's been seconded. Is there discussion? Commissioner Dusan.
Creo que hay fundamentos suficientes para decir que hubo interferencia legal y represalias. Creo que para la 1 y la 2 tiene que haber una conciliación respecto a la ley.
Never mind.
What? I'm sorry, I didn't hear you.
I'm puzzling with whether I wish to move that we separate recommendation number 5, separating the issue of housing and employment. But the basis statement, yeah, I'm fine. I'm not going to make that motion.
I appreciate your struggle, Joe. It's a close call, but I'm deferring to Alice on this.
No voy a hacer una moción respecto a hacer la diferenciación entre el empleo y el alojamiento. Me está costando trabajo y apoyo tu moción de que cuán difícil es.
Any other discussion from commissioners? Okay, so
there was a second. Deb seconded, I guess.
Julie seconded.
Julie did. Thank you.
So the motion is to adopt all 5 recommended decisions. All those commissioners in favor, please raise your hand and say yes.
Yes.
So it's 5-0. All 5 recommended decisions have been adopted. And the commission will follow up with the parties and council about the next steps. We appreciate everyone's patience with the process here and participation. And I think we are going to try to get through one more case before we maybe take a brief break and head into the afternoon session with probably one of the morning cases. Apologies to Ms. Tozier and Ms. Lorenzati, because that may be the one case that gets bumped back a bit. Deb, do you want to call the next case?
Yes. So now we will hear case E19-0239. Sozanne Elaskawi v. American Roots. And Commissioner Dusan has recused herself from this hearing. So seeing that this is a no reasonable grounds case, is there anybody here for the complainant?
And I believe Ms. Elaskawi is here, and her husband is interpreting for her at her request. And since I have failed to say his name properly, it is Abu, is what you have suggested.
Yeah.
Okay, so you'll have 10 minutes. Oh, now you moved. There you are. And I will again stop the clock for any interpreting, but you'll have 10 minutes to make your presentation, Miss Elsa Lakawi. And many apologies for my terrible pronunciation.
It's okay. No, you did good job. Shall I start or shall we start?
Yes.
Okay. So actually, Suzanne prepared some notes for these presentations. So what I will do, at the beginning, more or less, I will read what she prepared for this presentation. And please also, when I say I, it means Suzanne. Okay, so first, with all my respect, I completely disagree with the investigator report and its conclusion. It is very clear that America Roots fired me because I was physically unable to use 2 of their machines, and they are not telling the truth when they deny it. So they are completely in one of the documents in the file. They stated clearly, and this document clearly stated that they refused to make reasonable accommodations for my disability or medical conditions. They also clearly stated that I must be able to work in all machines to continue working in the America Roots. And during my last meeting with the America Roots owner or the respondent, and after I brought all doctor notes that they are requested in April 2019, they told me that I shouldn't come back to their company after that day anymore, and they will send me their final decision through the union representative. And on Wednesday, April 24, 2019, the America Roots wrote or sent their final decision to the union representative, stated that more or less Suzanne needs to be able to work in a full capacity at America Roots and be able to execute her duties as an America Roots stitcher, working with all machines. And some details on April 11, 2019, I brought a doctor notes from my doctor to the America Roots. It says, for medical reason, please excuse Suzanne El Salakawi from work activity or exercises that cause worsening of the lower back pain and the sciatica. And on April 19, 2019, at about 7:35 a.m., the America Roots sent an email message to the union representative. In this email message, they wrote, per multiple discussion with you both, we are requesting the following from Suzanne in order for her to work. 1 full list from physicians of what she is able to do. Full list from physician of what she cannot do. Then the union representative sent me this email message, and then I was able to meet with my doctor on April 19 at about 8:45 a.m. And I brought another notes from my doctor with the list of what I can do and with I cannot do. And then I took this doctor note to the American Roots in the same day. Then on April 24, 2019, the American Roots sent the following, or sent an email message to the union representative. In this email message, the American Roots stated clearly that to continue working in their company, I must be able to work with all machines. And they refused to accommodate me or to have any accommodation for my disability. And part of their message to the union representative, it says, Suzanne needs to be able to work in a full capacity at American Roots and be able to execute her duties as an American Roots teacher, working with all machines and duties as defined. And on April 26 and May 6, 2019, my attorney at that time sent a letter or sent letters to both American Roots and the union representative about if they will accommodate me so I can back to work or not. They never respond to my attorney at that time. In addition, the American Roots company and some of their workers used to create a hostile work environment for me all the time. I never did anything against the policies and or procedures. On the other hand, all what the American Roots company and some of their workers did against me violated the policies and procedures. Every time they fabricated stories against me, and I was able to prove to the union representative that these stories against me are false and fabricated. The union always went against American Roots company decision. I never accept any of these false and fabricated stories against me. I only signed some of their warning to me only to acknowledge that I received a copy of this warning. I completely denied everything stated in this warning. On May 3rd, 2018, my attorney at that time wrote to the American Roots company and CC the union representative, requesting them to write and advise him as to what I have done that could be considered like hostile, creating a hostile work environment, interrupting production, and etc. They never respond to his request. And all these documents are in the file. Also something related to vacation time. I worked for the American Roots company about 4 years. I did not take neither vacation time nor sick time over these 4 years. After I was fired, they refused to pay me for my vacation time. On the other hand, they regularly paid the vacation times for all other employees. So in my opinion, if this is not a discrimination against me, what else could be? Again, on May 22nd, 2019, my attorney at that time wrote to them regarding this vacation time, but they never respond to him. also in their termination letter, they stated the following: after review of your current circumstances, the circumstances at that time was my disability, and after I brought all doctor notes to them, this is what they said in the first statement in their termination letter. There are no positions available at American Roots per the work requirements of our USCW.
So, Ms. Abu, if I could ask you to pause for a minute, that's a little over 10 minutes.
Okay.
And if you were interpreting for Ms. Al-Salakawi, I would be giving you more time, but you were reading her statement.
Sure.
So that would be the time that you have available to you.
Okay. I think we are good.
Okay, so let me see if the commissioners have questions for Ms. Al-Salakawi. Commissioner Whitworth.
No questions.
Commissioner Ashby.
No, thank you.
Commissioner David.
No.
Commissioner, where'd you go? Oh, Commissioner O'Brien.
No, thank you.
Okay. So
Dussault.
She is recused in this case.
Oh, thank you. Thank you. Bye.
So I'm going to ask you, because that's the end of your time, I'm going to mute you, Ms. Al-Salakawi, and then we're going to turn to the respondent for their time. Oh, you muted yourself. Thank you. Okay, so now we turn to the respondent. Is there someone here for American Roots? Mr. Cloutier, I think that's you.
Yes.
Okay.
Thank you. Good morning.
Oh, I'm sorry. I apologize. Abu, are you going to be interpreting for Ms. Al-Salakawi during this? Nope, you need to unmute.
Yes, I do. I will.
You're going to be interpreting. So, Mr. Cloutier, I'm going to ask you to pause every now and again so that Abu can interpret for Ms. Al-Salakawi, okay?
Sure, glad to do that. Good morning to everyone. Thank you for hearing us. With me on the call this morning, the way I see it on my screen is Whitney Waxman twice, but it's actually Whitney Waxman and Benjamin Waxman, who are the two, they comprise the majority shareholders of American Rootswear, Inc., and are also the senior executives. They are, I don't think we have, we certainly are aware of the rule that says we shouldn't be introducing what we imagine to be new and important evidence. We're not going to do anything like that. We have carefully reviewed the investigative report, which is quite detailed, I'm sure you noticed, and covers a several-year employment situation that included kind of repeated instances where there was a question of employee compliance and insubordination. At one point, the employee was discharged for insubordination.
Mr. Cloutier, could I ask you to pause for the interpreting?
Mm-hmm.
Okay.
Then this is a 100% union shop, and at that point, the union and Ms. Isarakari filed a grievance, and that grievance was sustained in the sense that at least it was mediated or agreed through a negotiation, and that the documentation requirements were not followed properly under the contract, which those requirements had never been triggered before. And so the management then negotiated a discipline short of dismissal with an agreed statement, which the employee signed, indicating she did not agree with it. She never has.
Could you pause for a second?
Sure.
لا لحظه ما تتكلميش، انا بترجم لك انت. فاليونيون تدخل و كون اليونيون ما وفقش معاهم يعني، فده مش معناه ان هم اللي غلطانين. واخد بالك انت زي كده.
انا غلطت لك انا شيء.
Okay.
She did not agree with it, I mentioned, but that this was a final warning, and she was reinstated on that basis. Fast forward to the spring of 2019, and the employee had documented fully a back injury of some kind, which appeared to have grown more serious, and by 2019 was providing doctors notes of various kinds. They're in the record, and they're kind of brief, and they're not overly specific, except there was one at least that said she can't use this machine, she can't use that machine. Two different machines that were in. Well, one of them was a serger, which is an actual machine that is used in the shop, but which was not at that time and had not been for some time her responsibility as part of the team she was on.
Could you pause for a minute?
Sure.
Pause for a minute.
بيقول لك يعني يا سوزان، هو انت في 2000 كنت انت يعني حصل لك انجرد وبعدين تعبتي، وبعدين 2019 جبت دكتور نوتس يعني بتقول انك ما تشتغليش على 2 من الماشين، من ضمنهم السيرجر ماشين. والسيرجر ماشين دي بتعتبر المكنه الرئيسيه في الشغل عندهم يعني، وبرغم ذلك ما كنتش يعني ايه، ما كانتش بارت ريسبونسابيلتي يعني، ما كانتش ايه انت مجبر تشتغل عليه. واخد بالك انت ازاي؟ فطبعا بس ده اللي تقريبا اول لحد دلوقتي يعني. ماشي اوكي.
So the other machine was a reference to a machine that doesn't exist, but there's a couple of machines with similar names, and as far as the management was concerned, her responsibilities didn't include using those either, and it referred to a position that she should not take in her work schedule, and again the management believed that she should never be taking that position anyway. So I'll pause there.
بيقول لك يعني ان التو ماشينز يعني فيه ماشين منهم ما كانش تقريبا شبه موجوده. اي ماشين ما كانتش موجوده خالص، ولكن في 2 ماشين تقريبا
لا موجوده
يعني هم شبيهين بيها يعني، او سيميلر نيم حاجه زي كده يعني. اوكي.
As a result, the employer in the spring of 19 was needed to staff up at certain levels, and so they contacted her. She was out at least on a part-time basis, and may have been completely out, and said they needed to discuss and needed to have her meet with them to discuss what her limitations and accommodations needed to be, and scheduled a meeting. And she objected to attending a meeting with one of the union designated representatives. She wanted a different representative who was busy in northern Maine and had indicated he could not attend. So I'll pause there.
بيقول لك يعني ان في 2019 هو طبعا بيقول له كنت بارت تايم ساعتها، طبعا ده غلط مش صحيح. الحاجه الثانيه بيقول في الميتنج انت رفضت تقابليهم عشان يعني الكلام اللي هم بيقولوا عشان يعني يناقشوا معاكي يعني ايه اللي ممكن يتعمل، واخده بالك انت ازاي، وانت ما رحتش الميتنج يعني.
ما رحتش علشان انا عارفه
ايوه
الدسكشن
هنقول
بتاعهم.
هنطلبه منهم. لا هنطلبه. اوكي.
And the meeting was convened and she did not appear. And then a second meeting was scheduled for the next day. And again, she declined to attend. And as a result of that, she was discharged for insubordination. She accurately points out that her lawyer at times proposed that he participate in these meetings and the employer did not respond. This was consistent with the employer's understanding that her representation selection by the union of a union representative was a matter only for the union and was not something that could affect.
Can we pause for a minute?
Sure.
بيقول لك يعني ان انت بيتكلم عن الميتنج تاني برضه، انت ما رحتش الميتنج، وفي الوقت ده انت طلبتي تروحي مع المحامي بتاعك. واخده بالك انت ازاي؟
عشان هو
وانت ما هم كانوا متوقعين انك هتروحي الميتنج وما رحتيش. يعني بيتكلم على ان الميتنج وانت المفروض كنت رحتي وما رحتيش، وطلبت تروح مع المحامي بتاعك وكده يعني.
لا طلبت اروح الاول مع البريزنتر مايك.
اوكي.
So our point of view is that this was covered in more than adequate detail by the investigation. The company was aware of the issue of her being an Egyptian and a Sunni Muslim and an issue at the plant that she raised at one point with the company. At that, within no time, no appreciable time at all, the company management organized a company-wide meeting. At that meeting, her understanding was expressed, and the management made it abundantly clear that under no circumstances would any ethnic or religious discrimination be allowed or tolerated. Yeah.
We've got to make space for the interpreting.
Sure.
بيقول لك يعني ان انت مره عملت كليم يعني ان هم في ديسكريميشن اجينست يعني من المسلمين الشيعة يعني. واخد بالك انت ازاي؟ والكمباني زي اللي هم كانوا كاتبين في الورق يعني عملوا ميتنج كبيره واتكلموا عن الموضوع ده. واخد بالك انت
ورفضني انا وطلعوا
ماشي، ما هنكلموه.
رفضني انا 3 أسابيع وعشان كده جبت لهم اليوني.
طيب ماشي. اوكي.
The investigator did, and it's in the record, do a complete, what we think is a complete job of verifying that whole process and the understanding of other people involved by written questionnaires of, I think there was about 15 employees currently working at the time of the investigation for the company who had been working for the company at that time as well. And many of them are new Americans. So, they were able to get that perspective from them. That's really. So.
بيقول لك يعني هو كان في الوقت ده هو شغال حوالي 15 عامل يعني شغالين هنا. واخد بالك؟ وتقريبا كلك مش امريكاني يعني. واخد بالك انت ازاي؟ وان الانفستيجيتور يعني موضحه الكلام ده في الريبورت يعني. واخد بالك؟ على
ايه ده؟
على موضوع اللي هو ان في حد كان ديسكريميشن يعني عشان خاطر الديانه والكلام ده كله يعني. واخد بالك؟ اوكي.
So we would simply point to the fact that we had a record of accommodation. What it was that she needed accommodated at that time was unclear and seemed a little confused. These meetings were scheduled to clarify that. Her objections to the managers who she didn't want to meet with, and the union officials that she did not agree were in her interest. We're outside of the control of the company. She was dismissed after numerous warnings and a long history for insubordination. Had nothing to do with discrimination. That's all we have.
اقول لك يعني بيعيد تاني ويزيد ان هو انت يعني ما رحتيش الميتنج، واخده بالك انت ازاي، وما فيش ديسكريميشن، واخده بالك انت ازاي، وده كل اللي عنده.
طب انا رحت الميتنج.
لحظه بس،
انا طلبت زي ما
انا هكتب لها هقول لك
ان انا وصلت.
اوكي.
And as I mentioned, the management is on the line as well for any questions. We're glad to respond.
Okay. No, you cannot respond to any points. You've already used your time to complain it. There was a message asking if they could respond to some points, and you had 10 minutes to present, and that's all that each party gets. So questions for, okay. Yes, questions for Mr. Cloutier from commissioners. Commissioner Whitworth?
No questions, thank you.
Commissioner Ashby?
Thank you.
Commissioner David? Commissioner O'Brien?
All set, thanks.
Okay, so that's it from hearing from the parties and their counsel. At this point, we would have commissioners make a motion or motions.
We haven't heard from
Oh,
investigators.
you know what? Yep, we haven't heard from the investigator, as she just pointed out. Sorry, again, I'm getting ahead of myself. So many apologies to Jane and commissioners.
You sure you just forgot I was here because it's been a while?
I'm not quite myself. Yes. Investigator Jane O'Reilly.
My name's Jane O'Reilly. I was the investigator on this case. I don't actually have anything to add from the report or from the parties' presentations.
Questions for commissioners to the investigator. Commissioner Whitworth.
No questions. Thanks, Jane.
Commissioner Ashby.
No, thank you.
Commissioner David.
Jane, there was some reference in their presentation about a pay issue, but nothing shows up in the report. Do you recall? Is there anything in the record about that?
I did make note of that. I don't recall it being in the record. Unfortunately, the record was quite large. It's possible it came up as a small issue, and I would say that if it, I was looking at my footnotes and my analysis of the discharge, it would certainly there was no other evidence in the record of a pay issue being related to discrimination or anything. So I don't recall that, but if it had been mentioned, it would not have been a discriminatory.
Thank you.
Commissioner O'Brien.
All set.
Okay. Now we can, thank you, Jane. Apologies for skipping you. Now we can move on to say we need a motion or motions from commissioners.
Well, I'll move to take both together, if that's okay, and uphold the recommendations of the investigator that there are no reasonable grounds to believe that American Roots discriminated against complainant on the basis of disability by denying a request for reasonable accommodation, and that there are no reasonable grounds to believe that respondent discriminated against complainant on the basis of disability, national origin, and/or race with respect to her discharge from employment, and the complaint should be dismissed.
Second.
And was that Commissioner Ashby?
It was.
Okay. So there's a motion to find no reasonable grounds on both counts, and it's been seconded. Is there any discussion? Seeing none. All those commissioners in favor of finding no reasonable grounds on both claims, raise your hand and say yes.
Yes.
I see 4. And no opposed, and Commissioner Dusson is recused. So the finding is no reasonable grounds on both claims. And to Ms. Elsalakawi and the respondent and your counsel, we will send a letter confirming the findings and outlining next steps available to the parties. And we thank you for your patience in being here and with our interpreting process. And we have one case left on the morning agenda, and we've got parties and council coming on for the afternoon agenda. Deb, what do you think we should do in terms of taking a break?
So how about if we take a 15-minute break? That will just put us 15 minutes behind and allow everybody to grab something quick to eat and rejuvenate themselves.
And
I let Amy know this morning, but didn't reach out to you. I need to leave now, so I will not be returning after the break.
thank you, Commissioner Ashby. I wasn't sure precisely when you had to go. Okay. So then we will have 4 commissioners hearing the remainder of the cases. And to the parties and counsel for the Foley versus Maine Medical Center case, we appreciate your understanding as we take a short break. I'm sorry, it's hard to predict exactly when we're gonna get to cases, especially with interpreters. So 15 minutes, Deb?
Yep, 12:15, we'll be back.
Okay, thank you, everyone.
Oops. So it's just 12:15 and I'm thinking that people are starting to come back. Grab my agenda here. But I only see 3 commissioners. So we need to wait at least for Commissioner David.
Yes. Thank you for everyone's patience, especially the folks waiting for this morning's case to be heard.
If it's okay, I'll be popping cherries into my mouth. Is that all right?
Absolutely.
Thanks.
We have all 4 commissioners who will be here for this afternoon. Do we have both the complainant and the respondent, Aaron Foley, and somebody here from Maine Medical Center?
Yep, and the investigator.
Okay, great. Oh, good. Okay, so this is a no reasonable grounds case. So let's hear from the complainant, Aaron Foley, or your representative first.
Great. Thanks, everyone. Good afternoon. My name is Allie Tozier, and I represent the complainant here. The investigator found a no reasonable grounds finding that discrimination and retaliation didn't occur here, and the complainant disagrees with those findings. The complainant is a CRNA, and she worked at Respondent from 2010 until her boss fired her on November 19th, 2018. There was no justification for him to fire her. She had a great track record and was a phenomenal leader in her field of anesthesiology. As a CRNA, she worked alongside anesthesiologists, and the structure of her department was such that she had a direct boss, we'll call him the chief of CRNAs, or the chief for short. And he had an assistant chief CRNA, who's also a person in the fact pattern here. And then there was the chief of anesthesiologists, who I'll refer to as the chief of anesthesiologists to make that distinction clear. Here, respondents' stated reason for complainant's termination is that she had a poor attitude and was insubordinate. But there are multiple reasons that provide reasonable grounds for why this stated reason is not valid. One of the reasons is her most recent evaluation before she was fired was from 2017. And that evaluation marked her as had been an overall rating of successfully achieves, versus 2 of the other ratings she could have gotten, which were lower than that, were partially achieves or requires development. Also, in the fall of 2017, she was spoken to by her boss, the chief, about how there were comments that she had a poor attitude, that anesthesiologists had said that she had a poor attitude. And she later spoke to two other CRNAs who were males. Of course, she's female. And they said that they had similar comments from anesthesiologists on their reports, but that when they met with the chief about it, he said it was no big deal. And this is the most important piece. I think the investigator asked multiple times for respondent to provide all of the evaluations of every CRNA from 2017. Now, all of them fall under the leadership of the chief, and the respondent was asked multiple times. Finally, the respondent did provide some evaluations for comparison purposes, and only provided 8. And there are 70 CRNAs at the time, so they only provided 8. So the investigator said that was a complete, that they had given all of them, and they hadn't. They only gave 8 out of 70. So they can't say that the investigator couldn't conclude that they knew the universe of the comparator evidence, because they only had 8 out of 70 to look at for comparator evidence. And then the other thing is that the events in the timeline have temporal proximity. You know, they're close in time. Her reporting activity is close in time to the adverse actions, and I'll go through them quickly. One of the adverse actions is that she was instructed to be taken off all of her committees, and the second one is that she was fired. So let's back up and talk about her committees. She was on 4 different committees, okay, and two of them required her to be at meetings during work hours, and 2 of them were after hours. So in early 2018, she had been requested to be on the bylaws committee. This was a big honor. She was there with another lawyer and a staff member and 10 doctors and the medical staff president, and their job was to update and rewrite the medical staff bylaws for the hospital. And actually her boss, the chief, congratulated her about this honor back in February of 2018. And he said, email the administrative assistant about when these meetings are happening, which, by the way, they met every other week at 7 a.m. And then the floor walker, the CRNA, will look at what's on your schedule and won't put you in an operating room for those times, because basically how it works is you have a schedule, and the day before you're put on in an operating room according to when you're available. And so she also was appointed to the Nurse Practice Council, or she had been since 2015. She told him about it as well, the chief, and he said, also tell the assistant about this, and then she'll put it on your calendar. So that happened, and she was scheduled accordingly, and it was fine. And then she reported that a doctor had harassed her and also had created an unsafe environment for a patient. She reported this to the chief of anesthesiologist, but then she also reported it to the assistant chief CRNA. And as she was talking about this very troubling event, her boss, the chief, walked in and said, "What did you do to provoke him? What did you do to provoke the doctor?" And so he knew that she had reported this and was working on trying to get that resolved. And basically the doctor eventually came up to her months later and gave a faux apology, like basically said he didn't want to apologize and it wasn't a big deal. And this really upset her. And so she didn't feel like it was handled well at all, even though she tried to follow up. Well, fast forward to just a few months later, and she went into a meeting with her boss, the chief, because she heard that all CRNAs were getting a raise. And he said, "I'm not going to give you your raise or tell you about your raise until you tell me what your problem is with me." And she said, "Well, I'm upset that how you didn't handle my report. You didn't investigate it. I felt completely ignored. I was treated horribly because, and she mentioned because of my gender. And she also said, you don't treat female CRNAs the same way that you treat male CRNAs. So she specifically called him out in that meeting. He responded by saying, "Well, I just heard recently that you were rude to," and he had gotten a complaint about her being rude in a particular event a few days before. And she said, "Oh, well, there was a patient safety issue. And I was raising my concern about how these new nurses who weren't oriented at all were the ones in charge. There wasn't anyone above them." And so she tried to explain herself and he dismissed her. She went on vacation, she came back, and then she felt like she needed to do a formal complaint of the safety issue that I just mentioned because he dismissed her. Well, the next thing that happened after that was in September 12th, her boss and the chief of anesthesiologists sat down and said, "You're forbidden from, you have to remove yourself from all of the committees right now. And also, we don't want you representing us." And also what her boss said to her was, "You can't go to medical appointments during work hours." She had a back injury from work, which is a separate issue, but she had a back injury and she sometimes had to go to medical appointments. And so what happened next, I'm going to just fast forward to the end, is that she called to talk to the health department to find out that she actually could take these medical appointments during work time. And he got in trouble, her boss, and for telling her that she couldn't do it, that she had to only take these appointments outside of work hours. Now, the investigator found that the respondent said the respondent represented that she should try to schedule them outside of work hours, but that is disputed. Complainant remembers him saying directly to her at the September 12th meeting, you cannot schedule them during work hours. And so she requested her personnel file, and 3 days later, her boss came in and fired her. And right before that happened, he had gotten a call and had gotten in trouble about, telling her she couldn't schedule work time. And so that is why there are definitely reasonable grounds to find that retaliation and discrimination occurred here. And I'll reserve the remainder of my time, Amy.
Yep, you bet. Questions for Ms. Tozier, Commissioner Whitworth?
No questions just yet.
Commissioner, I've lost track of myself. Commissioner, it's all confused because Commissioner Ashby's not here. Commissioner David.
Attorney Tozer, is there any allegation that the process was not followed, the progressive disciplinary process?
Yeah, there was no progressive disciplinary action here. But thank you for asking that, because there was, the respondent is trying to say that they gave her written warnings, but what happened was this was after that September 12th meeting, and they had met with her in August, which she thought was going to be in response to her patient safety concerns, but really it was them telling her that that they didn't like her attitude, and what she felt they were doing was she felt her boss was trying to scare her basically into shutting up and stop complaining. Because remember, he had just called her out in that meeting, and she had just called him out in that meeting in July, and so she felt like this was you need to be quiet and stop complaining. And so then what happened after the September 12th meeting was she was told she needed to come right away to a meeting. And she felt like she was going to be lambasted again and caught off guard, because that August meeting, she had no idea that she was going to be in trouble, and so she said, I don't want to go without representation. I want to represent myself. And then the woman who came to get her said, well, if you don't go right now, you're going to be fired. And so she went in and she was given a warning because they said that she didn't respond to the emails, that there was an email right after the September 12th saying, make sure that you give us the names of all of the committee chairs so that we can contact them directly. This was her boss. I want to contact them directly and kick you off. And she didn't respond right away. It's true. She was on vacation for 2 weeks, and she reached out herself to those committees and took herself off. And so her first warning was insubordination for that. And then the next day they called her in again and gave her a final written warning. And the reason for that one was for her insubordination for not going in right away the day before. I hope that makes sense. Sorry, it's a very fact-specific case.
Commissioner Doosan, questions for Ms. Tozier?
I don't have any questions, thank you.
Commissioner O'Brien?
I think so. I hope I'm directing these at the right person. I'm trying to understand the claim that it's a sex discrimination case. And so you mentioned I think it was seven or eight, not sure, or here, can't find it right now, evaluations. And is that the only basis? Is that the only thing what else are you basing that on?
So there's two sex discrimination components here. One is her original treatment by that doctor. She felt that doctor had treated only women, and she knows that other women, have been harassed by this particular doctor and not men. So women were finding it really hard to, being harassed by this doctor. So there was reporting activity about that. And her boss was a part of the reporting. He was in that process and should have investigated it. And she felt like he didn't, that he dropped the ball and he just ignored the fact that she felt harassed by this doctor because she was a woman. And then in the July in the July meeting with him, when he questioned her and said, why do you have a problem with me? She said, I don't feel like you protect female CRNAs here. And so that's the second component of it. And in terms of the 8 out of 70, the investigator concluded that they asked for the respondent to give all those evaluations and say if they're male or female. And, they didn't, she said, you don't have to name the CRNAs, but say if they're male or female. Well, respondent didn't do that. Like, you can decipher which one's male, which one's female if you read the notes and stuff, like in the individual 8 evaluations. But there were 70 out there. There were 70 CRNAs. And so that's not comparing evidence. But the investigator said that, and what we don't agree with is the investigator said, if you look at the universe of the evaluations, hers stands out, and her comments about her were worse than the guys. Well, there's only 2 men in that group of 8. But what she told me was that no, there were 70 CRNAs and only 8 were provided. And also, and what she said in her complaint was that she spoke to 2 male CRNAs right after getting in trouble from Bradstreet. By the way, that was a year before he fired her. So if her attitude was such a problem, why did he wait to fire her until a year later? So he talked to her and said, you're being called rude. And then the male CRNA said, well, I had this similar comments on mine, but I wasn't in trouble for it. They also thought that I was rude. So that's the sexual discrimination element of it. And of course we have the retaliation claim too.
Thank you. Thanks. That's it for now.
So at this point, we would turn to hearing from respondents. Ms. Lorenzati.
Good afternoon, Commissioners. I'm Nicole Lorenzati on behalf of Maine Medical Center. I'll just take the sex discrimination and disability real quick, as did the investigator in her report. On the sex discrimination piece, first of all, it's entirely allegations and no evidence. There's no evidence whatsoever to support that Dr. Kovarik who's not a Maine Medical Center employee, treats women any differently than he does men. There was no evidence brought forward whatsoever to the commission in support of that allegation. Separately, as the investigator noted in her report, that allegation was never made in connection to a report. So there was no report made to support a complaint that he treats me differently because I am a woman, versus a complaint made that he just treated her poorly on a day in question. That is why this sex discrimination complaint was sort of knocked out early. On the disability discrimination complaint, I think it's only based on that she was told allegedly that she couldn't go see a doctor on a day in question. In response to that, and in response to a numerous complaints, instead of allegations, I would just turn you to the documentation evidence. She was never ever told that she could not go see a doctor. That allegation is made, and it is just that it's an allegation. However, Maine Medical Center submitted documentation to show that that is just false. It is exhibit to, I believe it's exhibit 4 in response to the physician's statement. It's an exhibit on a November 6th. It's a reference to a doctor's appointment for November 8th, 2018, where she was allegedly being told, according to the complainant, that she couldn't go to an employee health visit on November 8th on a morning at 8:30 a.m. She claims that she was told by John Bradstreet, the chief,
no names.
Sorry, told by the chief that she could not go to a doctor's appointment at employee health that morning at 8:30. If you draw your attention to, there is an email from actually the chief to the complainant on November 6th, 2 days earlier, specifically saying to her, hi, complainant, per our conversation this afternoon, and at the request of employee health, you are accommodated to attend the appointment scheduled for you on November 8th at 8:30 a.m. And I have noted this appointment in Q agenda. Let me know if you have any questions. He specifically told her to go to that appointment 2 days earlier. So not only did he deny it, but he specifically sent her an email saying, please go. She did not go, and she leading to her termination, suggested to folks that he told her she could not go, which was in fact not truthful. Therefore, the disability discrimination complaint does not stand. In response to the remainder of the complaint, which is based on retaliation claims, and I'll sort of jump to sort of the opening to Ms. Tolger's presentation, to suggest that she was a phenomenal leader in anesthesiology is, I don't understand it. The evidence that was submitted to the commission, again, in contravention to the allegations made, shows that it's just not the case. We did produce substantial evidence in 2017 in her evaluation, which was her most recent evaluations because she was let go before the 2018 evaluations, were just overwhelming in terms of the feedback that came back from all of her peers, which includes all of her CRNA coworkers and anesthesiology coworkers. So it's basically her coworker force that submits feedback that is used then by her chief to support her evaluations. It's overwhelmingly negative, and you could turn to it. It's Exhibit 1 to the physician's, Exhibit 1 and 2 to the position statement. If you walk through it, where the feedback is just overwhelming in terms of not her patient care skills, but in terms of her negativity and toxicity in the workplace. The comments are, I found complainant to be one of the hardest CRNAs to professionally interact with throughout the course of an anesthetic. This appears to be the worst when she's assigned in this particular department. She tries to impress that her plan is the only plan. She's good to interact with when she's in a good mood. When she's not, she's passive aggressive, grumpy, does not communicate, very difficult, abrasive, obstructive, does not understand. We agree to work in a care team model. Perhaps she should work in a different place. It is replete. Her evaluation is replete if you read through it with comments just like that. She's extremely difficult, demeaning, dismissive to work with, and these are her coworkers. So it is not her chief, it is her coworkers that she works with every single day. Prior to any complaints that she brought forward, and there were only two, actually it was just one. Prior to any complaints that she brought forward, she was removed. She was the assistant chief in the anesthesia department. She was the assistant chief. She was removed from that position. She was a floor walker, which means she was responsible for assigning other CRNAs around the CRNA department. She's the only floor walker in the history of Maine Medical Center, to my understanding, to ever be removed from that role. And she was removed prior to any complaints that she brought forward because she was so toxic in her behavior in the workplace. Again, that's before any complaints that she brought forward in 2018. Fast forward to 2018, her demeanor in the workplace didn't change. It never changed. It got worse. And that is why it led to corrective action in 2018 and ultimately her termination. After she was removed from being assistant chief, after she was removed from being a floor walker, her demeanor continued. On July 5th, which is the meeting to which Ms. Tozier refers to when she talks about, she suggests that the complainant brought forward complaints about safety, about coworkers in that meeting, or suggests that she brought forward concerns. That's not what happened. The chief, and this is Exhibit 1 to the position statement, the chief actually sought out to meet with complainant on that day on his own, because again, two coworkers brought forward a complaint about the complainant that day, about what the complainant did in the workplace that day. So it's an Exhibit 1. The complaint came forward to the chief. Dear chief, my staff today have reported significant difficulty regarding one of your staff members, complainant. Her initial remarks were disparaging regarding staff in the room due to a difficult day staffing our OR rooms. There was an out of cluster RN circulating in the procedure. Complainant spoke at length regarding her dissatisfaction with the staffing. She continued to be disparaging, not mollified in the least, when the staff's competence was explained. So complainant had an issue, I guess, with what she thought was an incompetent nurse, and she was reassured of the competence that the nursing was okay, but complainant wouldn't have it. Throughout the briefing, there was issues. The complainant was reassured it was okay, but she didn't have it. Staff felt uncomfortable and disrespected. Coworkers complained to the chief. Chief then, on July 5th, sat down with complainant. He recaps the meeting. I met with complainant about these events. She turned it into a complaining session about my leadership. I mentioned that I don't support CRNAs. I didn't have tech work done. I talk about people in the office that we hire substandard CRNAs. When I asked for specifics, she was unable to bring anything forward other than you always side with the doctors. There's nothing in this note that suggests she brought anything forward about sexism, anything forward about patient safety, anything forward supporting her retaliation claims whatsoever. She was agitated during the meeting, red in the face, continued to ask about a compensation sheet, and he says, let me redirect you to why we're meeting. She then says, why do I continue to get these comments about me? He says, well, the issues come forward about you. And she walked out of the meeting and said, I guess the conversation is over, and walked out. Concerns continued to be raised about her. She continued to be found off-site. She was missing her shift. She continued to disappear off her shift. She continued to go to meetings. He, in turn, as the record shows, he asked her, the chief asked her, what meetings are you going to? You are no longer assistant chief. You are no longer floor walker. You are not to represent the anesthesia department anymore at meetings. Please stop going to meetings on our behalf. Please tell me what meetings you're going to, what the chair of those meetings are, so that I can meet with them and assign somebody else from our department to go to those meetings. She wouldn't respond. The record and the documentation shows you on September 12th, he sat down with her and directed her to please stop going to meetings and to give him a list of the meetings she was going to and the names of the chairs and the times of the meetings. She didn't comply. She says she went away on the 2-week vacation, but she was in the medical center meeting with other people during that time. On September 19th, he sent a follow-up meeting request saying, please give me the info. She didn't comply. October 2nd, he sent another email. Please give me the information. She didn't comply. October 4th, she sent him an email. It's in the materials. She says, I reached out to the chairs. Don't worry about it.
Ms.
That's not what he asked.
Ms. Lorenzati, that's your time.
Thank you.
Questions for Ms. Lorenzati? Commissioner Whitworth?
No questions, thank you.
Commissioner David?
No.
Commissioner Dusan?
I have no questions.
Commissioner O'Brien?
All set.
Okay. Thank you. Sorry to cut you off.
Right.
Ms. Dozier, you have about 30 seconds left.
Okay, so there is a dispute of material fact about what happened on July 5th. Complainant's position is that she went to seek him out and it was about a raise that she had expected to get, and that conversation went completely differently than what you just heard, and that she did call him out for his behavior right then. And there's a lot to respond to. I don't have the time to do all of it, but I think the fact that there were 60 or more evaluations that were not provided that would have showed comparator evidence for this behavior. Oh, sorry. Okay, thanks.
Questions, follow up for Ms. Tozier, Commissioner Whitworth?
No, no questions.
Commissioner David? No. Commissioner Dusan?
No questions.
Commissioner O'Brien?
All set.
Okay. Sorry to cut both counsel off. So at this point, we would turn to the investigator, to Jane.
Good afternoon, Commissioners. My name is Jane Riley. I was the investigator on this case. I think the arguments and factual disputes have been summarized well by the counsel for the parties, so I don't have anything to add. I'm happy to answer any questions.
Questions for the investigator, Commissioner Whitworth?
No, no questions.
Commissioner David?
No.
Commissioner Dusan? Commissioner O'Brien? Okay, thank you. Thank you, Jane. So at this point, we would need a motion or motions.
I'll move that we take the recommendations together and find that there's no reasonable grounds to believe that there's discrimination on the basis of sex or disability, and no reasonable grounds to find that there's retaliation and the complaint should be dismissed.
Second.
So it's been moved and seconded to find no reasonable grounds on both claims. Is there any discussion? Seeing none. All those commissioners in favor of finding no reasonable grounds on both claims, raise your hand and say yes. One,
Yes.
2, 3, 4. So it is 4-0. And the findings are both no reasonable grounds. And I appreciate Ms. Tozier and Ms. Lorenzati you sticking around. We're going to move on to the afternoon cases. And apologies to those folks for our delay. It is always hard to predict how long cases will take, especially when so many of them include interpreters.
So moving on to case E19-0157, Natasha Pomeroy v. Cumberland Title Services. This is a reasonable grounds case. So is there anybody here for the complainant? I'm sorry, yes. No, the respondent, so sorry. Yeah, sorry.
Good afternoon. This is Gina McCormick here today for Cumberland Title Services, the respondent in this matter.
Go ahead.
Thank you. Good afternoon, Director Sneerson and commissioners. I am here today to discuss the objection we filed on behalf of Cumberland Title Services in this matter involving Ms. Pomeroy. And in accordance with the commission's rules, my objections to the investigator's report are based upon factual omissions in the report and issues concerning the investigator's interpretation of the law. As the commissioners know from the filings in this case, this is a Whistleblower Protection Act claim where Ms. Pomeroy has claimed that she was retaliated against for two reasons. First, she alleges that she was retaliated against for complaining about the office manager engaging in unlawful conduct. And second, she claims that she was retaliated against for voiding and destroying notarized documents. Yet, what the record in this case shows is that upon Ms. Pomeroy making her complaint about the office manager, Mr. McDonald, the owner of Cumberland Title Services,
Mr. McCormick, can you not use individuals' names?
Oh, I apologize. The owner of Cumberland Title Services listened to the complaints on numerous occasions, investigated those complaints, and determined that no unlawful conduct occurred. And in fact, Ms. Pomeroy continued to be employed for months after first making a complaint about the office manager. The record also shows that Ms. Pomeroy destroyed closing documents because they were signed in advance of a closing, which she disagreed with, even though the seller's attorney had advised the seller to sign those documents. And then finally, the record also shows, but does not sufficiently address the fact that Ms. Pomeroy was terminated because she refused to do two critical components of her job. One, conduct closings, even if they are last minute. And second, to perform her marketing duties. I'd like to begin with the factual omissions related to Ms. Pomeroy's refusal to perform two of her critical job duties. The investigator's report in the findings section at subsection H makes one reference to Ms. Pomeroy refusing to do her job. And it does so simply saying on June 26th, she sent an email to the owner reporting the previous day's events and stated she needed more notice to prepare the documents. Yet, if you look at Exhibits B and Exhibit C that were filed with Cumberland Title's response, it provides much more detail of the back and forth that occurred. That was actually the previous day on June 25th, not June 26th, and outlines Ms. Pomeroy's repeated refusal to conduct these closings without 24 hours notice. Yet again, if you do look at that email chain that was included in Exhibit B, it becomes clear that last minute closings are part and parcel of a title company's business. And those last minute closings are driven by demands of brokers and clients. And Ms. Pomeroy's colleagues were trying to explain that they were processing these files as quickly as they could, but that it would happen from time to time. Second, Exhibit C does include the email where Ms. Pomeroy refused to perform her marketing duties. And again, I would just encourage the commissioners to look back to the only finding on this, which is H, which really does not sufficiently get into the details of the exhibits or the facts underlying them to support one of Cumberland Title's stated reasons for the termination. Now I would like to turn to the issues with the investigation report's legal interpretation. The first issue has to do with the conclusion that Ms. Pomeroy engaged in protected conduct with respect to the notarized documents. Cumberland Title believes that this is not supported by the facts, and it is not supported by the Notary Public Handbook, which the investigator relied upon. Now, if we look at the investigator's report at 3 section G, the finding is that complainant voided the documents because she believed the documents should not have been signed and notarized until the transaction was complete. And that finding is consistent with Exhibit A, which is a letter that Ms. Pomeroy wrote. Yet, in the analysis section, which is the report at page 4, section 7B, the report discusses when the complainant voided the closing documents, she engaged in protected conduct. She produced copies of the Notary Public Handbook, which plainly instructs notaries public not to notarize documents if the signer seems confused or hesitant. However, again, the finding was that she voided the documents because the transaction was not complete. But the analysis states a different reason, that the seller was confused or hesitant. Now, even if the seller was confused or hesitant, if you look at the Notary Public Handbook, it actually addresses this exact scenario and says that if the signer is unsure or confused, the notary public should refer the signer to an attorney or other professional to assist them, as that would be in the best interest of the signer. And that is what Cumberland Title believed should have happened here. Everybody from the company involved in the transaction knew that the seller was represented by an attorney, and rather than after the fact going ahead and destroying the documents, Ms. Pomeroy should have reached out to the seller's attorney, looped him in, and then addressed any concerns that there may have been related to the status of the transaction or the seller's understanding, if that was in fact an issue. Lastly, the other legal issue with the investigator's report relates to Ms. Pomeroy's complaints about the office manager. First, the investigator's report does not have any analysis as to whether Ms. Pomeroy's complaint about the office manager was based upon a reasonable belief that unlawful conduct had occurred. Now, the complaint was that the office manager had added a new reference to a deed that did not change any of the boundaries on the deed, but that Ms. Pomeroy believed still constituted unlawful conduct. Cumberland Title's position is that no reasonable person in Ms. Pomeroy's position would have believed that to have constituted unlawful conduct. And in fact, the Bureau of Insurance, and this is detailed more in the response, concluded that no wrongdoing occurred with respect to this transaction that she complained about. And second, even if she had had a reasonable belief that it was unlawful, there's no causal connection here between the complaints about the office manager and her termination. Again, as detailed in the extensive filings in this case, Mr. McDonald looked into the complaints, talked with her about them, talked with the office manager, and continued to employ Ms. Pomeroy for months thereafter, and even had conversations with her about her bright future with the company. So for these reasons, the factual omissions related to the performance issues, as well as the legal issues I've discussed, Cumberland Title respectfully requests that the commission determine there are no reasonable grounds to believe that discrimination occurred here. Thank you.
Thank you, Ms. McCormick. And I would remind you to not use the names of the individuals and to instead use the pseudonyms that we've given in the report, like owner.
Yes, thank you.
So then we would turn to, Commissioner's questions for Ms. McCormick. Commissioner Whitworth.
I do have a quick question. So I'm not a expert on the notary handbook. So I just did a little bit of a quick Google search, and it says that a notary for his or her own protection should not agree to notarize documents when in their best judgment, they are not comfortable with the request.
Commissioner Whitworth, I applaud your initiative, but you should only be considering the record in this case, not anything that you have Googled about it.
Okay, then I will withdraw my question. Thank you.
Commissioner David, any questions for Ms. McCormick? No. Commissioner Dusan?
Is it in the record the exact language of the affirmation that the notary signs?
I believe that the record includes the documents that were notarized, and that may include the affirmation. No, I'm not seeing it, but I will defer to the investigator if it is in there, but I am not seeing it.
I'm happy to ask the investigator.
Okay. Commissioner O'Brien, questions for Ms. McCormick? Nope. Okay, Ms. McCormick, you'll have a little over a minute when we come back to you.
Thank you.
And then I see Ms. Pomeroy. Do you have counsel, Ms. Pomeroy? Are you representing yourself? I think you said representing yourself because you are muted. So you should unmute because now it is your turn.
Yes, I am representing myself, and good afternoon, everyone. I appreciate all of your time today. I have been up all night thinking about today and my prepared response to respondents' objections. After reading my notes for the 100th time this morning, I realized that I was repeating everything I've already written and submitted for the commission, almost verbatim. There's nothing that I could say to you now that has not already been said in some fashion or would change any opinion you may have. The truth is in your hands or on your computer. I am prepared to answer any questions that you may have, and I do reserve my remaining time.
Understood. Questions for Ms. Pomeroy, Commissioner Whitworth?
No questions. Thank you.
Commissioner David?
No.
Commissioner Dusan? Commissioner O'Brien?
No.
Okay. I have noted that you have your time left when we come back to you if you want to use it, Ms. Pomeroy. Back to Ms. McCormick. You have, as I said, a little over a minute.
I appreciate the extra minute, but I do not have anything further to add. Thank you.
Okay. Well, that was spectacularly brief, everybody. So then last chance, Ms. Pomeroy, anything that you want to say before we turn to our investigators?
No, I do not.
Okay,
Thank you.
Thank you. So Mr. Gitchos.
Good afternoon, commissioners. I'm Milo Gitchos. I'm the investigator that was assigned to this case. My finding for reasonable grounds was based primarily off of a timeline in that the complainant and a coworker decided to go to work for respondent at a similar time period. While they were there, very shortly after beginning, they noticed some questionable office practices by the office manager. Both of them took that information to the owner and informed them of what they saw. And he said, okay, I'll take care of it. These instances seem to continue. The record goes through additional complaints and discussions from complainant to the owner regarding what she was witnessing on behalf of, or in terms of the actions of the office manager. and raising complaints, and they were heard, they were met, and it seems to be understood that there were issues that were ongoing. The record goes on to show that complainants' job description was changing over this time period, less from marketing and more to closings, which was not misunderstood, but seems to have become the primary issue or the primary job of complainant at that time. And complainant did request to have more than 24 hours notice in completing the paperwork for the cases. Finally, on June 25th, there was another incident where, or not another incident, but this incident that occurred where complainant met with a seller, had been informed that there were, the seller was informed by their attorney to sign, but the seller seemed to show, in complainant's opinion, some significant hesitance. And in her professional opinion, and in order to make sure everything was above board, contacted the office manager and again was told to sign the papers. This complainant was not comfortable with that and voided the documents. Emails were sent back and forth, and the next day, complainant was discharged. So that was the reasoning for retaliation, that while complainant worked there for a period of some months, had this ongoing issue, and then prior to discharge was enacting a decision that she felt was covered by her rules of ethics. If you have any questions, I'm happy to answer.
Thank you. Commissioner Whitworth, questions for the investigator?
No questions, thanks.
Commissioner David, questions?
Milo, is it sufficient that she believed that the order was inappropriate in accordance with her standards, or does it require objective evidence that the activity is protected because it's illegal?
Well, it's not illegal. It's, as I understand it, a professional limitation, Commissioner David, that if the notary believes there's enough confusion, or it is not, if the person signing the document may not show 100% capacity, that they would have the ability to either void or postpone or seek additional information.
And it's clear to you that that's a protected activity?
Yes, legal counsel might be able to illustrate that. We discussed that, and
okay. Yep. Thank you.
Commissioner Dusan?
Yes, I wonder if Milo could share with me the wording of the affirmation that the notary is asked to sign.
The wording of the affirmation?
I think it's important. There's a paragraph above where you sign that says, I verify this person appeared before me. That's the language I'm looking for.
Okay. May I have one moment to pull that document up?
Certainly.
Thank you.
Is that an okay question?
Yeah.
Okay.
Commissioner Duson and Executive Director, if you'll back me up on this, that has yet to be added in our new database. So I do not have access to that particular document at this time. I have our investigators report, but as for that particular record, I do not have access to it right now.
I think I see Miss McCormick indicating that she has it at her fingertips.
No, in fact, the opposite. I'm sorry. I was just going to offer, to the extent it's helpful, the documents attached as Exhibit A to the response, which include the closing documents with the notarized signature, they do not include the typical affirmation that you would see, for example, at the end of an affidavit or a declaration of some kind. Instead, they're just closing documents with a place for the notary to put her seal and her signature. So again, I don't want to say that there isn't an affirmation in the record, but I'm not seeing one, and that's what I'm seeing.
Okay, well, since...
May I ask if Ms. Pomeroy would know what the affirmation language was? If she
Am I muted?
You are not muted.
Okay. Yes, so it says personally appeared the above name and acknowledge the foregoing instrument to be her free act indeed.
Thank you, Ms. Pomeroy.
Thank you.
Commissioner Duson, any other questions for the investigator?
Yeah, I think I want to come back to I think I really would like to hear this from the investigator versus the parties. So that being the affirmation language, I understand that complainant did not sign that affirmation, or are we saying that she signed it and then later withdrew the documents, or I don't want to say tore up, but there's a different word used in the record.
No, as I understand the facts of the case, Commissioner Duson, she did sign, but while still there, voided the documentation.
And how did one void the documentation?
If memory serves correctly, it was X'd out or void was written on it.
Understood. Thank you very much.
Commissioner O'Brien, questions for the investigator?
No, just thank Commissioner David for putting my question much more succinctly than I would have. Thank you.
Okay. Thank you, Milo. At this point, we have heard from the parties and the investigator, and we are looking for a motion or motions from the commissioners.
I'll move that we conclude that there are reasonable grounds to believe that the respondent retaliated and conciliation should be attempted. And speaking to that motion,
no, we first have to have a second.
Yeah.
Second.
Yeah, speaking to that motion, it's clear to me that affirmation, the judgment of the free act indeed, is for the notary to make, and that's a protected activity, and clearly she was retaliated against for exercising that.
Ms. McCormick, we're not hearing from the parties at this point.
I don't believe that's in the record.
Actually, a different investigator who is in the office is looking at the file and says the attestation clauses are there. So, I believe Commissioner David was just speaking to his motion, and then is there other discussion on the motion to find reasonable grounds to believe that unlawful retaliation occurred? Seeing none, all those commissioners in favor of the motion to find reasonable grounds in this case, raise your hand and say yes.
Yes.
1, 2, 3, 4. The finding there is reasonable grounds. Thank you, Ms. Pomeroy. And so then, Deb, do you want to call the next case, or shall I?
No, I can do that. So our next case, E190213, Nancy Segroy v. Cumberland Title Services. This is also a reasonable grounds case. Is there anybody here for the respondent?
Yes,
Ms.
Commissioner.
McCormick.
Chief McCormick, again, for Cumberland Title Services.
Go ahead.
Thank
I'm
you.
sorry. I'm sorry to interrupt. Would you tell me the case number again? I just have the list in front of me, not the agenda. And so I'm scanning down, trying to.
Yeah. So
which one
it's
to touch.
E190213.
Gotcha. Thank you very much.
You're welcome.
There it is.
May I begin?
Yes.
And-
Yes.
Thank you. This complaint brought by the complainant is a whistleblower retaliation case where the complainant alleges retaliation for two reasons. First, she claims she was retaliated against for complaining about the office manager engaging in unlawful conduct. And second, she claims that she was retaliated against for testifying on behalf of her former coworker during an unemployment compensation hearing. The record in this case does show that Cumberland Title, and specifically the owner, did hear and look into the complainant's concerns. And in fact, as the investigator spoke, and he was speaking of both of these cases, according to my notes, that the complaints were heard, that the owner did listen to them, and that the owner did respond to them. The record also shows, and this is particularly important to the case we're discussing right now, that Cumberland Title experienced a significant decline in business in the Bangor office where the complainant was working between the months of June and mid-September. And that is what led to the company's decision to terminate the complainant. And again, consistent with the commission's rules regarding objections to the investigator's report, this objection focuses on factual omissions and legal errors in the report. First, I just want to briefly touch on the fact that the report does not analyze whether the complainant had a reasonable belief that the office manager's alleged conduct was unlawful. Again, as the investigator was describing this conduct a few moments ago, and he appeared to be talking about both cases, was that there were questionable office practices. And that's consistent with the finding in the report on page 2, where the investigator found that, quote, complainant became aware of unethical practices undertaken in a closing conducted by OM, which stands for office manager. Yet the report then goes on to assume that the complainant had made a report of unlawful activity. It's important to note that an unethical practice is not necessarily an unlawful practice. And there's no analysis of that in the report, and these two ideas appear to be conflated. And again, even if there had been a complaint of an unlawful practice here, there's no causal connection. The complaints were first made in March. The complainant continued to be employed through mid-September, and the owner did take prompt action to address these concerns. The fact that he concluded that nothing unlawful occurred does not in any way suggest that he ultimately terminated complainant for making that complaint. And again, there's not that same temporal proximity here. Second, the record shows evidence of a lack of work. The facts as submitted by the respondent in this case show that between February 2018 and June of 2018, the Bangor office specifically had over 100 transaction requests. The record then goes on to show that between June and September of 2018, the Bangor office specifically had 34 transaction requests. And again, this is outlined in the response in narrative form. When the difference in the time periods is taken into account, the numbers show that the business in the Bangor office declined by nearly 50% in July, August, and September, which was when in mid-September, the respondent decided to terminate complainant's employment. Now, the report, notwithstanding that evidence, concludes that the alleged lack of work was a pretext used to justify discharging the complainant, and goes on to say that the respondent, quote, could have sent less work to the Bangor office to create an apparent lack of work. However, that conclusion is entirely speculative. There's no basis in the record to suggest that respondent in any way sent work to different offices. In fact, additional evidence that was submitted in the response shows that in addition to terminating the complainant's employment for lack of work in mid-September, the respondent in fact terminated another employee in January of 2019 for the same reason, a lack of work. Now, it's respondent's position that whether there was a downturn in business that persisted beyond the complainant's termination is irrelevant, because what's relevant is the time leading up to when she was actually terminated. But the investigator made that an issue in the report, and so I did want to note that there was an additional termination for lack of work shortly after the complainant's termination in this case. The other legal issue I would like to note for the commissioners today is that although the investigator cites to the correct case in analyzing this claim, Doyle versus Department of Human Services, and discusses the burden shifting analysis, the prima facie case, and then the employer's legitimate non-discriminatory reason, and the fact that the burden then shifts back to the employee to persuade the fact finder at the third stage of the burden shifting analysis, it appears that the report actually places a heightened burden on the respondent here. Because rather than making the complainant carry her overall burden at the third stage, the investigator, without any factual basis, there was no evidence from the complainant contrary to the respondent's demonstrated decline in business, and no legal basis, the report decided to question the respondent's proffered non-discriminatory reason of this decline in business. I would also note, and I will freely allow the investigator to correct me if I'm wrong, but based on my notes, I do not see where respondent was questioned at all about this decline in business during the fact-finding conference. Again, the only evidence that was provided was in narrative form, but did show the decline in business, and that was the reason for the complainant's termination. So in closing, I will just say that the investigator's conclusions ignore this decline in business. And it also ignores the fact that the complainant continued to be employed for several months after she first complained about the office manager. And so for these reasons, we respectfully request that the commissioners find no reasonable grounds to believe discrimination occurred in this case. Thank you.
Thank you, Ms. McCormick. Questions for Ms. McCormick? Commissioner Whitworth?
No questions.
Commissioner David?
Are there any other employees that are let go in Bangor, if the record deals with that?
The employee was not let go in Bangor, so Ms. Pomeroy was let go earlier in the summer, Ms. Segroy in September, and then the employee in January was from a different office. During that time period, however, it was an employee from the Portland office who was an existing employee who was able to absorb the additional work that was being performed in the Bangor office because of the decline. There was not enough business in Bangor to keep someone employed specifically for that office.
Okay.
Commissioner Doosan. Any questions for Ms. McCormick?
No, I don't have any questions.
Commissioner O'Brien?
Well, I think so, and I'm not sure if I'm able to ask it, so I'll be stopped if, but you just referred to the fact that work from one office was absorbed. Is it a practice of Cumberland Title to, if there was a decline in business in the Bangor office, wouldn't necessarily be in the Portland office, could work be in the past, had it been shared?
And before you answer, I'll just ask the investigator to confirm if that is in the record. Okay, he's messaging. Yes, it is in the record. So go ahead, Ms. McCormick.
I believe what's in the record is the fact that this Bangor office was new and it was opened so that the Cumberland Title Services could perform title work for the Bangor location. They saw a large increase in the volume of work for Bangor initially, but then there was a steep decline in the summer leading up to September when the complainant was terminated. And again, I don't want to speak outside of the record, so please, Investigator Guicho, stop me if I am, but the information that I understand to be the case is that Cumberland Title, when there is a small overflow of work, does have some capacity in other locations to do that work. But as a general matter, had to open the Bangor office because they did not have the overflow capacity as things were ramping up in the Bangor area when they first opened. Okay, and if I can ask another one, and again, I don't know if this is in the record, but I think it's probably relevant. Knowing real estate market is very cyclical, and 1 month can be 2 months could be 100 and then down to 30, 34. Is it relevant to ask, or that what happened directly after September? Is that, am I able to ask and get an answer on that one?
I think you might have to be a little more specific in terms of what happened.
Numbers of closings. Did it continue a downturn? Did it pick back up as often happens, or are you able to tell me that?
The evidence is that there's not evidence about that specifically in the record.
Okay. Thank you.
Thank you, Ms. McCormick. Then I believe, Mr. Black, are you here for Ms. Segroy?
I am.
Okay.
All right. Good afternoon, Commissioners. My name is Eric Black, and I represent the complainant Nancy Scroy in this matter. Unsurprisingly, we agree with the investigator's report and ask that it be adopted and affirmed. My client, Nancy Scroy, had worked in the title industry for 15 years prior to working for Cumberland Title. She's familiar with the correct and incorrect practices of that industry. Starting on March 1st, 2018, she began working in the Bangor office of Cumberland Title. She performed title abstracting, she drafted title commitments, policies, but early on, right from the beginning, it was evident that the office manager at her location was doing a lot of things that were raising eyebrows. And the point that I want to make, and I'll come back to, is that this was not just a situation where this individual was not performing proper due diligence, although we believe that happened as well. She reasonably felt that some of this conduct was crossing the line even into fraudulent territory. Altering documents to make it appear as though someone had signed something that they didn't, altering title descriptions to make it appear that a parcel of property was different than the one being sold, etc. And both she and Ms. Pomeroy witnessed these actions and reported them. And it's not a coincidence that both of these individuals were terminated within months of their reports, although Cumberland ascribes different reasons to each. To get a sense of the timeline, Ms. Pomeroy was fired on June 26, 2018, about 5 weeks later. Ms. Scroy was contacted by Cumberland's attorney, not the same lawyer representing Cumberland today, a different lawyer. And that lawyer tried to encourage Ms. Scroy to say that the coworker, this office manager, did nothing wrong. And she disagreed, and she told him so. And 1 week later, she actually testified on behalf of Ms. Pomeroy at an unemployment hearing before the Maine Department of Labor and discussed the behavior she had witnessed with the Department of Labor during that hearing. And 1 month later, she was terminated and told that she was let go due to lack of work, which shocked Ms. Scroy, as there was no indication that she was experiencing any lack of work from her position. Now, one of the objections that's been raised today has to do with whether she was a whistleblower, whether she engaged in activity that was protected by the Maine Whistleblowers Protection Act. The report found that she did, and we obviously agree with that. My client saw the office manager forge the signature of her boss on a document. Yeah, that's enough for illegality, plain and simple. And there's other things, such as altering title descriptions, deleting exceptions, even though the office manager hadn't performed title work and the title work wasn't complete at the time, making it appear as though a parcel of property was different from the one that was sold. This individual, the office manager, rushed to complete as many transactions as she could, and that led her to cut corners, play fast and loose with paperwork, and in some instances, that ventured into fraudulent conduct. And the key here is that even if the boss, the owner, reviewed this and either said, well, you know, no harm, no foul, or perhaps gave it his blessing after the fact, sure, it was okay that you signed my name to that piece of paper. Even if that was the case, that doesn't render the whistleblower complaint invalid, because the question is whether she had a subjective belief that some of this activity was illegal and whether that was objectively reasonable. And when you're in a legal environment, watching someone forge another person's signature, seemingly without their knowledge, because this office manager openly bragged about how good she was at it, I think that hurdle gets cleared very easily. If in my office, there was an employee that saw someone else forging someone else's signature on a document, I would be very disturbed if they didn't report it, because that sort of activity appears to be objectively, illegal. Now, the other main issue as to why she was fired, and I would ask the commission to look at a few different things here. Ms. Scroy's complaints were ongoing. They didn't just happen once, they happened multiple times. And her firing happened just 1 month after she brought these issues up in a Maine Department of Labor hearing in support of Ms. Pomeroy. So the time element is definitely there. Now, what of this alleged decline in business? Ms. Scroy never saw any evidence of a decline in her position. And if you look at the record, it's unsurprising why the investigator felt Ms. Scroy was more credible than the owner on this issue. In general, with credibility during these witness interviews, the owner denied that Ms. Scroy had ever complained about the office manager, which is in direct contrast to the submissions made by the company formally to the commission. So there's a giant contradiction there, which really renders the owner's testimony and a lot of the things that he had to say incredible. And then on the issue of the decline in business, again, there's a contradiction. The owner said that, according to my notes, that the company was very busy during this time period. And then later on said, well, the company was very busy, but the Bangor office wasn't. And now we get into the statistics that have come up. Statistics can be easily manipulated. There's a reference in terms of what these statistics are, what these numbers mean. They're supposed to represent transaction requests, but it's not even really clear what these are. Are they calls that were made into the Bangor office? Are these transactions assigned to the Bangor office by the boss? Because the boss can assign what he wants to any office. Title work in this day and age can be done in a lot of different places. It can be done remotely. You don't necessarily have to be close to a registry of deeds anymore. A lot of it's online. And Ms. Scroy testified that she received work not just from the Bangor area, but from the 4 other offices of Cumberland Title across the state. And so Cumberland Title has the liberty of deciding to allocate open files to a particular office. And if they assigned less to Bangor, then Bangor would experience a slowdown. But the statistic is relatively meaningless. I mean, even if these represented calls to the office, Ms. Scroy credibly testified in her interview with the investigator that she received work from many other offices anyway. So there really wasn't any workflow issue that she saw at all in her business. And it's also worth noting what we're talking about. Even if these statistics are accurate, this is a 2-month decline, roughly 2.5-month decline in calls. And if you look at that in a vacuum, it really doesn't mean that much. And that's a short period of time, frankly, in the legal profession to be making decisions about whether to lay people off. Moreover, the statistics that were provided, it's not even comparing apples to apples. We're looking at entirely different times of the year. You know, we're looking at one period between mid-February and the end of June, and another from the end of June to mid-September. Even if you take into account the differences in the time periods, it doesn't tell you much. You don't look at what the same time period was, for instance, in the prior several years. You know, as has already been brought up by, I believe it was Commissioner O'Brien. You know, the real estate market is cyclical, and you know, if you look at this in the vacuum, it doesn't tell you much. The bottom line is the data is simply inadequate, and there's nothing provided at all outside the narrative form, as has already been discussed. You know, but again, there's a lot of evidence that there was no reduction in work at all, and that perhaps is my main point. Ms. Scroy says there wasn't, and she testified credibly. You know, and I believe the investigator's report supports that. The boss confirmed in his interview that the company was very busy during this time period, and we've confirmed that this is an environment in which work can be freely assigned. And in fact, bonuses were given out in close proximity to Ms. Scroy's termination due to how well the company was doing. So there's a lot that doesn't add up here with respect to the proffered reason for termination. The bottom line is Ms. Scroy was terminated within a few months of her initial complaints and within a few weeks of her testimony before the Department of Labor. It's no coincidence that she and Ms. Pomeroy, who raised these issues, suddenly found themselves without employment in a matter of weeks or months. The investigator's report is supported by the evidence, and the commission should adopt and affirm the investigator's report. Thank you, and I reserve the balance of my time.
Okay, questions for Mr. Black? Commissioner Whitworth?
No questions, thanks.
Commissioner David? Nope. Commissioner Duson? No. Okay. Commissioner O'Brien?
No, thanks.
Okay. Back to Ms. McCormick. You have about 2.5 minutes left.
Thank you, Executive Director Sneerson. I'd just like to make 2 brief points. The first is that Attorney Black spent a significant amount of time talking about a complaint related to forgery and forged documents. I do not believe that that is discussed, or at least discussed in any detail, in the investigator's report. And I believe the reason for that is because the focus of this case was really on the complaint about the office manager's conduct during a March 30th transaction, which had to do with adding a new reference to a deed that, again, did not change the property boundaries. And Attorney Black did note that at one point during the fact-finding interview, the owner of Cumberland Title did make reference to not receiving a complaint. And I do believe that that was with respect to the alleged forged documents. It is incorrect to assert that the owner stated that the complainant did not complain about the March 30th transaction. There's no dispute about that. That was ongoing, and he did address those complaints. Secondly, I would just like to, without going over the same analysis, just note that, again, the employer has the burden of articulating a legitimate non-discriminatory reason. Here, that was the decline in business. There is evidence to support that decline in business. Now, as Attorney Black pointed out, there can be great speculation with respect to that. You could come up with any number of theories to say, well, what about this or what about that? But again, that evidence was provided. The numbers are the numbers, and at no point was respondent asked, either in writing or during a fact finding, to provide additional support for those numbers. And essentially what's being done here is imposing a greater burden than the law requires on the respondent to demonstrate its legitimate non-discriminatory reason for the termination, which was the decline. Thank you.
Thank you, Ms. McCormick. Follow-up questions from commissioners. Commissioner Whitworth?
No questions.
Commissioner David?
No.
Commissioner Duson?
No.
Commissioner O'Brien? No. Okay. Back to Mr. Black. You have about 2 minutes.
Yes, thank you. Just briefly to touch on what was just previously said, the forgery came up quite a bit, and it's right in my client's charge of discrimination, and it takes up a few paragraphs of the MHRC reply. So, you know, it certainly has been discussed in and amongst in this part of this case. Another thing I wanted to mention is that the comment by the owner that my client, or the allegation by the owner that my client had never had any problem with the office manager, I believe that was said in the interview, and it actually made its way into the first footnote of the investigator's report, where it says during the fact-finding interview, he stated a bunch of things, and that she never had any problem with OM. So, I mean, that was even captured in the investigator's report. And then finally, with respect to the data and whether it was, you know, whether it's sufficient or not. I mean, I've already said what I've had to say about that, but I will say that I believe the standard letter that goes out to a respondent when they're asked to reply to a charge of discrimination says that if you have any data, you know, please supply it in your response. You know, and all that was submitted here was just in a narrative form. There really wasn't any, I don't believe, any real backup data to talk about these transactions or any data that would, or any documents that would show these transactions. So they certainly had a shot to produce that, and currently just exists in a narrative form. So with that, I think I don't have anything further.
Thank you. Follow-up questions for Mr. Black, Commissioner Whitworth?
No, no questions.
Commissioner David?
No.
Commissioner Dusan?
No.
Commissioner O'Brien? Okay, thank you. Thank you to counsel. Now we will turn to the investigator, Mr. Gitchos.
Hello again, commissioners. I feel like complainant and respondents councils have done an excellent job of presenting their points. And if you have any questions for me, I'm happy to answer them.
Questions for the investigator, Commissioner Whitworth?
Nope, none for me.
Commissioner David? Commissioner Dusan? Commissioner O'Brien? Nope. Okay, quickest presentation ever. Thank you. So then we turn to the commissioners to make a motion or motions. So I guess a motion, because there's only one proposed finding here.
I'll move that we find that there's reasonable grounds to believe that there was retaliation against the complainant for protected activity, and conciliation should be attempted.
Looks like Ms. Julie seconded. So as motion to find reasonable grounds been seconded, is there any discussion?
Well, for me, it's terribly significant that she testifies in favor of Pomeroy, which is the other case that we're familiar with, and just made a finding about she testifies in support of her and then is terminated. And I'm concluding that but for that discrimination, even if there was a slowdown in work, that doesn't obviate the fact that there was retaliation.
Any other discussion from commissioners? Seeing none. All those commissioners in favor of the motion to find reasonable grounds to believe that unlawful retaliation occurred, please raise your hand and say yes.
Yes.
1, 2, 3, 4. It's 4-0. The finding is reasonable grounds, and I thank counsel for the parties. And now we are ready for the next case.
So next case, E19-0364, another reasonable grounds case. Christopher Bragg v. Walmart. Is there anybody here representing Walmart?
Good afternoon, Jonathan Rue.
And before we start, I just wanted to ask the investigator or commission counsel, when I was reading through this again, it looked like there may have been a typo.
Yes.
In recommended finding number 3, which says in it they're recommending a finding of no reasonable grounds, but the report itself actually recommends a finding of reasonable grounds. Is that an error in recommended finding number 3's wording? Mr. Gitchos, is that correct?
Yes, reasonable grounds were found in that respondent had retaliated against complainant. It's an oversight, a typo, Scrivener's error.
Great. Thank you. I just wanted to make sure before we started, so everyone's on the same page. Okay. Mr. Rue. Go ahead.
Good afternoon, Jonathan Rue on behalf of Walmart East. I guess just preliminarily, I would object to an amendment of the finding recommended by the investigator here. I understand that it's only slightly different than allegation number 2 or finding number 2, but I was not prepared to speak to finding number 3 today because I assumed that the recommendation was no reasonable grounds.
Did you read the report?
I did.
Okay, then let's go.
So this case, commissioners, requires a bit of a reality check. It boils down to whether at the time the law required employers to grant leave as a reasonable accommodation. But more importantly, it boils down to whether employers are required to excuse or provide as an accommodation 72% of an employee's shifts as unexpected absences that are protected. This would be a significant departure in respondents' perspective of the law. And more importantly, if you look closely, and we will, at the actual request for accommodation in this case, Mr. Bragg was requesting 13 out of every 18 days worked off.
I'm sorry, could we take a pause? I'm sorry, Attorney Rue, but I believe you are correct about the recommended findings. What the report actually finds is retaliation for MHRA related conduct, which is finding number 2. Finding number 3, no reasonable grounds for engaging WPA protected activity, is addressed in footnote 3 on page 6, where the finding, where it says that complainant did not identify any report of unlawful or unsafe activity. Shit. Oh, sorry. Oh, I just got a message that no one could hear me. And it turns out you can, because you're now all laughing at me for swearing.
Yep, totally my mistake. Yep, so we're a disaster at the moment, and apologies, number 1, to everybody watching this disaster, and also to Mr. Rue, because I was snarky with you for all the wrong reasons, and I am totally mistaken. Recommendation number 3 should be no reasonable grounds. You are right. I am wrong. My least favorite words to say, but I am 100% wrong here. Thank you, Barbara. Let's try.
Sorry it took me so long to catch up, but now that we all know what's happening,
yep,
I'll try to mute myself so I can swear privately.
Yep. All the apologies to everyone. Yep. Mr. Rue?
Thank you, Executive Director Sneerson. No apology necessary. I totally understand, but I also do appreciate it. And I thank you, Ms. Archer-Hirsch, for reviewing and catching that specific footnote. I wasn't necessarily going to be able to jump through the report quickly and find it. So getting back to kind of the overarching argument, complainant's request for medical request for accommodation says, I want 13 days off every month, unexpected absences in perpetuity. There's no end date in sight. So keep that in the back of your heads as we go through this. A few kind of important key facts that are in the record just to start things off. First of all, Walmart worked extensively for years granting accommodation requests that were requested by Mr. Bragg. If you look through the record, I think there are 5 or 6 different times where they worked with him to say, okay, you can have, 9 days in single day increments each month and 1 other day each month for treatment for your alleged disability. So any allegations today have to take into account that Walmart for years has been working hard with Mr. Bragg to allow him to continue his employment. But that does not change the fact that currently the operative facts start on or around October 5th, 2018, right? His FMLA protected leave runs out. So at that point, we're talking about protected leave under the MHRA or ADA as a reasonable accommodation for a disability. The law at the time, right, and it was changed in 2019, but the law at the time, the main law said, let's see, the MHRA expressly permitted employers to discharge employees who, because of their disability, were unable to be at, remain at, or go to or from the place where the duties of employment are to be performed. And that was 5 MRS 4573A sub 1B. There are cases that we're probably all familiar with interpreting that from the law court that said that renders leave an unreasonable accommodation under state law. This was changed later by the legislature, but it was changed after the fact, which means at the time that was the law under the MHRA. The only accommodation in this case requested by Mr. Bragg was basically forgiveness for these days that he was absent above and beyond what he was approved for. And there's recent case law that says that, you know, based on the law at the time, that is not a reasonable accommodation, essentially end of analysis, because there isn't any other reasonable accommodation that would allow an employee to perform the essential functions of their job if you can't be at work. And specifically the case I'm thinking of is Benson, and it's v. Walmart East from 2020, the district court here in Maine. The citation is 219 CV 41 LEW. And there somebody was, you know, at first a sales associate, just like Mr. Bragg, and then they moved this person to a greeter. But the court said, look, the record reflects this person can't do their job unless they're there. And the law at the time said you don't have to provide a reasonable accommodation in the form of additional leave for this essential function, which means they have to be there. So that should be the end of the inquiry on the disability discrimination claim. But assuming that the commissioners would like to hear about, you know, whether 13 out of 18 days off would be a reasonable accommodation under the state of the current law, which does not apply in our position, but I understand why, you know, given the report from the investigator, the commission is curious. The record shows that it is not reasonable. If you take a look at the job description for this position, the sales associate position, there's not a single function, essential or non-essential, that can be performed remotely. This employee has to be there. And if an employee is gone 13 out of 18 days each month unexpectedly, right? It's not like I want these specific days off. It's a call out the night before because of the nature of this disability. That means other employees are picking up the slack for all of those job functions that are listed in the job description for this position. So we have in the record, you know, the job duties include receiving and stocking merchandise throughout the store, arranging and organizing merchandise and supplies, organizing product displays. We have in the record that allowing unlimited intermittent absences would impact Walmart's ability to provide the necessary level of service to its customers and adversely affect the schedules of other associates, cause disruption in customer service scheduling. If you take a look at the medical certifications submitted by Mr. Bragg's treatment provider, a number of them specifically state that the reason he needs this leave is because he cannot perform the functions of the position unless he's granted this time off. So for those two different reasons, we would urge the commission not to adopt finding number 1 from the investigator that discrimination on the basis of disability occurred. I'll turn quickly to the retaliation claim, finding number 2, before hopefully having time for some questions. So the retaliation claim, first of all, you know, requires complainant to establish that he engaged in protected activity, you know, asking for time off, taking time off, and that he suffered a material adverse action or was adversely affected. And then the third element, that there was a causal connection between the protected activity and the adverse action. Here, Mr. Bragg specifically alleges that Walmart retaliated against him in February for not rehiring him. But I'm going to include argument about his termination itself because I can't imagine he's not also making that allegation or will argue that. So the record, it is kind of difficult to do, but critical that when you are looking at a retaliation claim, you parse out, where the employer took lawful action and where the employer didn't. And here, terminating a person for in a violation of the attendance policy is a lawful action because it would have been unreasonable to grant this person 13 days off out of every 18 workdays. So if the underlying discrimination claim fails, the retaliation claim fails because all Walmart was doing was saying, look, your FMLA leave expired on October 5th, 2018. As of October 16th, 2018, we will approve 6 days a month in 3-day increments. It lets us kind of schedule replacements. If you miss the first day, we know you'll then be gone for the next 2. We are not going to give you 13 days every month off. That's not reasonable, right? So the fact that complainant then continues to miss all of this work, those absences were unprotected and can't be the basis of retaliation because all Walmart is doing is applying their attendance policy in a fair and equitable manner because it was not only compliant with the law to deny that extra leave, but even if you do the undue burden analysis to look at whether Walmart would have been overly impacted by giving an employee 72% off, 72% of the days he is scheduled off, you'll find that it is an undue burden, in which case you can't be found to have retaliated against an employee for simply saying, we're not going to do that because it's not reasonable under the ADA or the Maine Human Rights Act. I tried to rush through there. I apologize if I jumped around a little bit. But the bottom line is Walmart bent over backwards for years, worked with this employee, terminated this employee after they realized, this is just unreasonable, but we will give you a number of protected days off. He went blowing past that in the span of 2 months, which, to kind of foresee what plaintiff is likely or complainant is likely to argue, the idea that he was fired for 2 extra absences is misleading. He had all of these unexcused absences in the span of 2 months, I believe, with normally you have 6 months to accrue 9 unexcused absences before being terminated. He accrued 11 within 2 months. And more importantly, Walmart was not required to grant the 13 days every month off because it's unreasonable and wasn't required by the law, which doesn't then mean that Walmart, by only offering 6, should have offered 2 more, which would have been reasonable. The fact of the matter is all plaintiff asked for was 13 out of 18 days every month off. Walmart denied it because it's unreasonable and not required by the law. And any retaliation as a result is not unlawful. He was being fired for a legitimate violation of the Walmart policy. Thank you.
Thank you, Mr. Rue. Questions from commissioners for Mr. Rue. Commissioner Whitworth.
Yeah, I do have a question. So you indicated that Walmart had done this for years, right?
Yes.
So if it wasn't unreasonable for years, what made it unreasonable at the time that his employment was terminated?
Excellent question. So here's the problem with this history. We're talking about 2 different types of leaves, right? An employee gets up to 12 weeks every year of protected FMLA leave, right? And Walmart is scrupulous about allowing employees to take that. And I'm glad you raised this. So October 5th of 2018, Walmart notifies complainant, you've used up your FMLA for the year, all 12 weeks, okay? So from here on out, the analysis is very different. Walmart is required to provide those 12 weeks regardless of undue burden, period. End of story, right? FMLA says you got to provide it, and we do. But from there on forward, you actually do look at, under the ADA or the Maine Human Rights Act, from October 5th going forward, what is required. And at the time under the law, additional leave was per se, according to the law court, you don't have to provide it. It's not a reasonable accommodation if the job requires you to be there, which this one does. Under the ADA, additional leave could be reasonable, right? And now under the MHRA, it could be reasonable. So then you have to engage in whether it's reasonable. Is it an undue burden? And I just got to go back, 13 out of 18 days, 72% of the days. An employee, a reasonable cause finding on this allegation sends a signal to employers across Maine. My employee can ask for 72% of the days he or she is scheduled to work off, and I have to accommodate that. I mean, the impacts on business and other employees is massive when it's so patently unreasonable.
Isn't that the nature of an accommodation? Is that it is not convenient and it is challenging for other employees?
Absolutely. And that's why some leave is appropriate. But I mean, counsel could correct me when she has an opportunity to address the commission, but 13 days out of 18, I've never seen anything like that as far as, a finding that is a reasonable accommodation. When we're talking about essential functions of the position, right? An employer does not have to allow an employee or change an employee's essential functions of their job. That is not required under the ADA or MHRA. And that's what this does. If he's required to be there as an essential function, because every task he's supposed to complete, you have to be there for. It's not like somebody doing data entry who can work from home or lawyers who can work from home. We're talking about somebody who has to be in the store to perform each and every function of his position, right? Then it is an undue burden and is not reasonable to ask for that. So I don't want the commission to focus on complainant's allegation that, 2 additional absences would have cleared this and they would have been fine. No, he asked for 13 out of 18 days forever. That's all his medical request said. And Walmart reasonably said, we can't do that. We can't do that. So I hope I answered your question.
Yeah, you did. Thank you.
Yeah.
Commissioner David, questions for Mr. Rue?
Yeah, what's the mention of changing him to part-time status? Did that get offered? Is that go ahead? Yeah, go ahead and answer that.
That did get offered. That did get suggested throughout. I mean, my understanding of the schedule right system, which is what Walmart uses to make sure that they've got coverage for all the hours that they need to make sure customers are being taken care of, is that at any time you can go in and you can change your availability. So if you want to say, I have availability from 6 a.m. to midnight, Monday through Sunday, right? I can work anytime. They'll then schedule you only for those hours. And in fact, I think the record reflects that his supervisor was encouraging him to do that if he wanted. And in essence, that's what we had been doing for the last couple of years, is providing a part-time schedule based on these accommodations. So any allegation that he was not granted the opportunity to do that, we have no evidence of it. There's no evidence in the record that he ever submitted a request and was denied, to my knowledge. And all the evidence in the record suggests his first of all, supervisor encouraged him to do it. And second, he didn't really need any permission. He could just do it on his own and change his availability, for instance, to say, I'm only available Monday, Wednesday, Friday, 8 a.m. to 5 p.m., which means he would only be scheduled in those 3 days. I'll also note that any allegations that he was denied time off, there's nothing in his original complaint, which is, pretty detailed, that says he had some specific conversation or somebody at Walmart denied him the opportunity to modify his availability and therefore have a reduced schedule. So any allegation to the contrary has to be viewed with a grain of salt, given that we saw nothing about that in his initial submission to the commission.
That's all.
Commissioner Doosan, anything else?
Yeah, I just want to know if something was worked out in the record. I didn't see it. Maybe I overlooked it. The pattern between the complainant and respondent seems to be important here. I would like to know if the complainant had, in these prior years of accommodation plans, had the complainant exhausted FMLA? Is that in the record in prior years?
Let me look at my notes. I thought I had something in here. So
The attorney is wagging her head no. And if you agree that's accurate, that's a good enough answer for me. Thank you.
I'm not certain that it is. I thought I saw something, and if I maybe, I mean, Ms. Wicks has looked at the record, I'm sure, more thoroughly than I have. So, but I would like an opportunity to at least look at it and make sure, because I swear I saw something about him exhausting FMLA leave previously. But I guess I would also ask, if Commissioner Dusan, is there kind of a reason you're asking so I can clarify the underlying reason, even regardless of whether it had occurred in the past?
I wondered, is it okay for me to answer?
Usually is a one-way direction for these questions.
I'd be happy to answer any other questions, Commissioner Dusan, you have.
Council's answer seems to cut in your favor, so I wouldn't ask me more questions about it if I were you. But I was seeking whether there was evidence in the record of a pattern of how Walmart might have responded in prior instances where the respondent, complainant, had exhausted FMLA. But there was no such instance, and so I'm good with that. Thank you.
And it just occurred to me, Commissioner David, did you have, I cannot remember if you were in the middle of asking questions when I moved on to Commissioner Dusan? No, okay.
Oh, I said that's fine. Yep.
Okay, just didn't want to cut you off. All right, Commissioner Dusan, you're all set?
I'm all set.
Okay, Commissioner O'Brien, any questions for Mr. Rue?
I'll hold.
Okay. You will have approximately 10 minutes to look at the record while we hear from Ms. Wicks.
Thank you very much.
Thank you and good afternoon, commissioners. I represent Chris Bragg, who is the complainant in this matter, and unsurprisingly, I believe you should affirm and adopt the investigator's decision. To start with the end, Commissioner Dusan, in the May 25, 2020 submission by Mr. Bragg, and this was in response to questions from Investigator Crossman, and Investigator Crossman specifically asked whether he had ever exhausted FMLA leave before, and in that filing, we explained that he had never before exhausted his FMLA leave. And just for context, Mr. Bragg in 2018, the year when his employment was terminated, 6 of the weeks he took for FMLA leave were for the birth of his son. So it's not a situation where the entire FMLA period was connected to his disability. Some of that leave, in fact, 6 weeks of it, was for the birth of his son. So just to get a sense here of how much he was actually absent. But I think it's quite significant. Over the 3.5 years he worked for Walmart, 2018 was in fact the only year that he exhausted FMLA leave. And just to start there, in these cases, we often zoom right to the technicalities of who took leave and when. But I want to center the fact that Chris Bragg was a really good employee and he did very good work for Walmart. You have his performance evaluations in the record where he was cited for being someone who was excellent at training coworkers on new tasks. He was quick. He had an urgency about him when he went from task to task. And there was a particular site to when he's showing customers how to find things. He doesn't just shout out the aisle number. He walks the customer to the merchandise and shows them where to find it. And by Mr. Bragg's account and in the record, when his store supervisors found out that Walmart was terminating his employment, they were upset. They thought, we didn't want that to happen. We thought you were a very good worker, right? So I think we have to understand that in context. And I also, very much disagree, is unsurprising, with Mr. Rue on his analysis of whether leave is a reasonable accommodation or was a reasonable accommodation before 2019. I think it is absolutely the case that leave is a reasonable accommodation under the Maine Human Rights Act, in addition to others as well. So as I explained, this is a good employee who hits a difficult health period in October and November of 2018. He absolutely hit a hard patch there and was trying to figure out with his medical provider how to get a handle on this really debilitating sinus condition that was causing tension headaches and vertigo and symptoms like that. And he needed some time away from work to get a handle on that so that he could, figure it out, get on the right medications and get back to work. So part of the problem here, and I think problem for Walmart, and I'm sympathetic to Mr. Rue, I know he was not representing the company throughout the investigation, but the way that Walmart organizes themselves when it comes to leave is they hire a third party, a company called Sedgwick. So they've outsourced a big chunk of this administrative work to another entity entirely. So you've got someone in Mr. Bragg's position who's working through a third party that's totally separate from his on-the-ground manager and even his on-the-ground HR contacts. So he was getting one set of messages from the third party entity and another set of messages from folks on the ground. And then there was another layer of complication where he also had to call into a Walmart portal regarding absences. So he was reporting these absences and trying to coordinate among at least 3 layers of administrative layering, right? So that's hard. And it's not surprising, given that very complicated structure, that when Sedgwick, the third party administrator, said
Ms.
to
Wicks, if I
Mr.
could ask
Bragg,
you, Ms. Wicks, could you not use the name of the third party because they're not actually a party? That's a
happy to. Yep, thank you. So when he got word from the third party company that it looks like you're exceeding the number of absences you thought you needed, what if you went part-time? Where Mr. Bragg thought, okay, I'll do that, and went to his boss first, his supervisor at the Waterville Walmart, and said, I'd like to go on a part-time schedule because I'm needing to get a handle on something here first. And his manager said, okay, go to HR. So he went to the HR folks at his store location, got paperwork, filled it out, submitted it, and it was rejected. They said, no, you can't go on a part-time schedule. And that is in the record, both in a declaration from Mr. Bragg that he went through those steps of submitting the paperwork and having it rejected, and in response to follow-up questions from the investigator. And I would just say, part of the trouble here is that Walmart, didn't provide any other information about that request. And I think understandably, it's sometimes hard for them to corral this information because much of it is held by a third party. But in any event, we have evidence from Mr. Bragg by way of a declaration and in his responses to follow-up questions from the investigator. And those were assumptions that were credited in this case by investigator Beecher. And I also need to address, at least briefly here, the arguments about undue burden. And this goes, Commissioner Whitworth, to your question. The problem for Walmart here, and as the investigator put right in his report, they just didn't provide any information in the investigation stage to show that there would be an undue burden here, right? So, they're making a sort of conclusory argument about, oh, it's an in-person job and we want to make sure we do good customer service. So of course that's going to be difficult if somebody's out, but they just didn't provide any evidence beyond that sort of conclusion. And unfortunately, they've got to live with the fact that they didn't provide that information when we were in the actual investigation stage. And I want to make sure I also address the retaliation point. So when Chris Bragg was fired, they said to him, hey, go ahead and reapply in a few months. That's something that you can absolutely do. So he did, he waited a few months and then put in an application to work at Walmart again. And he never heard anything and they didn't rehire him. And curiously, in the record here, Walmart says, oh, it's just our policy. We don't rehire someone if they were involuntarily terminated recently. And my head sort of exploded at that moment because they're putting Mr. Bragg in the same category as somebody who was fired for stealing from the register or harassing a coworker, where the reason that Mr. Bragg's employment was terminated was because he had a medical issue and needed leave, right? So you've now put him in the same bucket with someone who was terminated for misconduct, which is absolutely, perhaps an admission of all 3 elements you would need to prove in a retaliation claim. So I think the investigator's analysis of that was really spot on of, setting aside the fact that Walmart refused to provide any information about who they hired instead, or even frankly, who the decision maker was in either the rehire or the termination of Chris in the first place. But you can't just say, oh, we're going to lump in folks who have disabilities or folks who needed a leave as an accommodation with people who we fired for stealing. So that really stands out as well and speaks to the retaliation piece here. And so a quick perusal of my notes, although I am also happy to take any questions and answer anything that might be on the minds of the commissioners.
Thank you, Ms. Wicks. Questions for Ms. Wicks? Commissioner Whitworth?
Nope, no questions. Thank you.
Commissioner David?
No.
Commissioner Dusan?
I have no questions.
Commissioner O'Brien?
Yes, I think I hope it's just a very simple one, but from the beginning, I've been confused that he is considered a full-time employee. Did not need to go, according to the doctor's reports, that it wasn't necessary for him to go part-time. But what would a schedule look like if he's working 18 hours a month? I mean, 18 days a month. Where is the full-time in this?
If it's in if it's in the record, we don't need to speculate or we don't need a hypothetical.
Okay.
Yeah, no, I think it's a good question, because there's a little bit of, six one way, half dozen the other. There was a discussion about he needs to work less while we're getting the medical condition under control, and whether that is, to use Walmart's sort of HR parlance, excused absences, or whether that's a part-time schedule. I think you could look at it either way. And the issue with the unexcused absences, again, 2018 was the only year that he exhausted the FMLA leave. And so the thinking was that he needed to work less in this October-November timeframe while the diagnosis was gotten a better, where his medical providers could figure out what was going on and help him get back on his feet.
Thank you.
Okay, so thank you, Ms. Wicks. Mr. Rue, you unfortunately only have about 15 seconds left.
Okay, I'll be very brief. On the retaliation claim, it's really critical that we not go down the road of, fired for attendance violations. That means he was fired for his underlying disability. Totally different. He was fired for his attendance violations, which is legitimate, and he's therefore in the same bucket for rehire with everyone else who has attendance violations and other for-cause terminations.
And that is actually 19 seconds, but I gave it to you.
Thank you.
Follow-ups for Mr. Rue. Commissioner Whitworth.
Nope, no questions.
Commissioner David.
No.
Commissioner Dusan. Commissioner O'Brien. Okay, thank you, Mr. Rue. Ms. Wicks, you have, oh my gosh, I forgot to write it down, but I believe it was about 2.5 minutes left.
I'm happy to answer any questions from commissioners, but I'm otherwise happy to rest on the record and the discussion we've had so far.
Follow-ups for Ms. Wicks. Any commissioners? If not, shake your head. Nope, seeing nothing. Okay, man, I should do that more often. Okay, so thank you, Ms. Wicks. Now to Mr. Gitchos.
Good afternoon, commissioners. I believe council has done they've done excellent jobs of reciting the record. I really have nothing additional to add. If there's any questions I can answer for you, please feel free to ask.
Commissioners who have questions for the investigator, raise your hand. We're going to try this now. This is better. Raise your hand if you have a question for the investigator. Seeing none. Oh yeah, this is so much better. Seeing none. Thank you, Mr. Gitchos. Moving on. So commissioners, there are 3 proposed findings. So we need a motion or motions. Someone's going to have to make.
No, I'll move. So I'll take the first 2. So uphold the investigator's recommendation. No reasonable grounds to believe that Walmart discriminated against Christopher Bragg based on disability. And the claim should be conciliated, as well as reasonable grounds to believe that Walmart retaliated against Christopher Bragg for engaging in MHRA protected activity, and that should also be conciliated.
just to clarify, what you said for the first motion was that there are no reasonable
Oh,
grounds.
sorry.
I think
No,
you
no, no.
meant to say that there are reasonable
Yes,
grounds?
there are. Yes, so sorry. Yes,
Okay.
the first two uphold the investigator are reasonable grounds. Yes.
Second.
Commissioner Doosan seconded. So the motion is for reasonable grounds on claims 1 and 2, and it's been seconded. Is there any discussion? Seeing none. See, I'm just moving us right along. All those commissioners in favor, raise your hand and say yes.
Yes.
1, 2, 3. Okay. All those commissioners opposed? Okay. So the motion passes. And then there's still the sad number 3 that I mistakenly thought was supposed to be no reasonable grounds, but is actually written as no reasonable grounds. We need a motion as to that.
I'll move that there are no reasonable grounds to believe that Walmart retaliated against the complainant for engaging in WPA protected activity and that this claim should be dismissed.
Second.
So for number 3, Whistleblower Protection Act, it's no reasonable grounds, recommended finding. It's been motioned and seconded. Any discussion?
Yeah. What's the difference? Why are they taken separately?
Well, I can't answer why they're taken separately, but you can have reasonable grounds on the MHRA protected activity because that has to do with retaliation for requesting reasonable accommodations, which is different than WPA protected activity, which requires a report of an illegal or unsafe, and that's
the answer. That's your. Thank you.
You're welcome.
Yep.
Any additional discussion on number 3? Seeing none, all those in favor of a no reasonable grounds finding for whistleblower protection, raise your hand and say yes. 1,
Yes.
2, 3, 4. So that finding is no reasonable grounds. The commission will send a letter to the parties and council, and thank you so much for your time and patience. And again, Mr. Rue, please accept my apologies for my momentary lapse of common sense. Thank you.
No problem. Accepted.
Okay, we've got 3 cases left. Commissioners, you're doing a fantastic job. It's a very long day. It's a long day to be on Zoom like this. 3 cases left. So.
Okay, so let's see. Another reasonable accommodation, E20-0007, Darren Lyons v. Walmart. Is there anybody here for Walmart?
Good afternoon, Commissioners. Jonathan Rue.
Great.
Proceed, Mr. Rue.
What's that docket number?
E20-0007.
Got it. Thank you.
Welcome.
Commissioners, Executive Director, Jonathan Rue on behalf of Walmart East again. This case is very different, but of course, we're still talking about physical or mental disability, accommodation, discrimination, et cetera. So let me just start with the facts because I think they're relatively straightforward. Complainant currently works a set schedule, 12 p.m. to 2 p.m. Tuesday through Friday, and he still has a job coach. That has always been what complainant worked at Walmart. The allegation in this case is that Walmart at some point changed the terms of and conditions of his employment by denying him that schedule. And as you can see from the record, Walmart never denied him that schedule. He has always worked 12 to 2 p.m. Tuesday through Friday. He's always had a job coach, and that has not changed. So let's get into why this is before you, given that kind of basic set of facts. Essentially, Walmart, as you probably know from the record, switched over to the schedule right system. where they no longer will guarantee employees a set schedule in writing, right? They say, look, we determine schedules based on customer needs, the historical flow of traffic, purchases, how busy a store is at any given time throughout the day. And we are not going to, in response to requests from employees or attorneys for employees, say, forevermore, you will be granted this schedule in this position for these hours on these days forever. What they will do, of course, is look at individual circumstances, look at the store's needs, and say, okay, perfect. You need 12 to 2 Tuesday through Friday. We've got 12 to 2 Tuesday through Friday over in foods. We don't have it in hardware or whatever other portion of the store anymore because of the needs of the store, but we do have it over here. So here you go. This complaint boils down to complainants' hope that Walmart will change that policy. And so this is a vehicle for that, to challenge whether Walmart has to, under the scheduled rights system, essentially guarantee employees forever a set schedule. There are a number of problems with complainants' allegations in this case. So first of all, let's look at a couple of specific parts of the record. So at page 3, paragraph 5 of the investigator's report, he notes it's respondent's burden to show that no reasonable accommodation exists or that the proposed accommodation would cause an undue hardship. Okay, that's an or. There was never any denial of what this complainant requested, right? Still the same hours. And we know that because we look at Exhibit 11 to our statement of position submitted to the commission. Exhibit 11 is the medical request for accommodation for this complainant. And this is, I'm going to quote it. Here's what his medical provider asked for. Quote, reduced schedule, 2 hours per day, 4 days per week. End quote. Period. No demand that schedule right not apply to this person. No demand that he receive in writing that, for the entirety of his employment forever, will he be given this time or these hours. That's it. His medical provider said, reduced schedule, 2 hours per day, 4 days a week. That has always been granted. Right? Complainant has never worked a different set of hours as far as 2 hours per day, 4 days per week. So the inquiry is over. There is no reasonable grounds to find that that was denied because it never was, period. Second, right? Even let's assume somehow, okay, and it's not accurate, but let's assume somehow he was denied his request, which I just read it to you, so he wasn't, but let's assume somehow he was, right? Walmart had some obligation, despite the medical provider's note not saying it, to say, we promise forever to only schedule you Tuesday through Friday for these hours. The third element of a claim for discrimination requires adverse action. So where's the adverse action? I mean, the possibility that in the future, 6 months from now, Walmart's store patterns could change and his supervisor might come to him and say, hey, complainant, you've been a great employee. We love you, but we got to move you back over to hardware. And it's got to be from 5 to 7 p.m., 4 days a week, right? That hasn't happened. And you can't bring a discrimination claim for something that hasn't happened. There has been no adverse action taken against this employee, period. Couple of quick points just to kind of bolster what we're talking about. He's had the same terms and conditions of his employment, no loss of hours, no loss of pay, no loss of seniority. He was just given an option to change his request, or excuse me, he was just granted his accommodation, which is I need to work these hours every day. He moved into the foods department. That's not an adverse action. The EEOC is very clear about that. The law is very clear. Moving somebody from one department to another without some sort of loss of seniority, loss of pay, some adverse action, right? Actually affecting the terms and conditions of an employee's employment. That just didn't happen here. Reasonable accommodations under the ADA do not include the creation of a job or shift, or the requirement that an employer disregard the needs of the business, right? This stuff happens all the time. You decide, we don't need 3 checkers, we need 4, or we need 2. So we're going to move one of the 3 checkers over to sales associate sort of thing. EEOC is also very clear. Reassignment is a reasonable accommodation. Okay. So moving him to foods for the exact same hours on the same days is not an adverse action. I'm happy to answer questions about this, go through the facts if there are questions from the commissioners about the law or the facts, but I'd urge you to reject the investigator's findings of reasonable grounds and vote that there are no reasonable grounds because Walmart granted the accommodation. There was never any adverse action taken against this employee. Thank you very much.
Thank you, Mr. Rue. Commissioners, questions for Mr. Rue? Commissioner Whitworth?
No questions.
Oh, I should be doing this the new way. Any commissioners having a question for Mr. Rue, raise your hand. Excellent. Shorten things up. Commissioner David.
Isn't granting the accommodation a thing that's done in writing? Isn't there a process? He requests an accommodation and they have to respond. And your argument is they refused to grant it and say they're granting it, but in fact they did it. So no harm, no foul for the time being, right?
Not close, Commissioner. I see what you're saying, but this is, and you're right on the critical point here. If you look at the actual accommodation, right, it's not what plaintiff wants it or complainant wants it to be. It's not that, I get guaranteed some sort of, in writing, some sort of schedule. The actual request for accommodation is 4 days a week, 2 hours a day. Okay, that is that's in the record. So to the extent there was some sort of mix up or Walmart said, we're not going to grant you some sort of guarantee in writing, that's why that my second point is so critical. So first of all, I'm not sure that complainant has actually really alleged, well, you didn't grant my actual accommodation. What they're really alleging is you didn't grant me the accommodation I wanted that's not supported by my medical paperwork. But that's why the second point is so important. Even if, let's assume, Commissioner, because I hear what you're saying, right? The written denial, even assuming it was quote unquote denied, he still has to show an adverse action. And what is that? A change in the terms, conditions of employment. And there hasn't been one, period. Transferring to foods is not an adverse action. So his claim fails.
So the response to the request was a denial.
I don't want to overstate things. I just was looking at all the other documents in the other case. My understanding is, let's see here. There was a denial at first because, right, his paperwork said he couldn't lift over 15 pounds. That was legitimate because the position required 25 pounds for lifting. That got clarified in the follow-up medical documentation. And let me just look at the documents. I apologize, Commissioner. There was the written denial, and opposing counsel, I'm sure, will correct me if I'm wrong. And that's when they said, okay, we can't, let's see here. I don't believe there was a second denial, but I apologize if there was, because I'm not going to catch it quickly enough to, without wasting all of the remaining time for people to ask questions. I apologize.
That's all.
Thank you, Commissioner David. It may be that the investigator or Ms. Aiello can answer that later.
Right. I'll ask them.
I did find it. I apologize. May I just respond, Ms. Sneerson?
Sure.
So on October 30th, they did deny his request for a set modified schedule because establishing a set schedule would impact the company's ability to provide the necessary level of service to customers. adversely affect the schedule of the other associates and or cause disruption in customer service scheduling. But that's where it's so critical to note, first of all, right, that's the schedule right system. We're not going to guarantee people forever a schedule, but we'll work with them. We'll work with people on an individual basis, which is what happened here. So it was denied, but then he continued working those exact hours. All Walmart was doing was saying, we can't guarantee forever, which is not unreasonable. And that's not the crux of the case anyway, because again, he was never actually denied this set schedule. He was denied the future possibility that it wouldn't be changed, if that makes sense.
Oh, yeah, it makes sense.
Thank you. Okay, so no, commissioners, any other questions for Mr. Rue at this time? Okay, then we will turn, Mr. Rue, you'll have just under 3 minutes left, but right now we're going to turn to Ms. Aiello.
Thank you.
Thank you very much. Thank you, commissioners. I know it's been a long day for you. Appreciate your time. My client, Darren Lyons, has been an employee at that same Fulton, Maine store for 14 years at the time he filed his complaint at the Maine Human Rights Commission. He, during that time, has always been rated as a solid performer who meets job expectations. So in answer to Commissioner David's inquiry, Walmart came to my client and his job coach and informed them that there'd be no more set schedule available for him. He followed the requirements that Walmart indicated by contacting the third-party Disability and Leave Service Center on October 30th, 2019. He was told in writing, quote, establishing a set schedule would impact the company's ability to provide the necessary level of service to our customers, adversely affect the schedule of other associates, and or cause disruption in customer service scheduling. Through the commission investigation, Walmart was asked to provide information on how this would be an undue burden. Providing him an accommodation would be an undue burden. Walmart never provided evidence regarding its finances or how the accommodation would be an undue burden. Certainly, a reasonable accommodation doesn't mean a guarantee forever anything. But it does mean a protected, sanctioned accommodation that can be enforced if it's ever taken away or if issues ever arise. Walmart, importantly, has never retreated from its position that a modified set schedule is not reasonable. And they have not agreed to provide this schedule as a reasonable accommodation under the law. And so this is a real problem. Certainly, it is true that he has the same schedule, but what is so, Mr. Rue is saying, why are we even here? Well, we're here because Walmart has perpetuated this problem by not agreeing to it as a modified schedule. So why is this significant? This is significant because courts have been abundantly clear that a company's alleged voluntary cessation of a challenged practice does not deprive a court, or in this case, the commission, of its power to determine the legality of the practice. And so this is why the commission is here, right? The commission is here to look at illegal or unlawful practices under the law in the state of Maine. And this is exactly what's happening here. Walmart has informed Mr. Lyons regarding the accommodation that he had for 14 years, modified set schedule. That's written into the Maine Human Rights Act as an accommodation. They told him that he can no longer have it. And that is the adverse action. The adverse action is being that employee, namely in this case, Mr. Lyons, who's told that you can no longer have this schedule. To not understand how that's adverse, I suppose, is not really appreciating how critical it is for employees with disabilities who need accommodations in order to do their job. That, in essence, being told that he couldn't have that schedule anymore was, in essence, threatening him, threatening his job, and it created the same feelings of fear and anxiety that it would in anyone reasonably, told that their job is in jeopardy. So courts have repeatedly held that if employers do more than the law requires in order to assist an individual with a disability, and this is not more than the law requires, but Walmart insists that it's more than the law requires, apparently, given that the claim that the accommodation requested is not reasonable. So courts have held that they will not be required to continue the practice or be penalized for stopping it. And that makes sense, right? If an employer provides an accommodation for someone that gives more than what the law provides, then they shouldn't be held to keep giving that forever. In this situation, that's what the courts have found. But in this situation, Walmart is refusing to even acknowledge that this is a reasonable accommodation. So that creates problems for individuals like Mr. Lyons and others who have had this problem with this automatic scheduling system, where if Walmart is saying, oh, we'll give it to you, if they never challenge it, they'll lose the right to challenge it in court. As you know, there are very strict deadlines for bringing these claims to the commission, 300 days or you're out on many remedies under the Maine Human Rights Act. So courts have been very clear that it is well settled that Walmart's voluntary cessation of a challenge practice does not deprive a court or this commission of its power to determine legality. So that's what Mr. Lyons is asking this commission to do today, is to look at his claim for reasonable accommodation, the same accommodation he's had for 14 years. Consider whether or not that accommodation was an undue burden for Walmart, and then provide and then confirm that the investigator's report is exactly on point and correct, that Walmart refused to do that. It's not fair to play with people's lives. It's not fair for a large company like Walmart to tell folks who have a clear need and have proven their need for accommodation that they can't have it. And, oh, I guess that didn't mean anything, because that's what's going on here. So the denial was an adverse action. Darren was hurt by that denial. And we're looking for the Human Rights Commission to verify this investigator's report, because it is a problem. Walmart has questioned Darren's standing despite their denial of his modified work schedule. Now, the US Supreme Court has recently addressed the issue of standing in some recent cases, which provide guidance in the case before this commission. For example, in Roman Catholic Diocese versus Cuomo, the court entered an injunction on a COVID restriction in New York, even though New York had stopped enforcing the restriction, because a voluntary cessation of enforcing a restriction, and in this case, Walmart saying, oh, we didn't really mean it, we're giving you an accommodation, that's good enough. Well, that's not what the law says. And that's why the law provides for things like declaratory judgment and voluntary and declaratory judgment, to be able to inform the parties that this is okay or this is not. And this is why this case is so perfect for a reasonable grounds finding, because it will put this case into conciliation. This policy does not only affect my client, it affects other people in Maine. So Walmart has denied Darren his request for reasonable accommodation. They've alleged that establishing a set schedule would impact the company's ability to provide the necessary level of services to customers, adversely affect schedules, and or cause disruption. That does not equal undue burden. Walmart has failed to meet its burden in this case. My client has shown that he has standing to pursue this relief. He is entitled to injunctive and declaratory relief, and he's seeking to have this commission verify its findings. Indeed, the Maine Human Rights Commission has a duty to the public to investigate and to seek to eliminate all forms of invidious discrimination. I truly believe in the commission. I think the commission's work is really important. It's important to the parties coming before them. It's important to trying to resolve claims before they have to be litigated. Certainly the commission can bring litigation to ensure that unlawful discriminatory conduct is redressed, not for one individual, but for the public. But this is an example of a case that some really good work could be done in conciliation based on the finding of reasonable grounds. Thank you very much for your time. Happy to answer any questions.
Thank you, Ms. Aiello. Questions? Commissioners who have questions for Ms. Aiello, raise your hand. Seeing none, loving this, very fast. Then we go back to Mr. Rue. Mr. Rue, you have about 2.5 minutes left.
Thank you, Executive Director. I thought it was 3 earlier. Is it not? Is it?
It's actually 2. I said just short of 3. It's precisely 2.45, but I think you're going to go a few seconds over.
Thank you. I understand what opposing counsel is saying, right? This is an issue that she wants to get before the commission and the courts. This is not the case. I mean, the emperor has no clothes here. And I understand the equitable arguments, but this is not about the emotional impacts on complainant, as difficult as those may be, right? You cannot have a viable claim in front of the commission unless there was a denial of what was actually requested. And so we have to, I'm looking at the medical request. Reduced schedule, 2 hours per day, 4 days per week. How did Walmart deny that? There's nothing in there about you need to guarantee me the same 2 hours every day. There's nothing in that request that you have to guarantee me the same days every week. There's nothing in the request that Walmart denied. I understand that the denial that occurred may not have appreciated that fact, but that doesn't change the fact, right? Walmart said, hey, we're not going to guarantee you a set schedule because our schedule right system won't allow it. What Mr. Lyons could do is say, I'm only available to work Tuesday through Friday, 12 to 2, right? And then he will only be scheduled during those hours. And in fact, what happened was his supervisor, because he is a valued employee, went to him and they worked out a schedule that complied with everything his medical provider asked for, okay? Secondly, there is no adverse action that is actionable here. And if just because, you know, emotionally, this is a difficult case or the commission doesn't like what Walmart is doing with schedule right, that doesn't change the fact that there is no adverse action. And this is not the case for the commission to find reasonable grounds on because they don't exist. There was never, I didn't hear opposing counsel say that this is how his terms and conditions of his job were affected. I heard her talk about the impact on him personally, which I understand and I appreciate, but that is not why we are here. It is only an actionable claim of discrimination if the actual terms and conditions of an employee's employment change, and they did not. There is just a finding of reasonable grounds on this case. It just boggles the mind. This is just not the vehicle for this claim to get advanced to the next stage. And in response to Ms. Aiello's point, if he ever does get denied these hours or this schedule, that's when he can bring a claim. So the idea that there's a 300-day window that is ticking and had to be brought now, simply not true, right? We've got this medical record, 2 hours per day, 4 days per week.
Mr. Rue. Yeah.
Thank you. I apologize for going
That's
over.
okay. That's okay. Any commissioners who have questions for Mr. Rue, raise your hand. Seeing none. Love it. Ms. Aiello, you have about 1.5 minutes left.
Thank you very much. With all due respect to Attorney Rue, I know he's doing his job, but I think that there's some hair splitting going on here. The whole idea of a reasonable accommodation in the ADA, in the Maine Human Rights Act, is to modify something. I am not here to question a business's right to set schedules of their employees, to come up with good and innovative ideas for scheduling. What I am here to say is if you do have that scheduling system, more power to you, but you have to be willing to provide reasonable accommodation to it. You can't, more than 30 days after the enactment of the Americans with Disabilities Act, create a scheduling system and then say, well, it doesn't fit within the scheduling system and you have to do it a different way. And I beg to differ with the characterization that it's no problem to set a schedule with this automatic scheduling system, because it doesn't guarantee a set schedule. You get what you get, you can put your hours in, but it doesn't mean that you're going to get the set schedule that you need as a person with a disability who needs predictability and set hours. So, and I would also say that if I am an attorney representing someone and they get clear notice that they are denied a right the right to reasonable accommodation, I very well better be filing a complaint within 300 days. He was given clear notice in writing that right was denied. And so
Ms.
that's
Aiello.
it. Okay. Well, thank you very much.
Thank you. Any commissioners with follow-up questions for Ms. Aiello, raise your hand. Seeing none. Then we turn to the investigator. Oh, I heard a beep. Ms. Neal.
Good afternoon, commissioners. The attorneys have definitely covered the broad ground of what this case is about. And, the things that I just want to say kind of go to what Attorney Aiello just said, which is that, the whole purpose of a reasonable accommodation is to change a policy or practice that is a procedure to allow someone who has a reasonable accommodation request based on disability to be able to perform the essential functions of their job, to do it and to be able to have that. And the framework that Walmart has put out there is that they're shifting the onus to the complainant to say, you go in and change the schedule. It's all on you to do this. It's not them working with the person. It's Walmart telling the party who's asking for the reasonable accommodation, go in and just change when you're available and you'll get what you get if we can give it to you. And so I don't believe that the characterization is necessarily the same. So the bottom line is that on October 30th of 2019, respondents' third-party administrator sent a letter to complainant that said, your reasonable accommodation request for a set schedule is denied. And that is where we stand. Whether or not they've continued to allow him to work the time in a different department based on reaching out to him doesn't change that denial. It doesn't change that fact. He's not asking for, an accommodation forever guaranteed in writing. That definitely isn't something that came up as part of this case. It's just literally asking to work with him to change their policy or practice or procedure with this scheduling system to allow this individual with the disability to do his job. And I haven't heard anything else that would change my recommendation today, and I'm happy to answer any questions.
Thank you, Alice. Any commissioners with questions for the investigator, raise your hand. I see Ms. Dusson. Commissioner Dusson.
So to the investigator, Ms. Neal, there's no lack of certainty from your investigative position that denial of a request for accommodation is an adverse action.
To me, that is an adverse action. They've said, we've denied your request.
Okay, thank you.
Thank you, Alice. So at this point, we've heard from the and the investigator, and so we'd be looking for a motion. There is one proposed finding.
I'll move we find that there are reasonable grounds to believe that Walmart discriminated on the basis of denying a reasonable accommodation request, and conciliation should be attempted.
Second.
It's been moved and seconded. The motion is to find reasonable grounds. Is there any discussion?
Yeah, the case is a reasonable accommodation request. It's not a case about them changing his hours, and so the fact that they've continued to do it to avoid that is not an abrogation of the fact that they denied the request. The request on its face was reasonable. It's been reasonable for 15 years.
Any other discussion from commissioners? Okay, seeing none, the motion is to find reasonable grounds to believe that discrimination occurred. All those commissioners in favor, raise your hand and say yes.
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 Okay, that looks like 4-0 to me. And so the finding is reasonable grounds. Thank you, Mr. Rue and Ms. Aiello.
Thank you very much.
Thank you very much, commissioners and executive director.
And now, without further ado, shall we move on to our next case, which is housing and public accommodation.
Yes.
HPA 21-0007AB, Judith Ranta v. CP Management and James Wells. Is there anybody here for Ms. Ranta? No.
I don't believe so. So typically when the person opposing the recommended finding does not appear, the commissioners vote to adopt the recommended decision.
So I will move to uphold the recommendations of our investigator, Kit Thompson-Crossman, that there are no reasonable grounds to believe that CP Management and/or James Wells discriminated against Judith Ranta on the basis of race, color, national origin, ancestry, and/or disability, and that there are no reasonable grounds to believe that CP Management and/or James Wells retaliated against Judith Ranta for engaging in MHRA protected activity, and the complaint should be dismissed.
Second.
So it's been moved and seconded to find no reasonable grounds on both claims. Is there any discussion? Seeing none, all those commissioners in favor of finding no reasonable grounds on both claims, raise your hand and say yes.
Yes.
It's 4-0. Both findings are no reasonable grounds. And now we have the last case on the hearing agenda. And we thank the parties and counsel for their great patience.
So commissioners, case H21-0024 A, B, D, E. It's a reasonable grounds case. Kevin Osgood v. Summer Street Housing Preservation, Inc., Elizabeth Shue Ranking Center Condominium Owners Association, MCH Inc., and MCH Housing Inc. Is there anybody here for the respondent?
Good afternoon, everyone. Julia Pitney for the respondents.
Go ahead, Ms. Pitney.
Good afternoon. I represent the 4 respondents. There were 5 originally in the complaint, but the 4 respondents for whom a recommended finding of reasonable grounds I'm here on behalf of. I also represented the 5th, but I just wanted to point that out. This is a somewhat unusual case in the sense that it involves the constructive denial of a reasonable accommodation request in the housing context. In this case, the complainant made a request for an accommodation that he's arguing was simply ignored, but there's absolutely no evidence or no suggestion in the record or otherwise that it was denied or that there was any affirmative actions taken that could be read as a denial or any actions that would be contrary to granting the request. So it's a little bit of a different case in my opinion. The request was, just to refresh your recollection, because I know it's been a long day, was that any policy change be communicated to this resident, the complainant, by management. And that request, after it was made, was honored by the respondents. So it's essentially important to note 4 things here. The respondents were aware that the complainant had a disability, but not the nature of that disability until it was communicated by his attorney. The request for an accommodation was somewhat buried in a lengthy letter dated May 12th, 2020, that's part of the record, detailing a host of complaints about, other residents and other issues not necessarily related to any kind of accommodation request. In the subsequent communication from the complainant's attorney, and I just want to say a side note, I'm saying respondent and complainant because I've been watching this for hours and I'm so afraid of using anyone's name. So it's not meant to depersonalize anybody. I'm just going to stick with that to be on the safe side. So in the second correspondence from the complainant's attorney dated June 17th, 2020, the requested accommodation wasn't addressed at all. And the respondents did respond to the original correspondence and attempted to address the concerns about the other tenants and noise and so on and so forth. So just want to be clear that it wasn't if there's any allegation here that the lack of a response to the specific request is evidence of a denial, I just want to make crystal clear that it's not like it was radio silence. So as I mentioned before, the request was that the policy changes or anything like that be communicated by management, and they were. There were only 2 subsequent policy changes or updates. And again, I also want to mention this is at the height of the COVID kind of outbreak, and they were. So that was an important piece, which is acknowledged by the complainant's attorney in one of the subsequent communications. As I noted in our objection, while I know that there have been other decisions which may have, by this commission, which may have been addressed sort of a constructive denial, there are none that I could find, no court decisions in Maine where a specific lack of a response constituted a constructive denial of a reasonable accommodation request. So we are asking here today to simply ask that the commission not go along with the investigator's recommended decision and instead enter a finding that there are no reasonable grounds to believe that discrimination occurred here.
Thank you. Any commissioners with questions for Ms. Pitney, raise your hand. Seeing none. Okay, Ms. Pitney, you will have about 6 minutes left when we come back to you. And then we turn to Mr. Joyce.
Yes, could you let me know when I have 3 minutes left?
Yep.
My name is Mark Joyce. I'm attorney at Disability Rights Maine and represent the respondent. So I think one of the things is that the request for the accommodation really wasn't varied. It was pretty straightforward. And in fact, in the respondent's initial response, the question is list of accommodations requested by complainant. And it says, through his attorney, complainant requested that only MCH building managers, except in bona fide emergencies, approach Mr. Blank to inform him of all policies, not just those in place because of the pandemic, when they approach him to do so with respect and give him the underlying reason for the policy. And so the May 12, 2020 letter that was sent by the complainant's attorney at that time, Don Lawson Stops, says that verbatim. We therefore ask that only your building managers, except in bona fide emergencies, approach complainant to inform him of all policies, not just those in place because of the pandemic. When they approach complainant, do so with respect and give him the underlying reasons for the policy. Complainant suffers from a disabling level of anxiety, depression, and the like, but he is educated and intelligent. And in that May 12th letter that was sent by his attorney, and this is in the record, the RE of that letter is reasonable disability accommodation. In the body of that letter, it says the firm writes to you requesting accommodation. And it says, a specific example illustrating need for accommodation. It also talks about, we hope this letter motivates you to take all reasonable steps to accommodate complainant's disability. It was a request for a reasonable accommodation. The June 5th response from MCH contained nothing in response to that didn't even mention the word accommodation. And so when you talk about that there was nothing to show that the request was denied, if you got that letter June 5th that didn't even respond to the attorney's request for accommodation, that's not just a constructive denial, it's a denial. But even that, then the attorney wrote another letter that's in the record responding to that, basically saying that we respond to your letter with disappointment. You completely ignored the request for accommodation. And then it says, please understand that this response in the original letter provided you notice of the need for reasonable accommodation. And so the respondent's position is, well, we granted it to him. Well, that's what they're saying after he filed the complaint. As part of the investigator's request for information, she asked for all of the file of the complainant. Nothing in the file. There was no memo. There was no letter. There was nothing to indicate that they had actually granted the accommodation. And so they're saying that, no, we didn't, we left him alone after that. He would know that it's granted. How would he know? And I think the investigators pointing out that it would be it's extremely stressful. And I believe her words were that it says respondents are worried because complainant did not know whether respondents had granted his accommodation. He suffered increased anxiety about another interaction like the one he had with the worker. So the position that takes the constructive denial was just ignoring it. It just was ignored, and that is a denial of the accommodation. And so we would ask to support the investigators finding a reasonable ground.
Well, that was far short of needing 3 minutes left.
That's surprising.
Any commissioners with questions for Mr. Joyce, raise your hand. Seeing none. Can't believe I haven't thought of this in the prior 16 months. Then we return to Ms. Pitney, who has about 6 minutes left.
I don't have anything further to add. I would happily answer any further questions that anybody has.
Any commissioners with follow-up questions for Ms. Pitney, raise your hand. Seeing nothing. Well then, Mr. Joyce, anything you want to add? Nope. All right. Best argument of the day. So then thank you to Ms. Pitney and Mr. Joyce, and we turn to the investigator.
Bringing us home. Good afternoon, everyone. My name is Kit Thompson-Crossman. I'm the investigator assigned to this case. I don't have much to add except to echo that granting an accommodation and not telling complainant that it was granted isn't granting him an accommodation when there was no way for him to know. Sure, those policy changes were only communicated in the way that he'd asked, but he had no reason to know or believe that that would continue going forward. So in that sense, I believe it's a pretty straightforward case. Happy to answer any questions that you have.
Any commissioner questions for the investigator? Commissioner David.
And that's a legal requirement that when you make a request for an accommodation based on a disability, they have to respond, correct?
There needs to be some kind of dialogue. Yeah,
right.
and the letter, Attorney Joyce is correct. The letter that was sent in response to the first attorney's letter does not contain the words reasonable accommodation at all. And then there's no response to the second letter at all.
Right.
I think it's reasonable to point out here that complainant lives in housing that is in part specifically for adults with disabilities. So it's not as if we're dealing with a landlord who doesn't understand the reasonable accommodation process, I would imagine. That was.
Any other questions for the investigator? Commissioner O'Brien.
Just very quickly, is there anywhere that says that they didn't understand the nature of his disability?
The nature of his disability, I don't believe is in his initial sort of application to live in the premises. But in the first attorney's letter, as I think Attorney Joyce said, it does state he suffers from a debilitating level of anxiety. So they were on notice that that was part of his disability when the reasonable accommodation request was made.
Anything else, Commissioner O'Brien? No, okay. Okay, thank you, Kit. So commissioners, at this point, we would be looking for a motion or motions. There are two proposed findings. And if you just note, the first recommendation is about 4 of the respondents, and the second recommendation is about the other 5th respondent. And actually, I have completely failed at all to ask if there's anyone here for Rankin Center Condominium Owners Association. That is my oversight. Is there anyone here?
Sorry, that's me. I thought I tried to make that clear. I represent all 5.
Okay, I thought I understood that you represented 4 of them.
No, I'm sorry. I meant I was here to object on behalf of the 4, but I represent all 5.
Got it.
And
Okay.
we support the recommended decision for the 5th.
Got it. Okay. Thank you. Commissioners, a motion or motions?
I will move there are reasonable grounds to believe that Summer Street Housing Preservation, Inc., Elizabeth Shue, MCH Inc., and MCH Housing Inc. discriminated against Kevin Osgood on the basis of disability, and conciliation should be attempted in accordance with 5 MHRC.
Second.
So it's been moved and seconded to find reasonable grounds against 4 of the respondents. Is there any discussion? Seeing none. All those commissioners in favor, raise your hand and say yes.
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 1, 2, 3, 4, 4-0. Thank you.
And before there's another motion, I'm going to cut everyone off because we cleverly put the case against the Rankin Center on the consent agenda. So there's already been a finding.
Thank you, Barbara. Did not notice that. This is why she's in charge of me. I will never admit that again.
This is recorded, right?
I think this is recorded, right?
Yes.
You're not the boss of me. The 4 of you are the boss of me. To Commissioner, brain gone. To Mr. Joyce and Ms. Pitney, thank you very much. To Investigator Thompson, thank you so much. At this point, commissioners, we have, the only thing we have left to do is we need to go into executive session because there are cases up against a 90-day deadline that we have to vote on for litigation. So we need a motion to go into executive session that cites the relevant parts of the statute.
So pursuant to 1 MRS section 4056E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Second.
Okay, hold on. All those commissioners in favor, raise your hand and say yes. 1, 2, 3, 4. If you'll hold on just a second, I think I have failed to assign one commissioner to the proper room. Hold on. Deb, I don't want to lose you here. Hold on. Hold on, I'm working on it. I'm a little slow today. Aha, there it is. Okay, so it's been moved, it's been seconded, it's been voted on. So now I'm going to put everyone remaining into executive session. So I'll see you in there theoretically in a minute. 1 return, 2 return. That's 2.
There's a
They'll be
button on the
back.
toolbar that says to leave
Yeah.
room
Yeah.
Yeah.
that you need to click on.
But even if you don't, I think it
Yeah, you're
automatically
closing,
closes the room and you
If
can't
you
boot
closed
out.
it will.
Theoretically, they should be coming back here any second. Yeah, long day, huh?
Oh, yeah.
I'm awake, really.
This is what our very first Zoom meeting was like. It was like 8 hours and it was brutal. Well, where have they gone?
How much time did you give them in the break, closing the
Oh, I'm
breakout?
going to close all rooms. There. Okay. Now, I didn't hit that button before.
Yeah,
Should have hit that button before. And
they're
now
sitting
it's
there
like-
waiting for you. There you
Yeah,
go.
that was my bad. My bad. I didn't hit the right button. There you go. Everybody's back. Yay. Okay. Ed.
I move that the commission litigate H 20-340 A and C Tummings versus Tummings, and that we litigate case number H 20-0399 Garrett versus Larkin for the reason that that's recommended by council and required by the contract with the housing department.
Jill seconds. All right. The motion is to litigate the first two cases on Commission Council's memo, which are both reasonable grounds, dual filed housing cases. All those commissioners in favor, raise your hand and say yes.
Yes.
4-0. Thank you. We need one more motion.
Do we really need to make a motion on not doing something that we don't do in tens of other cases?
We do.
We vote on every single case that's reasonable grounds that fails conciliation.
Oh, it's because it fails conciliation. Thank you. No, that helps me understand. I move that we not litigate, where are we here? E19-0149 Dismore versus Maine State Prison, and that we not enter litigation in E19-0171 and not litigate E19-0355. Did I miss one? I thought there were 4.
You did.
Yeah, so
E19
E0470 that we not litigate Lemur versus Armour.
Yes. Is there a second?
Second.
All right, Deb. All those in favor of not litigating those 4 cases, raise your hand and say yes.
Yes.
1, 2, 3, 4. Thank you. That is it. You guys have done a heroic job today. Really, I can't thank you enough. You've done great. It's super hard to do this all day long. Next time, it will be a much, much shorter agenda.
Promises, promises.
What'd you say, Jill? I didn't even hear you.
Murmured promises, promises.
Yeah, I know.
You know how
have an
this
ice
goes,
cream
Jill.
I know. 3 cases with interpreters. No, 4. 4
Good
cases with
job.
interpreters.
Good job.
That's a lot. Thank you so
All
much.
the investigators' reports
everyone.
helped us get
Have
through
a good
it.
evening.
Yes, I will tell them that you said that, Jill. Thank you. Thank you, everybody.
Thank you.
See you later.
In
Bye-bye.